Thank you.
This is a written thing, not your favorite. Set a date for it and send notice to everybody.
All right, there we go. Good morning. I'm going to call the Spanish interpreter.
Morning, this is Sadia Romero, Spanish interpreter on the line, already sworn in today.
All right, thank you, Ms. Romero. You're remoting into BRC 2.
Yes. One moment, Your Honor. I'm dialing. She can hear the interpreter, Your Honor.
Great, thank you. This is case number 20MM5490. Ma'am, please tell me your name.
Ileana Balaguer Martinez.
Thank you. Ma'am, you were arrested for battery domestic violence. There is probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You may return one time with the police to get your things, and you're not to possess any weapons. I'm going to place you on pretrial release at this time. Thank you.
Thank you.
My name?
Yes.
I can speak in Spanish. Can we find out if the Portuguese has family out there? She lives so outside.
We'll do that one. Good morning, your name?
Jose Daniami Vasquez.
This is case number 20 CF 9110. You were arrested for sale and delivery of heroin, possession of cocaine with intent to sell or deliver, and trafficking in heroin greater than 14 grams but less than 28 grams. There is probable cause. I'll appoint the public defender to represent you. You are not to possess or consume any controlled substances without a valid prescription. Bond on count 1 is $150. Bond on count 2 is $150. Bond on count 3 will be $50,000. Thank you, sir. What about Marjorie Colon Rivera?
Another for you, Your Honor.
All right, Mr. Matos, I'll appoint your office. Do you want to waive the appearance?
Yes, Your Honor.
And that's 20 CF 9055. She was arrested for burglary of a conveyance. There is probable cause. The public defender is appointed, and bond is $2,500. She's not to return to the scene. Good morning, sir. Your name?
Heraclio Hernández Gamboa.
Heracli Hernandez Gamboa.
This is case number 20 CF 9123. Sir, you were arrested for introducing contraband into a county facility and possession of cocaine. There is probable cause. I'll appoint the public defender to represent you. Your bond on count 1 is $500. Your bond on count 2 is $150. Sir, I also need to inform you that you do have an immigration hold. Thank you. Looks like that was the only. Is this one?
It should
I think
be one more.
Sabrina Bond did, yeah.
Saber Gomez?
Yes.
Good morning, sir. Just one moment, please.
Sanabria bonded?
I think so. So far.
Sir, good morning. Tell me your name, please.
Hector Manuel Sanabria Gomez.
Sir, this is 20 CF 9056. You were arrested for possession of ecstasy and possession of drug paraphernalia. There is probable cause. I'll appoint the public defender to represent you in both of the cases today. Bond on count 1 will be $500. Bond on count 2 will be $100. You were arrested in 20 MO 792 for open container, and you will be ROR'd in that case. I'm not going to take any action on the out on bond case at this time. Thank you, sir.
Who is that?
That's Sanabria.
Who?
Sanabria.
Okay.
And then, Madam Interpreter, that's the last Spanish case we have today.
Thank you, Your Honor. Have a good day.
Thank you so much. You too. And what's the name of
Thank
the
you.
I
Portuguese?
have it.
Oh, you do?
Yeah.
What was the bond on open container?
Is anyone here for Ricardo Assis? No? Okay. Well, I'll just put it back.
Okay. Well, you can, yeah.
Keep it? Okay. I'll get it later.
You took no action on the add-on bond case? Correct.
Good morning. Tell me your name, please.
This is our Portuguese interpreter, Your Honor.
Oh, okay. We were going to do him at the end.
Okay. At the
Thank you.
The docket or in the domestic?
The docket.
Okay.
Thank you.
Hold on.
Good morning, sir. Tell me your name.
Terrell Golden.
Mr. Golding, you have 2 cases this morning. I will appoint a public defender to represent you in both. In 20 CF 9117, you were arrested for possession of ecstasy. There's probable cause, sir. Your bond will be $1,000. In 20 5337, you were arrested for battery domestic violence pursuant to a probable cause warrant. You are not to have any contact with the victim. You're to maintain a separate residence. You are not to possess any weapons or firearms. Your bond will also be $1,000. I'm revoking the bonds in 20 CF 7209, 19 CF 15287, and 20 CF 579. Those bonds will be set at them, sir. Thank you. Good morning. Are you Mr. Hardin?
Yes, ma'am.
Sir, you're here in 20 CF 9124. You were arrested for false imprisonment and battery domestic violence. There is probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You may have a one-time return with the police to get your things if needed. You're not to possess any weapons or firearms, and I'll place you on pretrial release at this time, sir.
Okay, thank you. I have a
Thank
quick
you,
question. I have a quick
Sure,
question.
sir. Go ahead.
We currently stay in the hotel, so if she left that hotel, can I go back? Because she was actually in the process of leaving yesterday.
Yes, sir.
Okay.
Sir, good morning. Tell me your name, please.
Good morning. Johnny Hernandez.
This is case number 20 CF 8753. You were arrested pursuant to a probable cause warrant for aggravated assault with a firearm, battery, domestic violence, and criminal mischief. You are not to have any contact with the victim, sir. You are to maintain a separate residence. You are not to possess any weapons or firearms. If you do own a firearm, it needs to be turned into the police department within 6 hours of your release from the jail. If you need a one-time return with the police to get your things, you may do so. Bond on count 1 is going to be $3,500. Bond on count 2 is $100. Bond on count 3 is also $100. I'm not going to revoke your bond on your out-of-bond case at this time, sir. Thank you.
Okay, thank you, ma'am. Have a great day.
You too.
Your Honor, next on the list, Chaz Horn, medical.
Mr. Matos, I'll appoint your office to represent Mr. Horn. Do you want to waive his appearance?
Yes, Your Honor.
That's 20 CF 9125. Mr. Horn was arrested for aggravated stalking after an injunction. There is probable cause. He's not to have any contact with the victim. He's to abide by the injunction in 20 DR 4492. He's not to possess any weapons or firearms. Bond is going to be $2,500. Good morning, ma'am. Tell me your name, please.
Dawn Lopergolo.
Ma'am, you're here in 20 CF 9126. You were arrested for false imprisonment and for battery dating violence. There is probable cause. I will appoint the public defender to represent you. You're not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms, ma'am. Your bond on count 1 is going to be $1,000. Bond on count 2 will be $100.
Your Honor,
Yes, ma'am?
I can't make bond. It's impossible, so I'm asking to be ROR'd. I don't have any contacts. I have no money. It's going to be impossible. I'll be sitting in here the whole time.
Why doesn't she qualify for PTR?
Excuse me?
She can qualify, Your Honor.
Okay, Miss Leporgolo, I'm going to place you on pretrial release at this time, okay? You'll be supervised by the pretrial release program until your case has been resolved. So you will be released from the jail today.
I will? Okay.
Yes, ma'am.
Thank you so much.
That's straight pretrial release, not bond or, right?
Correct, just PTR.
Thank you.
Your Honor.
Yes?
For Santiago Armindo, I have an argument that this should be a simple battery instead of an aggravated battery.
Okay.
May I proceed to make my argument, Your Honor?
Well, I need to call the case first,
Oh, absolutely.
but then yes, you may. Good morning, your name?
Armando Santiago.
Sir, this is 20 CF 9107. You were arrested for aggravated battery. I will appoint the public defender to represent you. And Mr. Matos, you had a probable cause challenge?
Yes, Your Honor.
Okay, go ahead.
Well, Your Honor, for an aggravated battery, you need to intentionally touch or struck the victim against his or her will and intentionally cause bodily harm to the victim. In the commission of the battery, intentionally unknown, the defendant must intentionally unknowingly cause the damage to the body part, the permanent disability, or the permanent disfigurement, and use a deadly weapon. A deadly weapon is a weapon is deadly if it is used or threatened to be used in a way likely to produce death or great bodily harm, Your Honor. Let me switch here. First, we must determine whether the victim suffered great bodily harm. The issue is whether the injuries constituted great bodily harm is a question of fact, Your Honor. See in Owens v. State. The state, however, must prove more than the victim just suffers some harm. In this case, I'm trying to claim that the victim only suffers some harm. In Owens, the court observed that great bodily harms means great as in distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises as are likely to be inflicted in a simple sore battery, Your Honor. Here, the evidence was insufficient to establish that the victim suffered great bodily harm. Now we must, and I feel like we must determine whether the cell phone, in this case, qualifies as a deadly weapon. A deadly weapon is in any instrument which, when used in an ordinary manner, contemplates by its design will or is likely to cause death or great bodily harm, or any instrument likely to cause great bodily harm because of the way it's used during the crime. Whether a weapon is deadly is a question of fact, Your Honor, and to be determined under all the circumstances, taking into consideration the weapon and its capability for use. When used in an ordinary manner, contemplated by its design, a cell phone is not likely to cause death or great bodily harm, Your Honor. Furthermore, the officer observed Jane with bruises and cuts on her left side of her face near her jawline. The cuts are approximately 1/4 of an inch, Your Honor. That's 1/4 of a quarter. There are no active bleeding at the time, Janet, which did not require medical treatment when the police interview her. The report represented no evidence to establish that the cell phone was used in this case and was likely to cause in a way that was likely to cause great bodily harm. Thus, the evidence is insufficient to establish the probable cause for aggravated battery. The evidence presented, however, may support no probable cause for a simple battery, Your Honor.
Ms. Fusco, your response?
Just that there was a cut with bruising and swelling to the left side of the face, and also on the second page, there was a bruise to the right forearm that was 1.5 inches in size.
I think that there is probable cause. I don't know what the state will be able to prove or what they're going to file on, but I do think that there is enough facts to establish that a reasonable person would believe that the crime had been committed. So I do find that there is probable cause. But I'll take your arguments into consideration, Mr. Matos, when setting his bond.
Thank you, Your Honor.
Mr. Santiago could be on pretrial release, correct?
Your Honor, it says that he does not qualify, but victim made no contact. I don't see why in his face sheet he would not be qualified for it.
He can qualify, Your Honor.
All right, Mr. Santiago, I'm going to place you on pretrial release at this time. You're not to have any contact with the victim. You are to maintain a separate residence. You are not to possess any weapons or firearms, sir.
Yes, ma'am.
Thank you.
I got that.
Wilkerson Hospital.
Wilkerson's Hospital.
Yes.
Mr. Matos, I'll appoint your office. Do you want me to reset it for tomorrow, or do you want to leave you here?
Your Honor, is she going to be in the hospital as in quarantine for 2 weeks? Because if so, we would like to waive. If not, if she's going to be here tomorrow, we would like to reset for tomorrow.
Do you think he's going to come back soon?
I'm not sure how long he'll be in the hospital, but we can send 24 hours from his return.
When he returns? Okay,
Yes.
we'll do that. All right. Good morning, your name?
Michael Bethel.
Mr. Bethel, you are here in 20 MM 635. You were arrested for battery domestic violence. There is probable cause. I'll appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You may have a one-time return with the police to get your things if needed. You're not to possess or consume any alcohol or controlled substances without a valid prescription. And you're not to possess any weapons or firearms.
Yes, ma'am.
Mr. Bethel, I'm going to place you on pretrial release at this time.
Thank you.
Thank you, sir. Good morning. Tell me your name.
Barishabai Bojic.
Good morning. This is 20 MM 5510. Sir, you were arrested for battery domestic violence. There is probable cause. I'll appoint the public defender to represent you. Ma'am, good morning.
Good morning.
Tell me your name, please.
My name is Angela Milicevic.
All right. And you are Mr. Bossack's mother, is that correct?
Yes,
All right, ma'am. Do you want to have contact with your son?
yes. What I was trying to do, Your Honor, is he's paranoid, schizophrenic.
Yes.
He's off his medication. And he will need at least anywhere from 3 months to 6 months just to get him back to normal. He's not functioning right. He's not my son. I'm just pleading for help.
I understand, ma'am. And unfortunately, I see so many parents just like yourself that come down here more than I'd like to. I don't have any particular resolution that I can offer for you today. This is the very beginning of the case. You'll be able to discuss with the state attorney and the public defender some additional options that might be available in the community for some treatment options. But I can't order anything like that today. The purpose of this morning's hearing is to determine his release conditions and his bond amount. So you've just told me that you're not afraid of him. Is that correct?
I am afraid of him. It's because every time he's not taking his pills, he's not stable, Your Honor. He's not stable at all.
Right.
He was at the University Rehab Center, July 17th to 24th. That's all he had. Then I haven't seen him for 2-3 days. He walks. Then when he comes back, I pick him up. You know, it starts all over.
Yeah. So
I just don't know what to do. His father, he has four years of probation.
Right. I see that. So, ma'am, today though I need to determine whether or not I'm going to allow contact between the two of you. So you told me that you do want to have contact, but you also told me that you were afraid of him.
Yes.
So I'm not inclined to allow contact at this time. That's something that could be modified on a later date.
Okay.
Okay?
He has nowhere to go but me.
Well, right now he has a hold because of his probation status, so I don't think he's going to be going anywhere.
Okay, all right.
He's going to be here. And hopefully they can get his medication worked out while he's here.
Okay, how long is he going to be here?
I don't know. So there's a 5-day hold on him right now. And that's to allow the probation officer to file an affidavit for violation of probation. I don't know if they will or not, but they have 5 days to do that.
Okay, how do I get a hold of anyone so I know what's going on?
Well, you could call the public defender's office because
Okay.
he's been appointed the public defender. And I think their phone number is 407-836-4800.
Is it on this piece of paper?
I don't know what that piece of paper
It
says.
says,
Your Honor, if she's comfortable giving me her number, I will put it in the notes for them to contact her as well.
Okay, ma'am, do you want to provide your phone number to
Sure.
the public defender?
Thank you,
Okay.
sir.
No problem.
Go ahead, ma'am.
$407-533-8649.
Thank you, ma'am. Let me read it back to you. 407-533-8649.
Thank you, sir.
No
All
problem.
right, ma'am. Thank you for coming today.
Thank you, Your Honor.
So, sir, at this time, you are not to have any contact with your mom. You need to maintain a separate residence. And you are not to possess any weapons or firearms. I'm also going to order that you're to take all medication as prescribed to you by your doctor and follow their treatment recommendations. Mr. Bossack, do you have any questions, sir?
Yes, can I request an R&R after my 5-day hold?
Well, sir, your bond is actually going to be set at $1,000, and the request for ROR is denied.
All right, thank you, ma'am.
Thank you, sir. Thank you.
Thank you. Thank you, sir.
Have a good one.
Good morning. Tell me your name.
Gino Marletta?
Mr. Marleva, this is 20MM 5507. You were arrested for battery domestic violence. There's probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victim. You are to maintain a separate residence. You may return one time with law enforcement to get your things if needed. You're not to possess any weapons or firearms. I'm going to place you on pretrial release at this time, sir.
Thank you, Dora.
Thank you.
Your Honor, next on the list, Raguliana,
Yes?
medical.
All right.
He has a witness here, Your Honor.
Oh, okay. That's 20 MM 634. Mr. Matos, do you want to waive his appearance?
Yes, Your Honor.
Okay. Good morning, ma'am.
Good morning.
Tell me your name.
Heidi Burgos.
Ma'am, do you want to have contact with Mr. Ragunanan?
Yes.
Are you afraid of him?
No.
How long have you been together for 7 years? Is that correct?
Yes.
All right. Have there been any instances of violence between the two of you over the course of your relationship?
No.
And it says in the police report that he was drinking last night. Is that correct?
Yes.
Okay. Do you have any concerns about your safety if I were to allow contact between the two of you?
No.
Are there any children in the home?
No.
Okay, thank you. Ms. Fusco, do you have any questions?
Do you believe alcohol played a part in this?
Excuse me?
Do you believe alcohol played a part in this?
Alcohol?
Yes.
Yeah.
Nothing further, Your Honor.
Ma'am, just one question.
Yeah.
If you felt attacked or anything were to happen again, would you be comfortable calling the police?
Yes.
Thank you. Your Honor, at this point, I would ask for non-hostile contact between the victim and the defendant. And my client also meets PTR. I would ask for PTR at this point.
Okay. I'm going to order that he's not to have any hostile contact with the victim. He is not to possess any weapons or firearms. He's not to possess or consume any alcohol or controlled substances without a valid prescription. And I'm going to place him on pretrial release at this time. Ma'am, did you have any questions?
No.
All right, thank you.
Thank you.
Good morning.
Good morning.
Are you Mr. Reddick?
Yes.
Mr. Reddick, this is 20MM 5502. You were arrested for battery domestic violence. There is probable cause. I will appoint the public defender to represent you. You are not to have any contact with the victim. You're to maintain a separate residence. You may have a one-time return with law enforcement to get your things if you need to. And you're not to possess any weapons or firearms. I will place you on pretrial release at this time, sir.
Okay.
Do you have any questions, Mr. Reddick?
Yes. Me and her have a child, and I'm trying to see would I be able to see him without being able to see her. Turning 3 months and 2 days.
Do you have a third party, like a family member that could facilitate the contact?
Can you repeat that?
Do you have a family member or friend who could facilitate the contact regarding your son?
Yes.
Who would that be?
It could be my father. It could be the godfather.
Okay, so let me make sure we're very, very clear. You still cannot have any contact with her,
Okay.
okay, at all,
Okay.
until that's modified in writing by a court.
Okay.
If your father reaches out to her and she doesn't want to allow you to have contact with your son, then you will have to go to court and have the order modified. If she is fine with it, then your dad can pick up your son and bring him to you and kind of do the handoff. Do you understand?
Okay.
Okay, what's your dad's name?
Zolly Reddick. Want me to spell it?
Yes, please.
Zollie. Reddick, same last name.
Zolly. Okay, got it. All right, Mr. Reddick, anything else?
No, that'll be it.
All right, thank you.
You're on the next on the list. Cyrus Stephen, bonded.
He bonded?
Yes, ma'am.
Thank you.
Yes. Tara Steve. Traffic. Tara Steve, traffic.
And a summons was started on it.
She gave it to me, thank you.
Are we ready, Your Honor?
Yes, for Mr. Walker?
He refused to attend, Your Honor.
Okay, I'm gonna find a waiver of his appearance in 20 MM 5017 based upon his refusal to come to court. I will appoint the public defender to represent him. He is being arraigned for the offense of battery. His court date, this is a Division 81 case. His court date is going to be on September 2nd at 9 a.m., courtroom 4C, and he was served with a summons on the 27th of July of this year.
Oh, Your Honor, that was Walker, not Wilkerson, correct?
Walker, yes.
Thank you.
All right.
You're appointed the public defender,
I
correct?
did, yep.
Tanisha Gaston is medical.
Okay. That's an out-of-county status. That bond is 19 CF 2994. That bond is to remain at none.
Yarilis Morgus Fernandez is also medical.
All right, that's an out-of-county case from Osceola County, 09 CF 2595 and 09 CF 2163. Per Judge Morgan, the defendant qualifies as a violent felony offender of special concern. Her bond is to remain at none. Good morning.
Good morning, Your Honor.
Tell me your name, please.
Traviance Amon Polite.
All right, this is an out-of-county case from Seminole County, sir, 2006 CF 3249. Mr. Play, at this time, per Judge Rex Seidler, you qualify for a violent felony offender of special concern, and your bond is to remain at none. As I stated before, sir, I've appointed the Orange County Public Defender here to assist you in coordinating with Seminole County for whatever you may need to work on your case while you're here.
So I just have a VOP for out-of-county warrant?
That's right.
Okay.
Thank you.
You're on the next on the list. Derek Wilkerson, medical.
All right, that's,
Your Honor, we have a plea for Mr. Wilkerson.
yes. He can't come to court. He's medical. It's 20 MM 2506. Mr. Machos, you'll need to note your system that they'll need to reset that
Okay,
plea when he's out of medical.
thank you.
Good morning.
Good morning.
Your name?
Tim Dewitt.
Mr. Woods, it's my understanding that in case number 20 MM 1390, you'd like to withdraw your previously entered plea of not guilty and enter a plea of no contest to the charges of petty theft and resisting officer without violence. Is that correct?
Yes, ma'am.
All right. And it says that the negotiated agreement is an adjudication of guilt, 6 months of probation. You are not to possess or consume any controlled substances without a valid prescription, and you're not to commit any new law offenses. Those are the terms of probation. You'll also have to pay court cost and cost of investigation to the Orlando Police Department in the amount of $68.83. Is that your understanding of the agreement?
Yes, ma'am.
And you would like to accept it at this time?
Yes, ma'am.
Did you read the plea form before signing it?
No, ma'am. But I understand though.
You have to read.
Mr. Woods, just let me know when you've finished, and then if you have any questions, okay?
Okay. So, the probation starts now.
Yes. So probation will start today when you're released from the jail, and you'll need to report within 72 hours of your release from the jail. And I believe right now, because of the COVID, people are not actually reporting, so you have to call in by phone. So that phone number will be on your paperwork, your probation paperwork, of how you need to call in.
I will be released today.
Yes.
Oh man. Are you
Mr.
positive?
Well, I don't. Does he have any other holds?
Yeah.
Miss Williams, do you know?
You don't have any holes. No, he don't have any holes.
Okay, so yes, you'll be released today.
He got bonds. He
Huh?
got bonds. He has to bond out.
Oh, he has a case.
All his
Can you tell me what the
open
bonds are?
let's see, 1, 2, 3, 4. He has 4 different cases.
Oh, okay.
Oh, yeah. I just think he has 4 cases. He got a lot of bonds. And total bonds is $23,050.
Okay, so Mr. Woods, you are able to bond out of the jail if you can. You have 4 cases that have bonds on them, so you'll have to post those bonds before you're released.
All right.
Okay.
Do you want me to put anything on there? Does the probation start once he's released?
I don't know if he can be in jail on probation.
Your Honor, what's the case number that
I'm here.
you're here on?
20 MM 1390.
Okay.
Well, I think probation will start today, but he doesn't have to report until 20 or 70. I'll give him 72 hours from release from custody.
Okay.
Okay. All right, Mr. Woods, did you read the plea form?
Yes, ma'am.
Do you have any questions about any of the rights that you're giving up on the plea form?
No, ma'am.
All right.
But I do have one question that it's not with this case.
Well, let me get through this case first, and then I'll try to answer your question, okay?
All right.
Mr. Woods, you're not on probation for anything else at this time, are you?
No, ma'am.
Do you understand if you're not a U.S. citizen that this plea will subject you to deportation?
Yes, ma'am.
Have you taken any drugs, alcohol, or medication that would affect your ability to understand what's happening in court today?
No, ma'am.
All right, and the defense stipulates to a factual basis?
Yes, Your Honor.
All right, Mr. Woods, I'm going to adjudicate you guilty on both counts, sentence you to 6 months of probation. You're not to commit any new law offenses, and you're not to possess or consume any controlled substances without a valid prescription. Those counts will run concurrent to one another. You will have to pay court costs, which will be due by July 30th of 2021 and includes cost of investigation to the Orlando Police Department in the amount of $68.83. You do have 30 days to appeal the judgment and sentence of the court in writing, sir.
He needs prints for count one.
Yes, he does need prints on count one. And then, Mr. Woods, because you're still here in the jail, your probation will start today. However, you do not need to report to probation until you've been released from custody. And I'll give you 72 hours to report to probation after you've been released from the jail, sir. Do you understand?
Yes, ma'am.
Okay. What's your question?
From my other charge, I have my understanding. I have 2 charges pending on me, right? And I'm wondering, when do I have court for that?
Yeah. I don't know. You'll have to get in touch with your lawyer, sir, to see when you might have court.
Is the courthouse is still closed?
What?
I was told the courts, downtown courts, was still closed.
They're not closed.
They're not? Okay.
No.
He has a trial date.
Because I was supposed to have court on the 27th, and I never went. They never called me.
Just a second.
October 22nd,
October 22nd?
9 a.m.
You have court on October 22nd, Mr. Woods.
Oh, my God. 27.
What?
You've got, looks like you have.
Oh.
You need that case, that number?
I have
Okay.
it at it. So you have,
Yeah, I ain't.
one of the cases hasn't been filed on yet.
October 27th? Yo, I did not know that. I got going out.
Mr. Woods, you need to get in contact with your lawyer about those other open cases, okay, to see if you can get a bond posted, and to work on those cases, okay?
Okay, thank you. Appreciate it.
Thank you.
I think Larry Herman
Yeah.
is the only one we're missing.
Yep.
I didn't see his name on the list, so
Oh.
I'm not sure if he bonded.
Dexter,
or-
do you have Larry Harmon?
I do not.
Okay.
I don't,
His name wasn't on their list, but he was on an add-on docket, so we might have to ask pretrial release if
Okay.
he's still here or if he
Is
bonded out.
Mr. Harmon here?
You have a booking number?
I have it. 2001 6545.
I see the jail search, it doesn't come up.
Might be bonded.
Posted bond yesterday.
Okay, he bonded. Thank you, Dexter.
okay.
Okay, that's done. And then,
I'm calling now.
you want to call? Okay. Ms. Fusco, are you ready on the 33-day motions?
Yes, Your Honor.
All right. 20 CF 7900 LG Alexander.
Yes, Your Honor. On July 29th, an information was filed, filing ID 111000844.
That'll be denied. 20 CF 7906 Ruben DeSources.
Yes, Your Honor. On July 29th, there was a notice of non-filing.
That'll be granted.
Yes, sir. I'm gonna place you on speakerphone. Is that okay? Okay, thank you.
Good morning, can you hear me?
Yes, I can hear you.
Great, thank you. I'm just waiting for the defendant to be brought in. This is 20MM5508. Sir, good morning. Please tell me your name.
Ricardo.
O senhor pode falar o seu nome?
Ricardo.
My name is Ricardo.
Tell me your last name, Ricardo.
Seu Ricardo, fale o seu último nome.
Assis.
Assis.
Thank you, sir. You were arrested for battery and for assault.
O senhor foi preso por assalto e por brigar.
Desculpa, não
There is-
entendi.
Don't speak, Mr. Assis. There's probable cause. I'm appointing the public defender to represent you.
Eu estou colocando defensor, advogado, para defender o senhor por essa provável causa.
Tá, mas eu não entendi por que eu fui preso.
I didn't understand why I am arrested.
I know, sir. You'll have to talk to the lawyer about that.
O senhor vai ter que falar com o seu advogado sobre isso.
But you were arrested for battery and for assault.
O senhor foi preso por causa de assalto e por ter atacado alguém e batido em alguém.
Assalto?
Não roubar, senhora. He's asking for clarification of one of the words, assault.
Okay. It's attempting to hit someone.
O senhor tentou bater em alguém.
Eu não.
Sir, you are not to have any contact with Elisandra Figueiredo.
O senhor não pode estar em contato nenhum com Alessandra Figueiredo.
You are to maintain a separate residence.
O senhor tem que manter uma residência separada da dela.
You may return one time with the police to get your things.
O senhor pode voltar uma vez mais lá com a polícia para pegar as suas coisas.
You are not to possess any weapons or firearms.
O senhor não pode ter possessão, ficar de posse de nenhuma arma de fogo ou nenhuma arma.
And I'm going to place you on pretrial release at this time.
Eu vou colocar o senhor agora numa condição de estar livre nesse momento.
Thank you, sir.
Is there anything else I can assist you with, Your Honor?
No, sir. Thank you so much for your help.
Thank you for using our service. Have a good day.
You too.
Thank you. Goodbye.
All right, goodbye. All right, then court will be in recess. It was working on Tuesday.
Usually it comes on its own. I just hit the power button.
There we go. Okay. Mr. Snur, do you need a moment?
I don't think so, Judge.
Okay, I'm gonna go ahead and call the case then.
Thank you.
This is 20 CF 9207. Sir, please tell me your name.
Jermaine Ingram.
Mr. Ingram, you were arrested pursuant to a probable cause warrant for the offense of second-degree murder. I do have your attorney present in the courtroom. Would you just place your appearance on the record, please?
Yes, Your Honor. Mike Snur for Mr. Ingram.
Thank you. So, Mr. Snur, typically how I handle these types of cases down here at the jail is you can, the state can go forward to present proof evident presumption, great, and we can handle that today here. Or you can elect to have that heard entirely downtown on a later date.
I don't think we're there yet, Judge. If you'd hear me out on that for a second.
Sure.
The two documents that I'm privy to that lay out the facts were the affidavit in support of the arrest warrant and then what has just been provided to me, which is largely a reprint of that, although I see some additional information in it. But the underlying felony to support either felony murder of some degree in both documents is laid out to be aggravated battery. Agree on that? I've given you the murder statute. Aggravated battery is not a sufficient predicate to support first-degree felony murder or second-degree felony murder. It is only sufficient as a catch-all to support third-degree felony murder. I've provided you with the Florida Supreme Court case from a couple years ago. I think it's pronounced Doherty, 211 Southern 3rd, 29, 2017, Florida Supreme Court, where they discuss third-degree murder on the 11th page of the decision in the top paragraph, headnote 12. The second sentence says, third-degree felony murder is a catch-all felony murder in that it may be based on any felony other than those enumerated in section 782.04 or statutes. Aggravated battery is not one of the enumerated felonies, and as such may form a basis for conviction of third-degree felony murder. This underlying allegation does not support a first or second-degree felony murder charge by definition. So where that leaves us is that third-degree felony murder is a second-degree felony, and it is not enhanceable by use of the firearm. And I thought I had that case. Just give me a second. Maybe I have it with me. Yes, I do. I'm sorry. Cosme. May I approach again?
Sure.
I would have done this in one-on-one, but sorry. In Cosme, Your Honor, the defendant was charged or convicted of felony murder. I think it was second-degree felony murder. But in head note 3, you can read the opinion or read the head note. It said the trial court could not enhance the defendant's convictions on 2 counts of attempted second-degree murder to first-degree felonies for purposes of sentencing based on the use of a firearm during the commission of the offense, where the defendant was not the shooter. It did not, and there was no evidence that he actually possessed a firearm. So, by statute, third-degree murder is a second-degree felony. Even if it were enhanceable, it would only be a first-degree felony. It does not appear to be enhanceable based on that statute. There's certainly not enough. There's no evidence in the facts before us. The record is that Mr. Robinson, the deceased, was the shooter who later died from return gunfire, taking everything in the state's affidavit at face value. So I think the court's required to set a bond. Now, I can proffer, and maybe that's an issue we need to resolve before we go any further, but I've got witnesses about, community ties and so forth, or I'll certainly proffer it to you, but they wouldn't let them up, so we'd have to call them up.
Okay. So I understand your argument, and I followed your argument. And this week, I'll let you respond in a second. Well, actually, I'll let you go ahead and respond.
It's just our position that the firearm does elevate it to a PBL.
Okay. I'm going to take a moment to just read this case on my own fully. Mr. School, why do you think that the enhancement would apply?
I'm just now getting the case and trying to read it, but my review of the statute is the reason.
All right, so looking at the facts in the case regarding Mr. Ingram, I just kind of want to try to walk through it in terms of the enhancement. I agree with you on the classification of the murder statute. On that, though, this is more of a procedural issue. This charge or this case came about pursuant to a warrant. I don't know what authority I have at this point to change what probable cause was found for because it's a warrant. I think if it came in on an arrest affidavit, right, I have to find probable cause for what the arrest affidavit was in order to continue the detention or to make that arrest lawful. But this was pursuant to a warrant where probable cause had been found, so I don't know if I can change that.
Well, I don't think you have to give deference to a clearly erroneous finding. Plain language of the affidavit in support of the warrant and the new report is that the underlying felony was an aggravated battery. Aggravated battery will not support second-degree felony murder as a matter of law. We I don't want to cast any aspersion on how it happens. Probably an oversight and an error, but I don't think if, as we sit here and am paying attention to the facts, that we could say, well, we're just going to overlook this error. It may not make much difference but I think it could. And I don't know what you have to find or whether it makes any difference if you found that it should be felony third-degree murder, third-degree felony murder with an aggravator, we're no worse off we're at a first-degree felony. If you found you weren't going to look behind the warrant, but the enhancement didn't apply, we're in the same place. Felony second-degree murder is first-degree felony, right? It's the enhancement that drives it to a PBL. So as long as you set a bond, I don't think we have really a disagreement. But if I'm wrong about that, I didn't think we would get hung up on the plain language of the affidavit in the statute. But if we are, I didn't really look to make sure. But I think it's only a first-degree felony. It's in the statute I provided you.
So the statute that's cited on the warrant is 782.04 subsection 2. It is a first-degree felony, but it is punishable by life.
But, I see what you're saying.
So
Then I need to stand by my argument, Judge. I don't know how we could ignore a clear error. And I'd ask you to correct that now in giving a meaningful first appearance, because otherwise you're just perpetuating the error and set a bond.
Ms. Fusco, did you want to be heard on that issue?
Just that he is charged under the statute as on the face of the affidavit, and the firearm did enhance it, and it is a PBL.
If he was charged with first-degree felony, a first-degree premeditated murder, we would be laughing. It's not supported by the statute, Judge. So the idea that there was an error made earlier on and we're all bound by it seems to deny Mr. Ingram at least procedural and substantive due process. We're here to evaluate whether he should be released and if so, on what conditions. And I think that includes looking behind clear errors, errors that are obvious from the paper.
In reading the affidavit and the supplement that was provided right before court, I don't see any other felony or underlying felony mentioned in either of the reports other than the aggravated battery. It's all predicated on that felony.
I haven't even addressed what I thought that we wouldn't get here, but his connection to the crime itself is tenuous. It's based on his affiliation with a rap musician, and at best that's tenuous. But even assuming, without looking behind that, they just charged him with the wrong statute.
I would argue the opposite, Your Honor, that there are facts that with the previous shootings between the rival gangs, and he drove to an address where the second in command of the rival gang was known to be staying. He brought a man with a gun, and the gun was already firing immediately as soon as this car stopped. The person he was shooting at was not armed until after the shots were fired. I mean, it's pretty clear that the intent was to go there and shoot a gun at the rival gang who had shot someone in their gang. And so, if anything, I think it's undercharged.
This is a perpetuation of the inference upon inference upon inference. He's already now a gang member, and he already has knowledge. None of that's readily apparent from the facts, Your Honor.
I understand, Mr. Schnarr. I agree with you on that the facts don't support what probable cause was found for in the warrant. And based upon that, I do think Mr. Ingram is entitled to a bond. In my head, I'm just trying to think out procedurally in terms of
if there's
just a minute. I don't know what I would put in the order, because with the warrant stating second-degree murder, I don't know if I can just change that and say the court determined that there wasn't probable cause for second-degree murder.
I think I would say probable cause for third-degree felony murder found.
Okay.
Bond set at X number.
We would argue if there is an issue of probable cause, then we should have 24 hours to supplement, correct, and
That would be more appropriate, Your Honor, if probable cause was not found for anything.
but probable cause was previously found by a judge.
Well, the alternative would be if you found no probable cause, you might be inclined to ROR him or alternatively give the state time to shore it up. Here you're simply correcting an obvious error that's present in the face of the paperwork. Where ROR is not an option.
Yeah, I think it's more akin to when there's a charge of, possession of cocaine with intent to sell, and you can't find the intent to sell, and you find probable cause for possession of cocaine. State can certainly charge whatever they want to later on after they've completed their investigation, but the court then usually sets probable cause and they set a bond. So that's what I'm going to do today.
Then we would ask 24 hours to supplement, Your Honor, if you're determining that there is not probable cause.
That there's not probable cause for
If you're
third-degree
saying there's
murder?
not probable cause, we'd like to have 24 hours to supplement.
I'm not saying that there's not probable cause. I'm saying that there's probable cause for third-degree murder.
But if you're finding it for a different statute that's what's on the face of the affidavit, then we'd like 24 hours to get that corrected.
You can have that, but I'm still finding probable cause for the third-degree murder, and I'm going to set bond. If Mr. Ingram hasn't bonded out tomorrow, then you can be reheard on that. But today, I'm going to find the probable cause for the third-degree murder. I'll give you the 24 hours to make whatever corrections you need, but I'm still going to set a bond for Mr. Ingram.
May I address the conditions of appropriateness of bond and so forth?
Yes, I didn't get to the enhancement, though, and I do want to talk about that because we skipped over that part.
Sorry.
In that case, it says that the defendant argues the trial court improperly enhanced his sentences on the 2 counts of attempted second-degree murder when the defendant was not the shooter and the jury did not find that he actually possessed a firearm. When a defendant is charged with a felony involving the use of a weapon, his or her sentence cannot be enhanced under 775-0871 without evidence establishing that the defendant had personal possession of the weapon during the commission of the felony. So just thinking through the facts, I'm trying to see how it does or doesn't apply based on that language, because in the facts alleged in this case, Mr. Ingram did have a firearm.
The other man was a shooter. That's the whole point is the deceased, Mr. Robinson, it's Jeremiah Robinson and
Yes.
Jermaine Ingram.
Yes.
Jeremiah Robinson is identified as the shooter from Mr. Ingram's car out the passenger side.
Right.
Then he was wounded by a return shot and died. That's the concept of felony murder. Mr. Ingram, they say, suffered a bullet wound, a grazing on his hand, but he's not identified as the shooter at all. In fact, if you get towards the end of the affidavit, while they're explaining the rationale, they said that Mr. Robinson was the shooter. It's right in the affidavit.
No, I understand, but in the bottom of the first page, it says Ingram told Master Deputy Luke Colbert that he fired his Springfield XD40 handgun at the male after the male pointed an assault rifle at him.
So
I was just trying to put that in context with the language. I don't know how that, I don't know how that play out.
I can tell you 2 things. One, they go on to say that all the shells were found outside the passenger side of the car, making Mr. Ingram couldn't have been the shooter, but unless he was Inspector Gadget's arm. In talking to the detectives, they told me that they don't believe he shot the gun. He was probably trying to cover for his friend, but it's clear that the passenger did shoot the gun, and I think that's consistent with what's represented in the affidavit of the other witnesses claiming the passenger shot the gun. That's Mr. Robinson.
Well, it doesn't mean that more than one person couldn't have been shooting the gun, and on the first page of the affidavit, it specifically says that he told the officer he fired it.
I don't dispute that. And I'm not...
Even if it did apply, Mr. Ingram would still be entitled to bond. Mr. Sir, they told you they wouldn't let the witnesses come up here?
Yes, they made them stay downstairs. In fact, they're out in their car. I'd have to text them, and you'd have to tell the deputies to let them come up if you want to hear from them.
If we're going to do that, I'd like to have the officer come.
Ms. Wusko, you could have had the officer here today. It's a bond hearing. In every case that we have that comes to first appearance and the defendant's requesting a bond.
I know, but he's charged with second-degree murder. I didn't know the charge was going to be changed.
Well, if he was charged with second-degree murder, wouldn't that also warrant the the police officer attending?
Not if I didn't know prior to getting here that he was going to argue that the second-degree murder charge should be changed to another charge.
Even, let's just say it was second-degree murder, and that's what we were proceeding on, right? And you had to go forward with proof evident presumption, great. Even if I found proof evident presumption, great. Mr. Snur could still ask me to exercise discretion and set a bond, and at that time, he would still have to put forth his evidence to establish the criteria when setting bond. So no matter what charge we're talking about, you would still have to have a bond hearing. So you would have had to have had the officer here for that.
I understand that, but if I had been informed in advance that there was going to be an attempt to get the court to change the second-degree murder charge, then, it would have been handled differently, except I didn't know till I got here.
Well, I would never know that either.
Well, Judge, I don't know that this is going to make any difference, but I just read the paperwork and analyzed it like a lawyer's supposed to do and came up with this argument, which I think is valid. It just requires reading the paperwork and working things out. So what I need to know is, do I need to get these
Yes.
people over?
Thank you. Denise, who do or do you call her? I need to call downstairs.
Oh, we have that number. It's in courtroom 2, I know.
Yeah.
Try 48314, because they would have to hear from you.
What I don't suppose you can look at the jail real quick.
48314.
He's bringing in witnesses and they're trying to change the charge.
And that should be the deputy supervisor.
You'd have to, how quick could you get here?
Hi, good afternoon. This is Amy Carter Klein from courtroom 1. I have an
If you can
attorney
get in
here
the
who
car
needs to
now,
have witnesses let
very
in
fast you
for our
can.
hearing.
All right, thanks.
Could you all let them in? I don't see one. Dexter, can you hear me?
Yes, Your Honor.
Is there a deputy there in courtroom 2?
Yes.
Yes, they are. I was just told before they weren't allowed to come up, so I just wanted to make sure that they're now coming up to the front and they'll be let into courtroom 2. No. They weren't allowed to come in, so their attorney just called them to say, hey, you can come into the courthouse. So they're on their way to the front entrance, and then they'll need to be brought to courtroom 2. Yes. Correct. I think they were in the parking lot, so it should just be in a minute or two. Okay? Mr. Snur, how many witnesses?
Well, 3 and they have a child, so.
So 4. Okay. All right, appreciate it. Thank you. Bye-bye.
Want me to stand down until they get here?
Sure, yep. Dexter, we can proceed with the rest of the docket until we're ready to continue Mr. Ingram's
Yes, Your Honor.
hearing. Thank you.
Hello. Okay.
Good afternoon. Tell me your name, please.
My name is Jimmy Lorego.
How about Danielle Harp?
I'm sorry, Your Honor. She bonded.
Ms. Harp bonded. Okay, thank you. And then tell me your name again, sir.
Jimmy Lorego.
Sir, you are here in case number 20MM358. You were arrested for trespassing. There is probable cause. Is there an offer for Mr. Lorgie?
Your Honor, we have him as incompetent.
Oh, okay. Mr. Lorgie,
Yes, ma'am. Yes, miss.
you are not to return to the store that you were arrested at. Do you understand?
Yes, miss.
All right, so you need to abide by that trespass warning. Otherwise, every time they see you, they're going to have you arrested.
Okay, I promise.
All right, I'm going to release you on your own recognizance at this time.
Okay, thank you.
Thank you, sir.
Thank you.
Good afternoon, ma'am. Tell me your name, please.
Jasmine Robinson.
This is 20 MM 1788. Ma'am, you were arrested for violating your conditions of pretrial release. At this time, your bond is set at none. I will appoint the public defender to represent you if they were not previously appointed.
I never did the nature of this crime.
Ma'am, I'm not saying what's in the affidavit is true. I'm just telling you what the warrant says. Okay?
Okay,
So you'll have to talk to your public defender about that.
Okay. Will I be able to get a bond or no?
They'll have to file a bond motion. It was revoked.
She has a private
So,
attorney, Leslie
what I
Sweet.
do
So it's my understanding that Ms. Sweet represents you, so you're going to want to get in contact with her to see if she can file a bond motion in front of the trial judge.
All right.
Okay? Thank you. Good afternoon, sir. Your name?
Kevin Chapman.
Mr. Chapman, you are here in case number 20MM2052. It is alleged that you have violated your probation by not complying with all the instructions given to you by the court when you failed to report to central intake on May 11th of this year. It also alleges that you have not completed the conditions of your probation. Your bond is set at none. If you'd like to enter a plea today, the recommendation is 120 days in the Orange County Jail. Revoke and terminate your probation. Your license will be suspended until you complete the mental health evaluation and provide proof to the clerk. Mr. Matos, I'm going to appoint your office to represent him. Do you want to enter a denial and then talk to Mr. Chapman about what he'd like to do?
Yes, Your Honor.
Okay. Mr. Chapman, the public defender has entered a denial on your behalf at this time, so they can come talk to you about the facts of your case and see what the best option for you would be. This is a Division 61 case. That's right. We've heard of Division 61, which is weird because it's a DV case.
It's not assigned to a division yet.
Oh, really?
Yeah, according to our system, it's not.
And it was signed, yeah, Division 61.
Let me go
It's
back and
on the
look.
warrant.
Okay.
Yes?
I'm gonna go back and look at some old,
Maybe it had gotten reassigned. There was
Yeah.
a time period when I think there was too many.
everything is still showing A. We can go ahead and assign it to 61. We'll just use that.
Okay. All right. I'm going to give you a Division 61 court date, which is going to be August 24th at 8:30 a.m., and that's courtroom 6C. Thank you, Mr. Chapman.
Okay.
You're the next on the list, Stanley James, medical.
It's medical. Okay. Mr. Matos, I'll appoint your office. Do you want to waive his appearance?
Yes, Your Honor.
All right. That's 20 CT 527. It's alleged that Mr. Stanley violated his conditions of pretrial release. Bond is set at $500. Good afternoon. Your name?
David Babuff.
Sir, this is 20 CF 9130. You were arrested for trafficking in methamphetamines greater than 200 grams, possession of methamphetamine with intent, and tampering with physical evidence. There is probable cause. I'm going to appoint the public defender to represent you. You're not to possess or consume any controlled substances without a valid prescription. Your bond on count 1 is going to be $100,000. Bond on count 2 is $150,000. Bond on count 3 is $150,000. Thank you, sir.
Nikki Bell, Your Honor.
Ms. Bell is medical.
Mental health,
Mr. Matos, do you want to waive her appearance?
Yes, Your Honor.
I'll appoint your office to represent her. She was arrested in 20 CF 9109 for battery on a law enforcement officer and resisting officer without violence. There is probable cause. Bond on count 1 will be $1,000. Bond on count 2 is $100. Good afternoon. Tell me your name, please.
Samuel Bengochea.
Sir, you were here in 20 CF 9053. You were arrested for battery on a law enforcement officer. There is probable cause. I'll appoint the public defender to represent you. Your bond is $1,000, sir. You also have 20 MM 5489. You were arrested for resisting officer without violence. There's also probable cause for that offense, and your bond will be $100. The public defender is appointed on both cases. Thank you, sir.
Hello?
Good afternoon. Are you Mr. Brown?
Yes, ma'am.
Mr. Brown, you're here in 18 CF 17167. You failed to appear for arraignment on April 16th of this year. Your bond at this time is set at none, sir. I will appoint the public defender to represent you. They'll need to file a bond motion in Division 14. Thank you. Good afternoon, sir. Your name?
Jaheen Davis.
Mr. Davis, you have two cases this afternoon. I will appoint the public defender to represent you on both. You have 20 MM 5511. You were arrested for less than 20 grams of cannabis. There's probable cause. I'm going to release you ROR on that case. You have 20 CF 8512. You were arrested pursuant to a probable cause warrant for burglary of a conveyance, criminal mischief, and petty theft. Bond on count 1 is $2,500. Bond on count 2 is $100. Bond on count 3 is $500. And then I'm not taking any action on the out on bond case because the offense date is July 2nd and the offense date in the warrant is June 22nd. Thank you, Mr. Davis.
Excuse me, I got a question.
Yes, sir.
My first warrant. When I came in here for the first warrant, why them warrants weren't issued out at the same time?
I don't know. It depends on when they turn it in. I don't have a good answer for you.
Yeah, because the police officer told me that the warrant was for the same thing, for the same day.
Right, it's an add-on. I don't know, sir.
Okay.
Okay?
Okay.
Thank you.
You're welcome.
Your Honor, John Gray, medical.
All right, I'll take care of Mr. Gray, and then Mr. Stern, do we have everyone present that we need? Okay.
I don't have everyone, Your Honor. I have the police officer and the ASA for the cases on their way.
When are they going to be here?
They're en route right now. They should be here within the next 5-10 minutes.
This is 20 CF 9083. This is he came in as John Doe, correct? It's the right case?
Yes, ma'am.
Okay. Mr. Gray was arrested for battery on a law enforcement officer and resisting officer without violence. There is probable cause. I'll appoint the public defender. Bond on count 1 is $3,500. Bond on count 2 is $100. Pardon?
The information sheet, I'm sorry.
Oh, this one?
Yes, for Mr. Gray. I just need to make sure I spelled his name right. Thank you. Thank you.
Ms. Fusco, I'm going to allow them to appear. I'm going to wait for them to get here. But in the future, you need to have all of your witnesses present when the cases are called. You need to anticipate that you're going to need any witnesses that you may need for a bond hearing. If you think there's any chance that you're going to have to call one of them on any case, then you should have them here. Sir, good afternoon. Your name?
Warner Lee Harris Jr.
Pardon me?
Warner Lee Harris Jr.
Mr. Harris, thank you. Mr. Harris, you have 3 cases this afternoon. I'm going to appoint the public defender to represent you in all of them. You have 20 CF 6140. This was an arrest pursuant to a probable cause warrant for burglary of a structure, criminal mischief greater than $1,000, and petty theft. Bond on count 1 is $1,000. Bond on count 2 is $150. Bond on count 3 is $100. You are not to return to the scene or have any contact with the victims. You have 20 CF 3224. You failed to appear for arraignment on June 12th of this year. Your bond, sir, is set at none. Your lawyer will have to file a bond motion in Division 22. And you have 20 MM 5509. You were arrested for resisting officer without violence. There's probable cause for that offense, and your bond will be $100, sir. Thank you. Sir, good afternoon. Your name?
Chancellor James.
Mr. James, you are here, sir, in 20 CF 8893. You were arrested pursuant to a probable cause warrant for possession of a firearm by a convicted delinquent and possession of ammunition by a convicted delinquent. Mr. James, you're not to possess any weapons or firearms. Your bond on count 1 is going to be $2,500. Bond on count 2 is $150. And then I'm not revoking the out on bond cases. They all stem from the same offense date. Thank you, sir.
Thank you.
Good afternoon. Your name?
Morning.
Name.
Scott Johnson.
Thank you, Mr. Johnson. This is 20 CF 9070. You were arrested pursuant to a probable cause warrant for burglary of a structure and for criminal mischief. I'll appoint the public defender to represent you. Bond on count 1 is $5,000. Bond on count 2 will be $100. You're not to return to the scene or have any contact with the victim, sir. Thank you. Good afternoon. Tell me your name.
Brian Lynn.
Mr. Lynn, you were arrested in 20 CF 9116 for possession of a controlled substance without a prescription and possession of drug paraphernalia. There is probable cause. I'm going to appoint the public defender to represent you. You are not to possess or consume any controlled substances without a valid prescription. I'm going to release you on your own recognizance at this time, sir.
Thank you.
Good afternoon. Tell me your name.
Joseph Eric Masterin.
Mr. Mastrin, you are here in 20 CF 9091. You were arrested for grand theft of a motor vehicle. There is probable cause, and I'll appoint the public defender to represent you. Your bond, sir, is $1,000. Thank you.
That's it.
Good afternoon. Tell me your name.
Glenn Mathis.
Mr. Mathis, you were here in 20 CF 9128. You were arrested for trafficking in methamphetamines greater than 200 grams and possession of methamphetamine with intent. There is probable cause. I will appoint the public defender to represent you. You're not to possess or consume any controlled substances without a valid prescription. Your bond on count 1 is going to be $75,000. Your bond on count 2 is $150, sir. Thank you.
He said 75,000.
75 on count 1. Good afternoon. Tell me your name, please.
Damani, last name Matthews.
Mr. Matthews or the other gentleman?
Mr. Matthews, yeah. Actually has 2 more different.
Oh, Mr. Mathis.
Yes.
The FTA.
Matthews.
Okay, I'll address that in a second.
Okay.
Your Honor, at 1:45, the audio always
Oh,
drops.
that's right. Okay. Let me log off.
that's what the guy said.
Mr. Matthews, can you hear me?
Yes, ma'am.
Perfect. All right, thank you, Paul. You were on it. Okay, thank you.
No problem.
All right, bye-bye. All right, Mr. Matthews, you were arrested in 20 CF 9095 for aggravated assault with a deadly weapon. There's probable cause. I'm going to appoint the public defender to represent you. You're not to possess any weapons or firearms, and your bond, sir, is going to be $1,000.
Thank you.
Thank you. And then, Dexter, I have to bring Mr. Mathis back, or Officer Williams, I have to bring Mr. Mathis back. I missed 2 of his cases. Oh, that's not Mr. Mathis.
It might take us a moment, Your Honor. Can we move forward?
That's fine. I can even do it at the end if it's easier.
He'll be here in a moment, but
Okay, I'll just set it to the side. Thank you. I'll give you that one back.
Okay.
All right. Sir, good afternoon. Tell me your name.
Daniel McCluskey.
Mr. McCluskey, you are here, sir, in 20 CF 9129. You were arrested for failing to report a change in address. There is probable cause, sir. I'm going to appoint the public defender to represent you. Your bond is going to be $1,000. And, sir, you do have reporting requirements when you're released from the jail. Do you understand?
Yes, ma'am.
Okay. Thank you, sir. Good afternoon. Tell me your name.
John Milburn.
Mr. Milburn, you're here in 20 CF 9112. You were arrested for petty theft with 2 prior convictions. There is probable cause. I will appoint the public defender to represent you. Sir, you're not to return to the J.C. Penney. I'm going to release you on your own recognizance at this time.
Okay.
Thank you, sir.
Thank you, ma'am.
Good afternoon. Your name?
Good afternoon, Edward Terrell Pelham.
Mr. Pelham, this is 20 CF 9007. You were arrested for aggravated assault, domestic violence, and burglary of an occupied dwelling with an assault or battery therein. This was pursuant to a probable cause warrant, and I will appoint the public defender to represent you. Ms. Fusco, did you want to be heard with respect to bond?
Yes, Your Honor. The state asked the court to consider all the facts in the affidavit. The victim and the defendant have a child in common. They've lived together in the past, but several months ago, he moved out and he no longer had permission to enter the home. He entered holding a knife and threatened to kill the victim. There were witnesses present. One of them gave a statement. The state asked the court to find that there's proof, evidence, presumption great that the defendant entered the home of the victim without permission, holding a knife with the intent to commit an assault therein, and hold the defendant at no bond.
Mr. Matos, did you want to be heard?
Your Honor, we would like to reserve this for an author here in downtown, and at this point, we'll leave it at the court's discretion.
Okay. Well, based upon the information that's before the court today, there is enough evidence for the state to meet their burden at this time. So Mr. Pelham, your bond on count 2 is going to be remain at none. You're entitled to bond on count 1. That bond will be $150.
Okay, thank you.
Oh, wait, I'm not done. Mr. Pelham, you are not to have any contact with the victim. You are not to return to the scene. You are not to possess any weapons or firearms. Do you understand?
Yes, ma'am.
Okay. Thank you, sir.
Thank you.
I'm not making a finding, actually, as the proof evident because the defense didn't require me to or want me to, so they can do the whole thing.
Okay, thank you.
Your Honor, we have Mr. Mathis back.
Oh, good. Okay, thank you. Mr. Mathis, I missed 2 of your cases, sir. You have 20 MM 3992. You failed to appear on the offense of petty theft for arraignment on June 25th. Bond in that case is $500. And then you have 19 MM 5562. You failed to appear for a violation of probation hearing on June 26th of this year. You're not to have any contact with the victim, and the bond in that case is set at none. That's a Division 50 case. You'll need to have your lawyer file a bond motion in Division 50.
You said you said because of having contact?
No, you failed to appear in court for your hearing.
I mean, with both of those charges, I was sent from the courthouse because of the COVID-19. So I was getting in contact with my probation officer, and she was trying to figure out court dates for both of those, as of
Okay.
I was, and nothing ever came up. Like, I was sent from the courthouse like 6 times.
All right, Mr. Mathis, just give me a minute, okay?
Okay.
Yeah, this is really odd, Mr. Mathis. You probably don't want to make a note in the. sheet with the. All right, Mr. Mathis, I'm gonna modify that Capias. Your next court date is gonna be on August 20th, August 20th at 10 a.m. It's in Division 50 in front of Judge Shoemaker.
Okay.
She has dates in the computer.
I mean, because when I was my first initial time showing up for court, it was for I think she retired. I forgot the judge's name.
Right, Judge Bell. That's
Judge
right.
Bell, yes, Marine Bell, and then
Yes.
they pushed it back and they had me coming to court to see Judge Shoemaker, but they kept turning me around at the courthouse because of the non-entry of the fact for the COVID. So on both of those last two, the violation of probation and then the dealing in petty theft.
On the petty theft.
So on both of those, I kept getting a turnaround when I was showing up for court for it. So, I mean, I even told my probation officer, she looked into it. She did send me an email saying that she probably wouldn't have any choice but to do another technical, but she would have to find out, and I never got an answer for that either.
Yeah, I don't know about that, sir.
I'm saying because of me not being able to go to court, she said that.
I don't know if she's doing that or not. That's something that you'll have to talk with her about. I don't have any information regarding that. But it does look like your court date's actually already been reset for the 17th of August. And it's gonna be at 2:30 p.m.
And that's for the petty theft or the
Nope, that's
domestic?
for the battery. That's for the battery. And then, let me just see if you have a court date on the misdemeanor. So, Mr. Mathis, I don't know how the division's working right now in terms of hearings with the COVID, because a pretrial is not an essential hearing, so it can't be in person. So you need to get in contact with your lawyer ASAP to figure out where you need to be and when.
Okay.
$3,992. Did that take that one?
That one doesn't have a date.
No. All right.
It's up here for arraignments, so.
Yeah, I don't know. Okay, all right. So I'm gonna set bond at $500. Mr. Mathis, I'm setting bond at $500 on the battery case, okay?
The batteries.
Thank you, sir.
The batteries are already set at 5.
It was set at 9.
No, it was set at none. The petty theft is $500.
Okay. May I ask you a question
Yes, sir.
about the two charges with the methamphetamine? I wanted to know how I was getting charged with that when.
So listen, I'm gonna stop you.
Okay.
Those are all really good questions that you're gonna need to talk to your lawyer about, okay?
Okay.
If it's about the facts of your case and what they can prove and what they can't prove, that's something you have to talk to your lawyer about. I don't want you to say anything that can be used against you later.
Okay.
All right?
All right.
Thank you, sir.
Thank you.
Sir, good afternoon. Tell me your name.
My name is Alexander Posley.
Mr. Posley, you're here in 20 CF 9111. You were arrested for carrying a concealed firearm. There's probable cause. I will appoint the public defender to represent you. You are not to possess any weapons or firearms, and I'm going to place you on pretrial release at this time, sir. Thank you.
Thank you. Ma'am, I do have a question for you.
Yes.
When I did have my firearm, there was an individual that walked up to me, showing that he
Well, hold
had,
on. Listen, wait. I don't want you to talk to me about the facts of your case, okay? If you want to ask me about how you can get your firearm back, you'll have to do that when the case is over.
the only thing I really just want to know is because officers let me know that I was only getting arrested because my bag was not closed. But
Again, Mr. Posley, listen to me.
Oh.
You're not listening to me. All of those are really good things to talk to your lawyer about. Today is not the day that I can hash that out with you, okay?
Okay.
All right. Thank you, sir. Ma'am, good afternoon. Tell me your name, please.
Tiffany Perk.
Ms. Perk, this is 20 CF 9093. You were arrested for grand theft of a motor vehicle.
Yes.
There's probable cause. I'll appoint the public defender to represent you. Your bond is $1,000, ma'am.
Okay.
Thank you.
Is there any way I could get a PR bond?
Pardon me?
Is there any way I could get a PTR bond?
No, ma'am. You are on probation in Ohio, and you have a warrant for failing to appear in Ohio. So I'm not going to do PTR or ROR.
Okay. All right. Thank you.
Okay? Thank you.
Y'all, the next on the list is Robinson. He refused court.
I have Mr. Ranking.
Thank you.
Okay. And then Robinson's a refusal.
Yes.
Okay. Are you Mr. Ranking?
Yes, ma'am.
Sir, good afternoon. This is 20 CF 7600. You were arrested pursuant to a warrant for attempted possession of a firearm by a convicted felon, discharging a firearm in public, and false reports to law enforcement. I will appoint the public defender to represent you. You are not to possess any weapons or firearms. Bond on count 1 is $2,500. Bond on count 2 is $150. Bond on count 3 is $100. Thank you, sir.
You're welcome.
And then I'm finding a waiver of Mr. Robinson's appearance based upon his refusal to come to court in 20 CF 9054. I'm going to appoint the public defender. He was arrested for burglary of a structure, burglary of a conveyance, petty theft, resisting officer without violence, and criminal mischief greater than $1,000. There's probable cause. He's not to return to Giant Recreation World. His bond on count 1 is $2,500. His bond on count 2 is $150, 3 $100, 4 $100, 5 $150. Good afternoon. Tell me your name, please.
Matthew Ross.
Mr. Ross, this is 20 CF 9019. You were arrested pursuant to a warrant for failing to report a name or residence change. I'll appoint the public defender to represent you. Your bond is $1,000, sir. Mr. Ross, I'm not going to revoke your out on bond case today, and you do have reporting requirements when you're released from the jail. Do you understand?
Yes, ma'am.
All right.
Can I
Thank
ask
you,
a
sir.
question, ma'am?
Sure.
Because I've never dealt with the whole bond thing. So you said you're not going to revoke what I was out on bond for. So if this bond is paid, I can get out on this and just get out?
That's right.
Okay, thank you, ma'am.
You're welcome.
My name is Jagason St. Victor.
Good afternoon, Mr. St. Victor. You have 2 cases this afternoon. I will appoint the public defender to represent you on both of them. You have 20 CF 9122. You were arrested for burglary of a structure, criminal mischief greater than $1,000, grand theft second degree, and trespass in a conveyance. There is probable cause. Bond on count 1 is $3,500. Bond on count 2 $150, 3 $150, 4 $150. You also have 20 MM 359. You were arrested for possession of cannabis less than 20 grams and trespass in a conveyance. There is probable cause for both of those offenses. I will ROR you on count 1 and count 2. You're not to return to the scene, sir. Thank you.
Wait, Your Honor, I could ask you a question?
Yes.
So basically, I don't really know what I'm like. Y'all know? I don't really know what I can't get the question out.
What's your question, sir?
So like, what's my bond basically? I can't. It is.
Do you need to write them down?
Oh no.
You wrote them down, Your Honor.
He wrote them down? Okay. Thank you. All right. Do we have everybody here for Mr. Ingram's case?
Good afternoon, Your Honor.
We do.
Good afternoon.
Good afternoon.
All right. Mr. Resort, do you just want to put your appearance on the record, please?
Yes, ma'am. Tom Mazurk on behalf of the state of Florida.
Okay.
Your Honor, are we going back to Mr. Ingram at this time?
Yes, thank you very much. Mr. Snur, who did you want to have come in first?
Are we going to deal with the, I'm not sure what my burden is. I may have to overcome a burden. Are we going to deal with the legal classification, or are we talking about bond at this point? If you're settled on what you indicated earlier, then I'll just call my witnesses and see what happens.
Well, I'm not settled on the weapon classification, but it would still entitle Mr. Ingram to a bond.
Well, that's what I meant.
I beg your pardon, Your Honor. Obviously I missed what came before, not having had the benefit of the first part.
Sure.
What's, if I may ask, what's the court's first concern if it's something that I can address?
So, in a nutshell, prior to you being here, we discussed the offense for which Mr. Ingram was actually arrested for pursuant to the probable cause warrant. Mr. Snur established that there was not probable cause for what was contained in the warrant based upon what the predicate felony was, and then trying to establish the second-degree felony murder. He provided the case law and the statute, and what is in the actual affidavit substantiates third-degree murder, which is a second-degree felony. His second argument is that the weapons enhancement does not apply to third-degree murder, and he provided a case to establish that as well. I wasn't sure whether or not the weapons enhancement applied based upon the facts in Mr. Ingram's case.
I just don't want him to get off on a tangent. My assertion is that the weapons enhancement doesn't apply unless there's evidence that Mr. Ingram was the shooter or possessed.
Yes, that's your argument.
Not that it couldn't apply. It's
Yes.
just factually that it doesn't here.
Yes.
Okay. Then if my understanding is correct, the court has found, based upon the affidavit for the arrest warrant, that there was not probable cause established for a second-degree felony murder. Is that correct, Your Honor?
That's correct.
Okay. In that case, the state would ask for the court to review whatever came before my appearance this afternoon through the testimony of Detective Josh Miller, who is the lead detective on this case. He's here this afternoon, and he may be able to, I think he can provide whatever information may have been missing from Your Honor's prior determination that there was not probable cause for second-degree felony murder.
If I'm, Judge, the argument is not a factual one, it's a legal one. Is that aggravated battery is not a predicate offense to support either second or first by statute, but it would be to support third. I have the statute.
That's correct.
It's sitting right there if you want to look at it.
Okay. What I wasn't entirely sure on would be where the determination was made, and I haven't seen the affidavit in support of the arrest warrant at this point, Your Honor, but where the predicate felony would have been an aggravated battery.
That's correct.
Yes, and if that was what was contained in the affidavit for the arrest warrant, that's something that I'm unaware of.
Do you want to see it?
If the court doesn't
Does
mind.
this have it?
Actually, I'm sorry. I don't know if this is going to be the same as the affidavit.
And then the supplement was pretty much exactly the same, except for
The
I
supplement
found
adds a
one
couple
additional
things.
sentence,
It adds two things.
Okay.
and then one additional paragraph.
And then I think that may be the issue that I'd be asking for the court to reconsider as to whether or not the predicate felony would have been an aggravated battery, or if it could have instead been an attempted homicide.
That's what I was arguing.
So, Mr. Schnur, I think that that's a reasonable request, and I think that that is fair. I think under what's happened in court today, you came in and asked the court to reevaluate the information that was contained in the probable cause affidavit. The state's asking to be able to be heard and to provide the court with additional facts in order to establish what was actually in the affidavit. So I'm going to hear from the detective as to what other additional facts may be that could be used to establish, I guess, the predicate felony.
Can't stop you from doing that. So.
Okay. All right. Did you want to have the detective sworn in, Mr.
Yes,
Ward?
ma'am, please. Would you like Detective Miller at the podium, Your Honor?
I think it'll be easy to hear at the podium
Yes,
or
ma'am.
at the lectern.
Do you mind? I have time for a question. Here, that way.
That's fine.
Can you raise your right hand, please? Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Can you state your name for the record?
Detective Joshua Miller.
Thank you.
Your Honor, may I proceed?
Yes, you may.
All right, great. Good afternoon, Detective Miller. I don't know if you've met Judge Carter on a previous occasion, so could you please introduce yourself to the court, including your first and last name?
Nice to meet you. I'm Joshua Miller with the Orange County Sheriff's Office.
Thank you, sir.
And Detective Miller, are you currently assigned to the homicide unit at the Orange County Sheriff's Office?
Yes, I am.
All right. And how long have you been a part of the homicide unit for?
Since February 2019.
And prior to that, were you in the sex crime unit?
Yes, I was.
All right. As it specifically relates to this case, are you the lead detective as it relates to homicide investigation regarding a defendant?
Yes, I am.
All right. So then I want to take you specifically to the investigation that you have been undertaking as it relates to defendant Ingram. Can you please tell first to Judge Carter, give her a description of the geographic area where the death of the victim occurred?
This was off Powers Drive, which is a pretty major intersection in Pine Hills, Florida. It was Pine Ridge, I believe it's Court, which is a subdivision that's off Powers Drive, in between Claricona, Coe, and Silver Star Road.
And so where the decedent was actually found by law enforcement, was that in a residential area?
Yes.
All right. Now, when I say residential area, is it mixed at all, or is it entirely a residential neighborhood?
It's entirely a residential neighborhood.
Okay. And then even more specifically than that, the residential neighborhood where the decedent was located, is there any particular way, or are there multiple ways in which you can access the location where his body was found?
There is one way into the neighborhood and one way out of the neighborhood.
All right.
By vehicle.
All right. And so if someone were to be driving into that neighborhood, would it be in regards to the destination of like a purposeful route you would have to take?
Yes.
In other words, where the decedent was found, would someone be traveling that same path to access another neighborhood or a resident or a commercial area or anything like that?
No.
Okay. Can you, is it almost like a cul-de-sac or something like that?
Yeah, it's like a big circle is kind of how I described it. Almost like maybe like a beer bottle. There's kind of a long entrance, like not too long, but a longer entrance, and then when you enter, it's a circle or an oval with the residences on each side.
Okay, and so again, by car, it's one way in and one way out?
Yes.
All right. When you were investigating this case, did you ever obtain any type of surveillance video that would have revealed any information about the death of the victim in the case?
Yes, I did.
All right. Did you have an opportunity so far to review that video?
Yes, I did.
Do you have that video with you this afternoon in case Judge Carter would like to review that for herself?
Yes, I do.
All right, very good. Well, we might get back to that, but in the meantime, can you please explain to Judge Carter what you observed on the video, the surveillance video, as it relates to the death of the victims?
You see, the first thing that you see that catches your eye in the video is...
Excuse me, I'm going to object to the description of the video. That's impossible to object to selective editing. I'm going to ask you to look at it if they're going to use it.
That would be sustained. I can look at the video for myself.
Okay, great. Judge, would you like to do that now?
He can finish the testimony and then I'll go.
All right. when you were reviewing the video, did it ever appear that shots were fired from a car?
Yes.
And in reviewing the video, were the shots fired in a particular direction?
The way the car drove into the neighborhood, the passenger only kind of had from the passenger window, only had a limited area to shoot. And the people who were near the two cars that you'll see in the video were the intended targets of the shots.
All right. Were there shots that fired fast towards the vehicle?
Yes, there were.
But the actual first shot, where did the first shots originate from?
From the vehicle.
And how are you able to determine the shots first came from the vehicle?
In this video, you see several people exit two vehicles that pull up, and then as the third vehicle enters the neighborhood, you hear shots being fired. And if you quickly look at the people exiting the car, none of them are in like a shooting posture. None of them have or appear to have guns on
I have
them.
the same objection, Your Honor, that this is a selective editing and selective recantation of what he thinks is not recantation, but an accounting of what he thinks is in the video. I leave it to you to assess that.
I don't necessarily disagree that it's going to be Detective Miller's explanation of what he sees, but as the court is well aware, the rules of evidence that are applied here are vastly different than they are in the trial. So I'd ask that the court consider Detective Miller's testimony for what it's worth this afternoon.
Okay, so I think what I'll do then is I'm gonna take a break then. I'm just gonna go watch the video so I can watch for myself, and I don't need to have the detective tell me what he saw in the video.
Yes, ma'am.
Okay?
In that case, though, I think the court, if you don't mind, will probably have to watch it from Detective Miller's laptop. Is that right, John?
Yeah.
Well, then, do you guys want to watch it up here? Okay, that's fine. Sure. Yep.
Yeah.
I'll be able to, but you would need an HDMI cable. You could ask.
Because I wonder if there's a way to hook that up so that it can be seen on the monitors.
Mr. Stern, I wish I knew how to do that, but I do not. I'm just happy that it's working today.
We don't want to go past 145 again.
Right, every day without fail, and they can't seem to figure out, every day everything shuts off at 1:45, and then we just have to reboot and continue.
Hey, Judge, maybe somebody can try to maintain the appropriate distance, or does it mind you can view it first, then provide it to the
Okay.
As long as you're respectful of distance.
I appreciate that.
no problem.
Right. It's, I mean, it's a lot, just in that little span of time. So if you mind if I present you with the detective laptop momentarily so you can video?
Sure, please.
May I approach?
Yes.
Need help? Please let me know.
I do.
Need help?
No, don't got it. Okay. I don't want to get touched.
Judge, I want to take you off and view the whole thing.
Okay.
May I approach?
Sure, thank you.
And Judge, may I continue that questioning Detective Miller?
Yes.
All right. So Detective Miller, now that Judge Carter has had an opportunity to review the surveillance video, I want to take your attention first to the black car that is featured in the video. Was that car identified with the defendant in this case?
The car
In the street?
that when it makes its approach, they're shooting.
Yes, sir.
Yes, Mr. Ingram was driving that vehicle.
Okay. And the direction of travel of that that vehicle belonging to Mr. Ingram, was that headed to the neighborhood in such a way that he was headed just into further residential area?
To me, no, it did not look that way.
In what direction? And actually, have you had an opportunity to go to the actual scene also?
Yes.
Okay. So having had an opportunity then to go to the scene where the shooting occurred in the video, in what direction of travel was the vehicle that is in that video?
To me, it looks like they got into the entrance.
Judge, I'm going to object. He's speculating. The direction of travel is a directional answer, westbound, northbound. But describing what they were thinking about doing, really it's visible to you. That's what I'm trying to avoid. I object. Speculative.
I'll sustain the objection.
Okay, so based again upon your having gone to the scene itself and having seen the surveillance video, what direction of travel was that car headed?
When the shots are quit being fired, they are stopped, the vehicle looks like it's bladed. So if you were going to turn right, the car, all of it would have gone to the right. If it was going to go left, all of it was going to go to the left.
Object again, Judge. It's just.
I've seen the video. I saw the car turn.
So I guess, I beg your pardon.
Go ahead.
My question is, would you have had to turn around in order to exit that neighborhood?
He would either had to turn around or go all the way around the neighborhood to go out the exit.
But there, again, that's just one entry and one exit.
Correct.
Okay, so the direction of travel of that car, the car couldn't have been going to some other area.
No.
I mean, he couldn't have been going to another street or another neighborhood, a business, or anything like that.
He would have had to pass the house that was with the people exiting the vehicle, and when they entered, they were heading towards a residence. That vehicle would have had to pass that residence in order to go anywhere else in that neighborhood, if that's what you're asking.
Well, would the vehicle essentially have had to go through the bottleneck, turn around, and come back out?
Yes.
Okay. So, are you also...
Mr. Wazork, it might be, maybe if we can pull the clerk's microphone, the court reporter is calling us having difficulty hearing.
I could pull it closer too.
Okay. So essentially then, the vehicle driven by the defendant would have had to turn around on that same street in order to leave that street again. Is that correct?
Correct.
Okay. Now, as a law enforcement officer with the Sheriff's Department, do you have a familiarity and training with firearms?
Yes.
Are you trained on pistols?
Yes.
And are you also familiar with rifles?
Yes.
Does that include how the two different guns operate and the sounds that they make when they're fired?
Yes.
All right. Now, in this particular case, was any type of gun found in the possession of the defendant?
Yes. He handed a deputy a firearm, a handgun.
Was that handed to one of the first responding deputies on scene?
Yes.
All right. And through your investigation in the case, did you learn if any of the people who had first arrived at the house had been in possession of any type of gun whatsoever?
A rifle was recovered. Mr. Sands admitted to shooting the rifle after being shot at by the vehicle by Mr. Robinson, the deceased in this case.
All right. Now, with your familiarity with firearms, do you have an opinion as to what type of gun is first being fired in the video that we observed?
I think he's been qualified for that.
I think Mr. Wazork just laid the predicate of his knowledge of the
I
firearm.
own pistols and rifles, and I wouldn't hold myself out to be an expert on what they sound like at a distance. On a Nest sound system on a camera attached to a house a block away.
I'll allow the witness to testify that. He testified that he had training and experience with the firearm, so I'll let him testify to that.
So based on your experience with firearms, Detective Miller, what type of gun did you believe we first heard fired on that surveillance video?
A handgun.
All right. And then subsequent to that, do you have an opinion as to what type of gun was being fired in response to the handgun?
Rifle.
All right. And was that consistent then with the other evidence in this case as well?
Yes.
All right. And to your knowledge, through your investigation, did you determine if there was any reason for defendant Ingram to be driving through that neighborhood on that particular day?
False speculation.
Sustained.
As far as you know, did defendant Ingram live on that street where the shooting occurred?
No, he did not.
All right. And are you personally aware of any friends or family members that defendant Ingram had on that street that would have caused him to be driving past on that particular occasion?
No, I am not.
All right. And in fact, did defendant Ingram speak with law enforcement when they first arrived on scene?
Yes, they did. Yes, he did.
And to your knowledge, did defendant Ingram ever provide a reason as to why he was driving past that house at the time that the shooting occurred?
Judge, this is a comment on the right to remain silent.
I'll sustain.
Judge, at a bond hearing, his right to remain silent is irrelevant to the question of whether or not there's probable cause.
All right, you can.
That's a jury issue. Did he ever provide a reason to law enforcement for his presence in the neighborhood at the time that the shooting occurred?
Same objection.
No, he did
No,
not.
I'm sorry.
No, he did not.
All right. And the deceased in this case had, if you know this, was it determined that the type of injury he sustained would have been consistent with a shot from the rifle that was fired at him from the resident or occupant, whatever he was, of the house that was shot at?
That is something I'm yet to get an answer on. I'm waiting for ballistics to come back from the FDLE.
Okay. I have no further questions at this time, Your Honor.
Detective, the things that you just testified to, you knew when you filled out the affidavit in support of an arrest warrant, true?
Yes.
And the things you just testified to, you knew when you filled out the supplement that we've since received.
Yes, sir.
And in that, you characterized the underlying felony as an aggravated battery, true?
Yes, sir.
Now, did you canvass the neighborhood to determine whether Mr. Ingram knew anybody down that street?
The deputies that initially got the detectives and the deputies did canvass the area.
Every house?
I do not know if it was every house. I know they spoke with several neighbors, one being the truck that pulled in at the beginning of the video. I don't know if it was every house.
Mr. Robinson, the passenger, was not communicative, as far as you know, at any time?
No.
So he wasn't able to be asked where they were headed or who they knew back there?
No.
You were able to determine that all of the shells fired from the black sedan were fired out the passenger window, right?
Yes.
All the shells were out the passenger side.
Yes. Most, if not all, the shots came from the passenger side, according to witnesses.
No shells found in the car.
I'd have to look over the forensics report,
But it's your belief that the passenger, Mr. Robinson, is now deceased, fired the gun?
yes.
And that was supported by witness testimony of the other people, right?
Yes.
Now, in that video, when the black car pulls up, it blocks the view of the other car. True, it kind of gets between the camera and that other car.
Yes.
We can't tell in looking at that video whether anyone in that car pointed a rifle or a gun at the black sedan, can we? From the video.
You can see him, I mean, you could see him seconds before the shooting, and he does not look to have a rifle or long gun in his possession, and then the shots are fired, and then he goes into the vehicle. I mean, you don't see that on the video.
That's right.
But you can see on the video before the car cuts off the camera that the person who shot is not armed at that time, and then you see the car.
You don't know if anyone else pointed the gun and that the shooter, his name is the guy who shot with the rifle?
Jeremiah, Mr. Sands?
Mr. Sands, you don't know whether he got the rifle from someone else? You can't see on the video how all that went down, right?
Correct.
Mr. Ingram invoked his right to remain silent after he told the responding deputy that he fired the gun, right?
Correct.
He didn't answer any other questions
Correct.
of any kind.
No, he did not.
And you took him down to the operations center, right?
Correct.
Or he was transported?
Yes.
He didn't answer your questions down there, did he?
No.
I have no further questions, right?
Judge, I had one maybe follow-up to Mr. Schnorr's questions. Detective Miller, Mr. Schnorr had just asked you about the defendant's statements to law enforcement. Now, you had given an opinion that you thought the evidence was consistent with the passenger of Mr. Ingram's car firing the weapon first. Is that right?
Yes.
But did Mr. Ingram actually make statements attributing or claiming that he was in fact the person who had been shooting at the occupants or residents of that house?
To one of the initial deputies, yes. He said he fired the gun. And then when we asked for clarification, he did not speak with us.
Okay. And then he handed the gun to that same responding deputy?
Yes.
I mean, he mean Mr. Ingram?
Yes.
Okay. All right, thank you, Detective Miller. I have no further questions, Your Honor.
Just have one follow-up on that one. When we spoke, you told me that you didn't believe that because all the shells were out the passenger side, right?
When we spoke, I said I did not believe. Looking at his autopsy photos, Mr. Robinson's autopsy photos, he has a, and I'm willing to show those as well. He has one gunshot wound right here to the base of the skull, which made me believe if he's outside the car shooting, I didn't see, and there was no exit wound. The actual round was recovered from his skull. It was hard for me to believe how did a projectile get behind him if he's facing. So one of the early thoughts was maybe Mr. Ingram had a gun, fired across, and hit the passenger. The fact that no second firearm was recovered from the vehicle, just following the evidence, I don't think Mr. Ingram fired the shot that killed Mr. Robinson ultimately.
And the projectile recovered from Mr. Robinson's head, you say there was no exit. Has that been identified to any gun or traced to any gun?
That's what we're waiting for from FBLE.
So
I have a picture of the round, if you would like to see that, but
we can't. I don't think anybody here can. You can't identify.
yeah.
Okay. Could you tell what the direction of travel was?
It was, no, it's too mushroom, but like I said, the entry is right here. If I could show you a picture for clarification.
I don't have any further questions.
You said no other questions?
Yeah, I'm sorry.
That's okay. Mr. Resort, did you want to put on any other evidence?
No, ma'am, not at this time. I think the court's already had an opportunity to review the affidavit in support of the arrest warrant as well as the supplemental report that was provided by Detective Miller.
Yes, I have.
All right, then no, ma'am, nothing further.
Okay, so
I
then
won't argue that.
this time you're asking the court to find that there is probable cause for felony murder?
Yes, ma'am.
Okay.
Felony, yes, second degree.
And that's based on the underlying felony would be the attempted murder of Mr. Sands?
Yes, ma'am. Based upon, again, all the evidence that has been presented to the court. The state's position is that there is certainly probable cause for second-degree felony murder, and further, the state's position is that the court would be well-founded in making a determination that the proof of the defendant's guilt is evident and the presumption of his guilt is great. It is a punishable by life felony. From the state's perspective, the evidence establishes that the defendant in the case, who is identified as the driver of the car the court had an opportunity to see on video, entered into that residential neighborhood after the targets had already arrived, pulled up obviously in front of the house as the court could see on the video, and someone from that car began firing at the people at that house, and one of the individuals at that house then returned fire, ultimately resulting in the death of the victim identified in this case. But it is incredulous, I think, that to believe otherwise, that the defendant in this case did not go into that neighborhood on that occasion with the purpose of seeing through a shooting in front of that house. The car is obviously stopped in front of it. Whether or not he was the shooter or not, because at one point he claimed that he was, Detective Miller actually has said that he doesn't think that's true, much to, I think, law enforcement's credit. They have made a determination based on the evidence, the other eyewitnesses, and the location of the shell casings. Perhaps the defendant wasn't, in fact, the shooter, but he had every intention of seeing that that shooting was carried out. Unfortunately, of course, the end result ended up in the death of his passenger at the time. It is a punishable by life felony, Your Honor, and the state's position is that the defendant should continue to be held on no bond. I understand this court may still have discretion subsequent to whatever finding the court makes, but that's the state's position as to probable cause as well as proof evident presumption grade.
Okay, thank you, Mr. Resort. Mr. Snur?
Yeah, there's huge jumps and leaps of logic in that, and speculative leaps of logic at that, Your Honor. Nothing changed. You didn't hear a single thing today that wasn't written down. and it was characterized as an aggravated battery, maybe because of the interviews, who knows? The link that Mr. Ingram, the defendant, had knowledge of what was going to happen is tenuous at best. So even if you altered your understanding of the facts to determine that it supports probable cause that a homicide was the underlying felony that would support a felony murder charge, even if you've come to that conclusion, the idea that the proof is evident, the presumption great on this seems, just as to use Mr. Resort's terms, incredulous. We can't get there from here without indulging every inference upon inference upon inference. So I think that there's nothing wrong with him coming in and putting on some additional evidence, but all of this was known before. And when it's discovered that all of a sudden it's not going to get rubber stamped, they take the same evidence and argue it says something different. That's just hard to swallow for a defendant who comes here ready to make argument on what's been put on paper. Again, if they're free to put on evidence, so we're living with that part of it. But I don't think it's, on this evidence, it's possible that they could have met their burden of proof evidence presumption.
Your Honor, with all due respect to Detective Miller in the case, he was the one that prepared the affidavit in support of the arrest warrant. He identified the predicate felony as aggravated battery. I disagree with that, again, respectfully to Detective Miller. I think that the evidence does establish an attempted homicide in this case. I was not, of course, the one to personally prepare the affidavit for the arrest warrant and otherwise submit it. So I don't think that Your Honor is in any way limited by Detective Miller's characterization of the predicate felony as an aggravated battery in the affidavit. I think the court has well within its right to find that there is probable cause as a predicate felony for attempted homicide, particularly having reviewed the actual surveillance video that was obtained, which of course could not be included in the affidavit for arrest warrant in the way that it was presented to the court today. There's no concern about rubber stamping anything. When I found out that the court was making a review of what previously occurred, I didn't even know the defendant had been arrested. I wanted to make sure that the court was completely informed as to the evidence in this case and what the state currently believes the state can prove at trial. And I think that there is certainly proof evident presumption grade of second-degree felony murder under the circumstances. There was no reason for the defendant to be there in the first place unless his intended object was to be shooting at the people that day.
Okay. So the first thing I'll address is the revisiting of the probable cause. I think that that is okay. I found initially the probable cause for the third-degree murder. The state requested the 24 hours. I granted them that time. I was going to proceed on the third-degree murder bond, but then the state brought the additional evidence and witnesses. So I'm satisfied with that portion. The second part...
Satisfied, I'm sorry.
That I properly allowed the state to present the additional evidence for the attempted murder for the underlying predicate to establish the felony murder.
Are you finding that?
No, just that I allowed them to do that.
Understood, thank you.
Haven't got there yet. So the second part is whether or not there is probable cause if the state's met the burden to establish that by what was presented in court today. So the standard for probable cause is whether or not a reasonable person would believe, based upon the facts and circumstances, that the crime had been committed. That is a very low standard. It's completely different than a reasonable doubt or beyond a reasonable doubt, which is what is required for proof evident presumption grade. So based upon that standard and what I viewed in court today, I do think that you could make, I do find that there is probable cause for that underlying felony of attempted murder. Now, having said that, as I just said, the standards are very different between probable cause, reasonable doubt, and beyond a reasonable doubt. And after viewing the video, I don't think that the state can meet their burden to establish that there is proof evident or presumption grade. As Mr. Snur stated, the only additional evidence that was presented in court this afternoon was the video. Everything else was contained in the affidavit. What also was in the affidavit, when I read, was there were 4 other people that were witnesses to the incident, and I didn't have any information about that either. So when you look at the video, to me, the video is unclear about who started the shooting, how it occurred. I don't know. I have questions about what happened, so that to me says that there's not proof beyond a reasonable doubt if I have questions about how it occurred. So I'm going to allow Mr. Snur to put testimony on in order to establish bond for Mr. Ingram.
All right, let me call then, if I might, Mr. Ingram's mother. Want to testify inside the window, Your Honor?
Yes, please.
Okay. Thank you. Ma'am, if you'll tell us your full name.
Janitra Sharon Harp.
Let me just stop you 1 second, ma'am. Could you please raise your right hand to be sworn in?
Do you solemnly swear and affirm the testimony you're about to give shall be the truth, the whole truth, so help you God?
I do.
Thank you.
Your Honor, would you permit her to remove her mask for clarity purposes?
Yes.
Thank you. Tell us again your full name.
Janitra Sharon Harp.
How are you related to Mr. Ingram?
Mother.
How old is he?
Jermaine is 23, 24.
Okay. Where does he live?
1919 Lockshire Loop, Ocoee, Florida, 34761.
Who else lives there with him?
My husband and my son.
You live there?
Yes.
You, Mr. Ingram, your husband, and another son of yours?
Yes.
Okay. Who owns the home?
Jermaine.
Jermaine.
Jermaine and Jashay.
Okay. So that you and Mr. Hart are not, you're just living with them?
Yes. Yes. Jermaine has been a homeowner since elementary.
Okay. And how did he come into that money?
His father was in an accident at Coca-Cola.
Okay. So the proceeds of a civil
Settlement. Yes.
Does he need to work?
No.
Does he have a job?
He did have a job. He was working and going to school. He worked at a moving company, I think 2 men in a truck. He worked there, and then Corona happened, and he lost his job. And then he started mobile detailing, driving for one of his friends.
Just driving?
Yes.
Okay. And are you aware of the food truck?
Yes.
Tell us about that.
Jermaine is in the process with my husband and myself and getting a food truck, and we're going into business. We started the business last year, so now we're just working on getting the food truck manufactured. So he is working, and also he coaches and AAU team, our nonprofit organization.
I'll ask you about that in a second. But the food truck has been ordered and
Yes,
being
sir.
produced, right?
Yes, sir.
Okay. How long has Jermaine lived in Central Florida?
All his life.
How long has he owned that home?
Since 2004.
So he was a minor.
Yes.
That was bought with the proceeds of that settlement?
Yes, sir.
What other relatives live in Central Florida, his relatives?
All of them.
Anyone live outside of Central Florida?
A few cousins, and I have aunts and uncles that live outside, but the majority of the family is here in Florida.
Have you ever known Jermaine to be involved in any gang activity?
No.
Has he ever been in any legal trouble?
No.
Have you had any difficulty with him as a parent?
No.
Does he abide by your wishes?
Yes.
If the court were to order that he be on house arrest or wear an ankle monitor and be home by a certain hour, have a curfew or those kinds of restrictions, would you assist him in abiding by those restrictions?
Yes.
Does he listen to you?
Yes.
Even at his age?
Yes.
What is this nonprofit organization you're talking about?
Unity Elite. We've been in a couple of tournaments the past 2 or 3 years, but Jermaine has been coaching the kids and also helping us as far as getting us into the tournaments. And, he has a real bond with all the players, and we're starting a girl league also this year. So
How many different age group levels are involved in this nonprofit?
we have a 10th grade team so far. We're working on a 5th and 6th grade for this upcoming school year, and then a 4th grade girls team.
And he's a volunteer for this?
And he's a coach, yes, sir.
Does he get paid?
No.
You know how many hours a week or a month it takes?
I would say maybe 30 hours a week, maybe, because we at least practice 4 times a week.
Year-round or seasonal?
Year-round. Year-round. We have a few players that play football, but for the majority, the main players are basketball players, so it's year-round.
If the court were to set bond in the amount of $50,000, did he have access to $5,000 in cash to pay the bond premium?
Yes.
I don't have any further questions, Ron.
Thank you, Mr. Stern. Mr. Kozak?
Yeah, maybe remove my mask a bit. Ma'am, first, for our record, can you please spell your first and your last names?
Jenitra, last name Harp.
Thank you, ma'am. And you said that your son Jermaine does not need to work, is that right?
He doesn't have to work, but he works because he doesn't want to use all of the settlement money. He wants to earn a living. So he was working and going to school, and like I said, he was working doing the detailing.
When you said that Jermaine doesn't need to work, is that because he has what you referred to as settlement money?
Yes, and he can start his own business. So he's coming into business with me and run the business.
When you referred to settlement money, was that the settlement money from the lawsuit referencing your son's father?
Yes.
Okay. What was that settlement?
I don't know the amount. Are you asking for amounts or what?
Yes, ma'am. How much money?
Oh, no, I can't disclose that.
Do you know how much?
No.
You were never informed?
Yes, but he'll be taken care of for the rest of his life.
Okay. So what the court needs to know is how much money was in that settlement.
I can't give you a specific dollar amount.
Were you never informed of what the amount was?
Sir, that was,
Without further inquiry, it may be the subject of a non-disclosure agreement, so I'm not sure this is the appropriate way. If it's in a trust, I don't know the details of it. If it's in a trust and there's a monthly or so payout, I don't necessarily think that's inappropriate, but the full amount may be the subject of a non-disclosure agreement.
That's true, but I've got to have some way in which to determine how much money is available to Mr. Ingram.
I don't dispute that, but I think she's hung up on the amount that may have been put in trust, so I'm just saying maybe a different question about how much does he get, if he gets a monthly amount, maybe.
Do you know that it's in trust, Mr. Stern?
I don't.
Okay.
I don't know any of the details.
Okay.
Ma'am, do you know how much money your son received?
No.
Was that amount never communicated to you?
It was, but it's been so long ago.
How long ago was it?
His father passed in December of '97.
All right. And does your son, the defendant in this case, in fact receive a monthly check as part of a settlement?
No.
I'm
Yes,
sorry?
he does get a monthly part, yes.
All right. What does he receive monthly?
Monthly, his check is roughly around $500-600.
$500 or $600 per month?
Yes.
And for how long has your son been receiving $500 to $600 per month?
Since he turned 18.
All right. And for how much longer will your son be receiving $500 to $600 per month?
Probably till he's 85 or 90 years old.
All right. And you've said that he doesn't have to work, meaning your son does not have to work because of this settlement. Do you have any other reasons why your son does not need to work besides the settlement from, I think you said it was Coca-Cola?
No, I would like for him to go to school and get a degree, but if this business goes as planned, he'll be helping me run the business.
All right. The home that you've identified at 1919 Lockshire Loop in Ocoee. And for our record, that's spelled Lochshyre. Is that home owned entirely by your son outright, or is there a mortgage on that home?
No mortgage, owned outright.
All right. And do you know what the current value is of that home in Ocoee?
It should be at least 200, maybe 250.
And when you say 200 or 250, do you mean 200,000 or 250,000?
Yes.
Does correct me if I'm wrong, your son owns that home with your other son, is that right?
With his sister.
Oh, I beg your pardon, with his sister. Okay. Are there any other owners of that home besides your son and his sister?
No.
All right. In order to post a bond for your son, Jermaine, where would you expect to take those funds from?
I have money. I work.
Okay. So would you be relying upon any of the value of the home or his settlement checks or your own?
No, my own income.
Okay. All right. Thank you. So to that extent, then, how much money do you make?
I make roughly 60 to 70,000.
All right. And again, please, ma'am, what's your occupation?
Data entry.
For whom?
CNA.
What is that?
An insurance company.
Okay. Is that locally here?
Yes.
All right. In addition to your yearly income of $60,000 to $70,000, do you expect to use any other sources of income or wealth in order to post a bond for your son, Jermaine?
No.
All right. And your son, Jermaine, was he born here in Central Florida?
Yes.
Have you ever obtained a passport for him?
No.
All right. To your knowledge, does he have a passport?
Not that I'm aware of.
And ma'am, still today, are you residing at 1919 Lockshire Loop?
Yes, I am.
All right. Would your son be able to continue to reside at Lockshire Loop if he posts bond for this case?
Yes.
All right. Do you own any property on Powers Ridge Court in Orlando?
No.
Do you have any family members who live on Powers Ridge Court?
No.
Do you know or have any friends who live on Powers Ridge Court?
No.
To your knowledge, does your son have any friends who live on Powers Ridge Court?
Not that I'm aware of.
Does your son, Jermaine, have any reason to be on Powers Ridge Court?
Outside the scope of the examination, Your Honor, for bond.
All right, sustained.
Judge, that's where the incident actually occurred. I think the court should be apprised as to whether or not the defendant has any reason to be in that area so that the court can appropriately protect people who live on Powers Ridge Court from the defendant should he have no reason to be there. It sounds like he doesn't have any reason to be there. I want to make sure that that's the case.
Thank you, Mr. Rizzo. Okay.
And so, does your son, to your knowledge, have any reason to be on Powers Ridge Court?
Not that I'm aware of.
Okay, I didn't think so. All right. And do you own a car, ma'am?
Yes.
What kind of car?
Dodge.
What kind of Dodge?
Avenger.
What year?
95.
All right. And does your son own a car? Your son,
No.
Jermaine?
No.
Okay.
Not anymore.
Do you or your son, Jermaine, own any other property besides the home located at 1919 Lockshire Loop?
No.
I have no further questions, Your Honor.
Just a follow-up.
Sure.
Ma'am, at the time this happened, is it your understanding that Jermaine was driving someone around as part of, to assist them in their job?
Yes, sir.
That the other person had lost their driver's license?
I'm not sure if they even had one. They just needed a person to help with the mobile detailing business.
And do you understand that person to live across Powers from where this occurred?
I didn't know. No, I didn't.
Thank you. That's it.
Nothing further, Your Honor. Thank you.
Thank you, ma'am. Mr. Snert, any other witnesses?
I don't want to needlessly prolong this, but I would put on his stepdad to establish that the guy he was driving for, his home is directly across the intersection from where this occurred. I don't think it's inappropriate to ban him from driving on the road where this occurred. That's fine. He doesn't need to be over there. But directly across from that, so here's Powers, is the guy with the detailing business for whom he's been driving. So if you want to hear that, I'll put it on. If that explanation suffices, then
You're telling me there's no reason for him to be on the street where the incident occurred?
we don't have any objection to you banning him from being on that street.
Okay.
That's what the state was going to request, Your Honor.
Okay. Right, I didn't see any facts that indicated that he lived on the street, so I was going to order no return to the scene anyway. So we don't need to have that witness. Is there any other witnesses that you'd like to call?
No.
Okay. Anything else from the state?
No, Your Honor, just argument in terms of what would be appropriate for bond.
All right. Anything else, Mr. Snur, before argument?
No other facts, just argument.
Okay.
So, Judge, apparently the defendant is a homeowner, a home in Ocoee that is worth somewhere between $200,000 and $250,000. He also is the beneficiary of a settlement check that provides him somewhere between $500 and $600 per month. In addition to that, according to the testimony from his mother, they wouldn't even necessarily be relying upon any of that source in order to post a bond, or those sources, because his mother also has a yearly salary of somewhere between $60,000 and $70,000. From the state's perspective, it is obviously a very serious case. The court has found probable cause for second-degree felony murder. I don't think that it would be inappropriate for the court to set bond in an amount of $500,000. It seems that that is well within the defendant's reach, and that is something that would certainly be in the defendant's interest to continue to appear for all court appearances as required if he does in fact post bond. The state would also ask that the court order the defendant to have no contact with any of the individuals whose names are contained within the affidavit for his arrest warrant. I know the court has already said that you would order that he not return to Powers Ridge Court in Orlando.
Were you finished, Mr. Roosevelt?
Yes, ma'am. Thank
Okay.
you.
Thank you. Mr. Snur?
Judge, I have a completely different perspective. The rules require the court to examine non-monetary conditions. Bond is not meant to penalize, but simply meant to ensure his appearance. He doesn't have a passport. All his relatives are here. Where's he going? $50,000 is something that I think doesn't impair the dignity of the court and court proceedings. They have the cash available to meet that. They have the equity available to secure the balance of that for the bail bondsman. A $500,000 bail bond would require $50,000 in premium, and there's just no evidence before the court that they can muster that. Even if you were to choose something in between, the reality is that the state's arguing for a high bond. They didn't argue that he's a flight risk. They didn't argue that he has no prior criminal history. He's never failed to appear before. It's just to punish him. You can restrict him to a geographical area. You can put him on house arrest. There are other mechanisms to assure his appearance. So I'm going to argue for $50,000. I think an entirely appropriate bond doesn't impair the dignity of the court and is sufficient, but not greater than, as they sometimes say in federal court, to ensure his appearance.
Judge, unfortunately in Orange County, as the court's well aware, there's no mechanism in order to ensure that the defendant were to abide by a condition of home confinement. That's just not a service that's available in Orange County. I don't disagree with Mr. Snor. I'm not aware of any prior criminal record for the defendant, at least no prior criminal arrest. However, I would point out that Section 907041 of our statutes only has a preference for non-monetary conditions of release when the defendant is charged with what would be a non-dangerous crime. However, when a defendant is charged with a dangerous crime, the conditions for the court to consider are different. And so the state's position is the court does need to make sure that the defendant has enough incentive to continue to appear and make himself available to the court for future court proceedings, and a substantial bond would ensure that the defendant not flee the jurisdiction of the court in the future. Nothing further, Judge.
Okay. So I'm going to start with the non-monetary conditions. Mr. Ingram, you're not to have any contact with any of the witnesses that are named in the affidavit for your arrest. You are not to have, you're not to possess any weapons or firearms. Mr. Snur, you're confident he doesn't have a passport?
That was a testimony. I have no knowledge of one, Your Honor.
Okay, I'm just going to put in there surrender passport if one exists within 24 hours of your release from the jail. You are not to return to the scene. You're going to abide by a 7 a.m. to 7 p.m. curfew.
Did you say 7 p.m. to 7 a.m.?
Yes.
In which case, Your Honor, should the defendant be confined to 1919 Lockshire Loop? That was the address provided.
During the hours of the curfew?
Exactly.
Yes.
I do have one thought when you get to the monetary part, Your Honor.
Sure, no problem. You're also not to have any contact or affiliation with anyone associated with the Army gang or the All Family No Friends gang. Or anyone associated or affiliated with the 438 gang. Mr. Snur, did you have something else you wanted to say about the monetary portion?
If you're inclined to impose $50,000, I don't have anything else to say. But if you're not,
I'm not.
Okay, you're not. Think about this, if you would. Assuming the house has a value of $250,000, and they've got to come up with the principal or the premium for the bonds money. If he fails to appear, he's going to dispossess his entire family from their home. There's no reason for it to be any greater than that. That's all I have to say.
Thank you. All right, and I'm going to set bond in the amount of $250,000. Well, the curfew, yeah, I said it backwards. It should be, he should be at the house at night, so it should be 7 p.m. to 7 a.m. Is there anything else?
No, Your Honor.
Okay, anything to say? All right, thank you.
Thank you for waiting, Judge. I appreciate that.
No problem.
If I'd known Mr. Zork was coming, I would have agreed to wait, Judge. Always a gentleman.
It's good to see you both.
You too, Your Honor. Stay healthy.
You too.
Thank you.
Great seeing you. Thanks for, you were really very generous. You're a good guy.
And then the supplemental collection.
You right on that. I'll just scan it.
All right. Sir, tell me your name, please.
Hector Sierra.
Mr. Sierra, you were here in 20 CF 8709. You were arrested for robbery with a mask and grand theft third degree. This was pursuant to a warrant. I will appoint the public defender to represent you. You're not to return to the scene or have any contact with the victim. You're also not to possess any weapons or firearms.
Yes, ma'am. Yes.
Bond on count 1 is going to be $5,000. Bond on count 2 will be $150.
Okay.
Thank you, sir. Good afternoon, your name?
Taiwan Turner, ma'am.
Mr. Turner, this is 20 CF 1646. You were arrested for failing to appear at your plea hearing on July 9th. At this time, your bond is set at none. You'll need to have your lawyer file a motion in Division 19. Thank you, sir.
Judge, yes, a failure to, out on bond case.
No,
Oh, I'm not taking any action on that case. Thank you.
You're welcome.
Sir, good afternoon. Your name?
Robert Wright.
What is it?
Robert Wright.
How about Mr. U2?
He's mental health, Your Honor.
He's medical?
Mental health.
Mental health.
Mental health. Okay. That case is 20 CF 8229. He was arrested pursuant to a warrant for failing to register as required. Bond is $1,000, and I'll appoint the public defender to represent him.
Next, we have Walker. He refused court.
All right, I'll find a waiver of Mr. Walker's appearance based upon his refusal to come to court. He has 2 cases. I'll appoint the public defender in both. In 20 CF 8788, he was arrested pursuant to a warrant for attempted burglary of an occupied dwelling, written threats to kill or do bodily harm, and aggravated stalking with a credible threat, and criminal mischief. Bond on count 1 is going to be $150. Bond on count 2, $5,000. Bond on count 3, $150. Bond on count 4, $100. He's not to have any contact with the victim. He is not to return to the scene. He's not to possess any weapons or firearms. And in 20 CF 9103, he was arrested for possession of methamphetamine. There's probable cause for that offense, and bond will be $150. All right, and you're Mr. Wright?
Yes, ma'am.
Thank you, sir. You have 2 cases. I will appoint the public defender to represent you in both. You've got 20 CF 3608. You were arrested pursuant to a warrant for failing to register. Your bond is $1,000. Sir, you do have reporting requirements when you're released from the jail. Do you understand?
Yes, ma'am.
All right, sir. And then you also have 20 CF 6364. You were arrested pursuant to a warrant for burglary of a dwelling and grand theft 3rd degree. Bond is $5,000 on count 1. It'll be $150 on count 2. You're not to have any contact with the victim or return to the scene. Thank you. Good afternoon, your name? Mr. Cross, this is 12 CF 3736. You are alleged to have violated your probation, sir. Your bond at this time is set at none. I will appoint the public defender to represent you. And, sir, you have reporting requirements when you are released from the jail. Do you understand?
Yes, ma'am.
All right, thank you. Good afternoon, your name?
Deshaun Jordan Love.
Mr. Love, you're here in 19 CF 12584. It is alleged that you violated your probation in 20 CF 9118 for possession of cannabis greater than 20 grams and possession of drug paraphernalia. There's probable cause for those offenses. I will appoint the public defender to represent you. Bond on count 1 is $1,000. Bond on count 2 is $100. And your bond for the violation of probation will be set at none. You will see Judge Whitehead in the next 7 to 10 days.
Can I have a quick question?
Sure.
In the next 7 to 10 days, will I be, you said I'll be going to court to see a judge for my VOP?
Yes.
Okay.
Okay? Thank you.
You're on the next on the list. Aurora, Medical.
All right. I'll I'm going to appoint the public defender on the out-of-county warrant from Lake County. His bond on count 1 is 2,000. Bond on count 1 is 2,000. Bond on count 2 is 10,000. 3, 1,000. 4, 500. 5, 500. 6, 1,000. And then I'm not taking any action on the pretrial release case or the Orange County case because I don't have any information about the Lake County case to determine whether or not it would be a violation. It just says it's an outstanding warrant, and I don't know what the date in the warrant is. Oh, here we go. Oh, well, it's being corrected. So on the notification, it says he was arrested on July 29th by Coy Police Department for 6 outstanding warrants from Lake County Sheriff's Office. It lists the charges, and the charges occurred on July 23rd. So I'm going to revoke his pretrial release. It's 20 mm 580 AW. It's a battery domestic violence. And revoke those conditions. And bond will be set at none.
There's a no information notice in this case. There's a no info notice.
Oh, there is? Oh, thank you.
You want me to print it out? I don't.
Yeah, so, Ms. Williams, on the case that you gave me this for, the state has filed a no information notice. Okay. So it doesn't exist. So I just don't want it to say no bond in your system when there's no case.
Okay.
Okay? And I can give you,
We didn't have it out on bond form, so I don't
that's
have
probably
it.
why, because it's a no info. Okay, I'll give you this back so you can match up the case number. System. Thank you. All right.
Oscar Capps is also medical, Your Honor.
All right, I'll appoint the public defender to represent Mr. Capps here in Orange County to help him with his case in St. Johns County. His bonds are set at none. Once we hear back from St. Johns County, we'll return Mr. Capps to court. Are you Mr. Maldonado?
Yes, ma'am.
Mr. Maldonado, you are here for an out-of-county warrant out of Polk County related to violation of probation for possession of cocaine. Your bond is set at none, sir. I'll appoint the public defender here in Orange County to assist you with your case. I will reach out to the judge in Polk County to see if they'd like to make any modifications to your bond in the meantime. Once I hear back from Polk County, I will return you to court and let you know what they said.
Awesome. Thank you so much.
All right, sir, thank you.
We did.
Good afternoon, your name?
Roberts Joel.
Mr. Roberts, you were here for an out-of-county warrant out of Seminole County for possession of drug paraphernalia. Your bond, sir, is $405.
Okay.
Are you going to be able to post that bond, Mr. Roberts?
Yes, I should be able to post that bond, no problem.
Okay, so I'm not going to appoint the public defender here to represent you if you're going to be able to post the bond.
Okay.
Okay?
Yep.
Thank you. Are you Mr. Strong?
Yes, Your Honor.
Mr. Strong, you were here for an out-of-county warrant out of Lake County. It's a 4-count warrant. You have a $2,000 bond on each count. And you also have a warrant out of Seminole County, which is a violation of probation. That bond is set at none, sir. I will appoint the public defender here in Orange County to coordinate with Lake and Seminole counties to assist you. Once I hear back from them with respect to what modifications they want to make, if any, I'll bring you back to court.
Okay, Your Honor.
Sir?
I pled out to my Seminole County VOP yesterday and was time served on it.
Okay.
Is there any way that I would be able to get a like a PTR or ROR on this bond? Because I'm not going to be able to post it, and I've been in here for 92 days, and they haven't filed charges yet.
So, you mean on what? Filed charges on what?
On the Lake County.
Okay. So, The warrant was just served today. I don't, the public defender can look at what legal options might be available to you regarding the filing of charges. But what I'll do today is the out-of-county cases that come through today, I will send an email to those jurisdictions informing them that the warrant was served on you. So the Seminole County folks will probably inform me that that case no longer exists. Once that happens, I'll inform corrections here, if that's true, to release the hold. With respect to Lake County, I'll ask them if they'd like to make any modifications to the bond amount. But you also have the public defender here to help you file any motions that you may need.
Okay, how will I be able to contact that public defender, Your Honor?
There should be that sheet right there in front of you. And it has the phone number on it.
Okay. All right.
Okay.
Thank you, Your Honor.
You're welcome, sir. Thank you. All right, I think that's everything. All right, court will be in recess.
Good morning, sir. Please say your name.
Michael Boyer.
Thank you. Counsel, I'll tell Mr. Beaulieu he's charged with trespass in an occupied structure and another count. So 2 cases, 20 mm 1394, 20 mm 1458. Both are charged as trespass. Mr. Beaulieu, let me just open the file so I can see what the difference is between these 2 cases. The first one is from June 10th, supposedly from an address 790 Rolfe Street in Kissimmee. That is punishable by up to a year of jail, a year of probation, and $1,000 in fines. The second case, supposedly from June 18th, and that is from same address. Also punishable by up to a year of jail, a year of probation, $1,000 in fines. How does the defense wish to proceed?
Not guilty, Your Honor.
Mr. Beaulieu, your lawyer is asking us to enter you a not guilty on both, okay? You're going to be set for pretrial on these next court dates. Pretrial September the 24th at 8:30 in courtroom 5B. Now, in 20 mm 1458, the case that is June 18th, the public defender your name doesn't appear on my sheet. Do you want the public defender in that case too? You have the public defender representing you on one case. Do you want them representing you on both?
Yes.
He will be appointed. 1458. All right. Thank you. That's all. Joel Castillo.
Azalea Ramirez Sanchez on behalf of the defense.
19 M.
Next group, Your Honor.
375. Second group. Okay. Andy Cherizard.
Second group, Your Honor.
No problem. Let me just put this sheet over here. Wallace Cone.
Azalea Ramirez Sanchez on behalf of the defense.
Good morning, sir. Please say your name.
Wallace Khan.
Thank you. Mr. Khan, you're here for arraignment. The state filed a charge against you for resisting without violence. Worst case scenario, up to a year of jail, a year of probation, and $1,000 in fines. The public defender's office does represent you. Defense?
Your Honor, Mr. Khan is going to accept the negotiated offer of adjudication of guilt, 45 days in Osceola County Jail with credit time served of 36 and for cost.
Mr. Khan, how do you wish to plead?
Guilty.
Did he get a plea form? Do you know?
There should be plea forms there. Yeah, there should be a blank form in there.
Have you had an opportunity to look over the form yet? If you want, you could go sit down and read it. When you're done, I'll call you back up, okay? Thank you. Gonzalez Cuts, 20 1620.
Second group, Your Honor.
Thank you. Joshua Engel.
Second group, Your Honor.
Okay. Jermaine Ingram.
Morning,
Good morning, sir. Can you please say your name?
Jermaine Antoine Ingram the first.
Thank you. And this is a public defender case. Mr. Ingram, the state filed a charge against you for resisting without violence. Worst case scenario could be up to a year in jail, up to a year of probation, and up to $1,000 in fines. How does the defense wish to proceed?
Azalea Ramirez Sanchez, on behalf of the defense, not guilty.
All right, Mr. Ingram, your lawyer is asking us to plead you not guilty.
Now, man. I ain't say not guilty.
I can't hear you,
I
sir.
said I'm guilty. I do it now.
You want to take the offer?
Yes, ma'am.
What is the offer?
1 second, Your Honor.
All right. State, did you have an offer written down?
Your Honor, I am trying to get it from Rachel Plankito right now. She's trying to get into the lobby, actually. She's not able to join the Microsoft Teams.
All right, let me see if I can send her the link. Is this her case?
No, my attorney name is Benjamin King.
1 second, Mr. Ingram.
One moment, sir, one moment. I'm talking to the state attorney. Give me a second, I'll come right back to you, okay? All right, Ms. Lentz, let her know I just sent her the link.
Okay, I'll send her a text.
Thanks. And it's her case, so you don't know what the offer is, correct?
Yes, Your Honor.
All right. Public defenders are coming back in, or one of the public defenders who went out to talk to who's in the hall. I don't know why she's not coming in. Must be a glitch on her end, because it's the same link I sent you.
Yeah. If you have a case number, I can go ahead and just email her to see what the offer is.
20 1510. Mr. Volker, did you go out and see what they told you in
Yeah,
the hallway?
initially he said not guilty, Your Honor.
But what was the offer? Do you have that written?
We don't
down?
have the offer, no, Your
There
Honor.
wasn't an offer.
There wasn't an offer in this case, Your Honor.
Okay, here she comes. Rachel's coming in. Good morning.
All apologies, ma'am.
No problem. I just wanted to make sure that you guys had the link. It's different than the one we use on Monday, Wednesdays, and Fridays. So what we have is Jermaine Ingram, 20 1510, and he would like to know what the offer is. The public defenders believed at first he was going to plead not guilty, but he's at the jail and he's wanting to resolve this today. And that would be 20 1510.
Yes, ma'am. Well, I have my sheet right this moment.
No problem. It's a charge of resisting. That's all right. Technology is what it is. We deal with it the best that we can. We're getting there, sir. We're getting there.
No problem, man.
Couple
Take
more
your time.
minutes.
Take your time.
Oh, okay.
grab it.
Sure.
I'm having trouble finding it.
That's fine. Mr. Ingram, if you wouldn't mind, please have a seat. I'll call you back up in just a couple of minutes. All right, Cortel Jones?
Azalea Ramirez Sanchez on behalf of the defense.
Good morning, sir. Please say your name for me.
Cortel Jones.
Thank you. Mr. Jones, you have 3 cases on the docket this morning. 2020 CT 1620 is charged as leaving the scene of an accident. That's a criminal charge. It's punishable by up to 60 days in jail, 6 months probation, and $500 in fines. That was supposedly from June 11th. You also have 2 non-criminal tickets, a careless driving and an improper lane change. How does the defense wish to plead?
Your Honor, we're not appointed in this case. Can we ask if he wants us
Sorry, I
appointed?
thought you said.
I thought so, my
That's
mistake.
okay. Hold on real quick. Does the state have an offer?
Yes, Your Honor. Due to the defendant's criminal history, including this being his second leaving the scene of an accident, the state's offer is an adjudication of guilt, 5 days in the Osceola County Jail, followed by 6 months probation or whatever the calculation runs out to be in days. The aggressive driver's course, drug evaluation and treatment is based on his recent history and his pending cases, as well as reserving restitution and any court costs. I want to make Your Honor known he has a warrant out in Orange County for violation of community control. That's 19 CF 7582 in Orange.
Thank
He
you.
also has a pending Osceola County case of 20 CF 1670.
Excuse me, Your Honor.
Yes.
We're having problems here in the state.
Yeah, I'm gonna repeat it. Unfortunately, the way it is the computer. Oh, you know what? Maybe I can do this. I think I did this last time. For future reference, we'll do this. If the courts will let me do it. It's just a little bit harder. All right. Ms. Computer, can you put your appearance on the record, please?
Yes, ma'am. It's Rachel Kleinpeter on behalf of the state of Florida.
Thank you. Did that help?
Yes, ma'am.
Fantastic. So let me repeat it for purposes of this case, but from here on out, the state's connected to the microphone. So, Mr. Cohn, the offer from the state, I'm sorry, not Mr. Oh, I moved this. Mr. Jones, the offer from the state for the leaving the scene is 5 days in jail, followed by 6 months of probation, an aggressive driving class, a drug evaluation, order and reserve as to restitution, and court costs. If you have that open Osceola case that is related to this, that might affect you. If you have that open Orange County case that is related to this, this might affect you. So I want to make sure you understand that before you decide if you want to say guilty or not guilty. So what do you think?
Not guilty.
I can't hear you.
Not guilty.
All right. Mr. Jones, do you need a public defender to represent you?
Yeah.
Say again?
Yeah.
Is that a yes?
Yes.
Okay, I'm sorry. The mic is really low, and I don't know why. Maybe we could call IT and tell them that even with people talking without their masks on, they're very hard to hear. We're going to enter you a plea of not guilty in these cases and set you for pretrial.
Can you tell me about my warrant? They were supposed to ROR me on the warrant.
I have no idea about your warrant. I show that you were in custody in Orange. I don't know if it was the same case the state attorney just said, but I don't have a warrant. I don't see a warrant for you in the Osceola system, and I don't show that anything's flashing in Orange. So maybe they took care of that warrant already with your arrest. When were you arrested recently?
I was arrested June 11th.
June 11th?
Yeah, I've been sitting here the whole time.
All right, let me ask the state attorney, the warrant that you saw out of Orange, does it show something from June 11th to now?
When I looked at it yesterday, it had warrant process still active on it.
Okay, I'm gonna let your lawyer look into that. I don't show it, I don't see it, but I don't have all of Orange County stuff, so they can look into that. Do you need a public defender to represent you?
Yes.
PD appointed, next court date will be? September 29th, but that might change. Your lawyer will let you know. Now that I gave you a public defender in this case, they'll be in touch with you and they'll be able to look at Orange County and figure it all out, okay?
All right, so
They'll call you.
Can I get a bond here?
You're not in custody on my case, so you're not picking up credit on my case. On the case that I have for you, you're not in custody, so there's no bond for me to give you because you're not considered in custody.
All right,
All right, thank you, sir. Ms. Computer, did we find Mr. Ingram?
I'm looking at it now. I thought it was a DV case, but it got kicked from DV. So I'm gonna have an offer form today, right now.
No problem.
As soon as I look at his history.
That's fine. Jean Ocasio, Giancarlo Ocasio,
Azalea Romero Sanchez on behalf of the defense.
19 CT 1813, 19 CT 1814. Good morning. Please say your name.
Jean Ocasio.
Thank you. That's definitely a better volume. All right, Mr. Ocasio, looks like you're here for arraignment on a violation of probation. Lisa, we need to probably take that note out. It says CTS plea on the top. You see it by VOP arraignment? Okay, well, I don't see where that came from. He hasn't ever been arraigned. I don't think so. I mean, I'll take a plea if that's what they want to do. If that's what the offer is, no problem, but I don't know why that was put right there. Mr. Ocasio, the violation of probation indicates that you didn't get your license and you failed to report in November. On the one case, you didn't do your aggressive driving class or your community service hours and failed to report in November. So that's why you were violated in these cases. You already have a public defender appointed to represent you. Let me ask the defense how they wish to proceed.
Your Honor, in 19 CT 1813, the client is going to accept a negotiated offer as to admit adjudication of guilt, credit time served, and court cost. As to 19 CT 1814, he's going to also accept a negotiated offer to admit adjudication of guilt, credit time served, and court cost.
All right, let me take a look and see what his driving record would tell me, and I'll let you know if I would accept that plea. These are from this date. All right. Yes, Mr. Ocasio, if you'd like to plead guilty and resolve the case the way your lawyer said, I will accept your plea. How would you like to proceed?
I plead guilty.
All right. Did you read the plea form already?
Yes.
You sure? Because I can give you time to read it now if you need to read it.
What it is, this?
Yes.
Okay, yes.
Is that the one that says plea or does it say admission?
Plea.
Yeah, I need you to have the one that says admission. Let me ask the COs if they have that paper there. The violation of probation plea form. It's a different plea form. There you go. So, Mr. Ocasio, put the other one down back where you found it and take the one he just gave you to read, and I'll call you back up in a minute, okay?
Okay.
Thank you.
Your Honor, I am ready with an offer.
All right, Mr. Ingram, Jermaine Ingram. Back to 20 MM 1510. Okay, state, what is the offer?
Your Honor, based on criminal history, I would offer an adjudication of guilt and a credit time served.
Yes, ma'am, let's do that.
Mr. Ingram, you want to take that offer? Yes, sir? You want to take it?
Yes, ma'am. That's
All right.
perfect.
Do you need any more time to talk to the public defender on the phone before we finish this?
About the other case, yes, ma'am. But this
No,
case,
about
we good.
this case. Only
ma'am.
about this case.
No, ma'am. How much I owe, court costs and all that stuff? We good.
I'll tell you in a minute. I need you to read the plea form. So grab that form right there, go have a seat and read it, and I'll call you back up.
I read it 30 times already, ma'am. I was praying about this. I'm ready.
All right. Please go ahead and put the paper down. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand. Say your name.
Jermaine Antoine Ingram, the first.
Mr. Ingram, the plea form that's on the bench there in front of you, you said you've read it several times. Is that correct?
Yes, ma'am.
Do you understand the rights that are in that form?
Yes, ma'am.
Do you have any questions about any of those rights?
Yes, ma'am.
What are your questions?
By me pleading guilty, right?
Yeah.
They can't bring the other charge back up.
I have no idea what the other charge is.
That's fine, ma'am. Yes, ma'am. I'm good.
Do you want more time to figure that out?
No, ma'am. I want
All
no
right.
more time.
Do you have any other questions about the rights that are in the form?
No, ma'am.
Do you understand that those rights are rights that you're giving up by entering into this plea today?
Yes, ma'am.
You're giving up the right to have a trial by jury. Do you understand?
Yes, ma'am. The camera showed me. I'm guilty.
All right. You have the right. You have the right to make the state prove the charges against you. Do you understand?
Yes, ma'am.
You have the right to know what the evidence is against you and what witnesses will be called. Do you understand?
I'm all right, ma'am. I plead guilty. I'm good.
I understand. I have to go through this with you.
Okay.
All right. I have to ask you these questions. All right. You have the right to remain silent or the right to testify. Do you understand that?
Yes, ma'am.
You have the right to call your own witnesses if you want to and challenge any of the evidence that the state has. Do you understand that?
Yes, ma'am.
You have the right to have your attorney make certain motions for you and have the court consider those motions before we proceed to trial. Do you understand?
Yes, ma'am.
Are you willing today to waive those rights and to enter this plea to resolve this case?
No, ma'am. We're going guilty. We're going all the way.
That's what I'm asking. You give up those rights by choosing to plead guilty. Do you understand?
Yes, ma'am.
And do you understand that your lawyer might be advising you to not take the offer, but it's your decision that matters? Do you understand that?
Yes, ma'am.
And is this the decision that you came to freely and voluntarily?
Yes, ma'am.
Are you acting under the influences of any types of medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand?
Yes, ma'am.
On June 25th, 2020, in Osceola County, Florida, did you not do what the officer had the right to tell you to do or to stop doing? Did you not follow his order?
Yes, ma'am.
So I find that you are alert, that you're intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. Anything further from the state?
I just want to make Your Honor and defense aware, he does have a second case pending right now that was seen in IAs. That's 20 CF 2124 aggravated battery, violation domestic violence conditions, aggravated battery with deadly weapon. That bond is set at $1,000 on each count. So he still has to make bond on that to be released.
Understood. Thank you.
Yes.
Anything further from the defense?
No, Your Honor.
Yes, sir. What would you like to say?
Miss, I have 3 busted eye vessels, so if it's a way that you can get me back to the hospital, I bonded out just to go to the hospital.
Okay.
It's an altercation that happened in this jail, and I had to bond out and go to the hospital.
All right. If you bonded on that felony case, once you resolve this this resisting today, then you should be good to go.
Yes, ma'am. I plead guilty. I just gotta go back to
I
the
understand.
hospital, ma'am.
So at this time, I find that you are alert and intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Pursuant to the offer, it'll be an adjudication of guilt, 34 days with credit for 34 days, $273 in court costs, and $100 public defender lien payable within 180 days of release from jail. You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Thank you, sir. Good luck.
Yes, ma'am. You have a nice day.
Louis Paul Burial.
Azalea Romero Sanchez on behalf of the defense.
Good morning.
Good morning.
Please say your name.
Louis Paul Burial.
Thank you. Mr. Pohl, you're here for arraignment. The charge is violation of probation. The probation officer said you failed to report September and October. You didn't do your hours. You didn't make your payments. How does the defense wish to proceed?
Your Honor, the client is going to accept a negotiated offer of admit, adjudication of guilt, credit time served, and court cost.
All right, let me take a look at the file. All right, Mr. Pohl, you were put on probation back in December. You had a withhold of adjudication and you were ordered to do a year of probation. You had credit for 1 day at that time. Actually, this was in 2018 originally. So from December 2018 to the violation in October of 2019, you did nothing. But I'm assuming because of the withhold, there were no priors. It doesn't say whether he was pleading to count 1 or count 2. How many counts were there at the end? How many were filed on? One, so it's a paraphernalia. Okay. All right, Mr. Pohl, do you wish to go ahead and take the state's offer?
Yes, ma'am.
Did you already read the plea form?
Yes, ma'am.
All right, please raise your right hand. Do you swear to tell the truth, so help you God?
Yes, ma'am.
Thank you. Please lower your hand. Sir, you told me that you read the admission form in this for this type of charge. Is that correct?
Yes, ma'am.
Did you have as much time as you needed to review it?
Yes.
Did you have as much time as you needed to talk to the public defender?
Yes, ma'am.
Do you understand the rights that you're giving up by pleading today?
Yes, ma'am.
Do you have any questions?
I will be released today, right?
As to this charge, yes.
Yes, ma'am.
Do you have any need to talk to the public defender again before we finish this?
No, ma'am.
Do you feel like anybody forced you to make the decision you made?
No, ma'am.
Are you acting under the influences of any medications, drugs, or alcohol?
Nope.
If you are not a U.S. citizen, entering a plea would be used as a reason to deport you. Do you understand that?
Yes, ma'am.
Are you willing to waive your rights and enter this plea to resolve your charge? How do you plead?
Not guilty.
Guilty, you said?
Yes.
All right. Do you admit that you did not comply with the probation requirements the way you were supposed to?
Yes, ma'am.
If you would have tried harder, could you have done it?
Yes.
So I find that you are alert, that you're intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. Pursuant to the negotiations, it'll be an adjudication of guilt, revoke and term probation, 10 days in the county jail with credit for 10 days. The balance of your court costs is $540.50. That's from before. That's not any new charge.
Okay.
But you do owe probation $225. So I'm going to put that into your balance.
Okay.
Send that to the clerk for collection. You're going to have 30 days from the day you're released to contact the clerk's office to set up a payment plan.
Okay, ma'am.
If not, your license is going to get suspended. You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Good luck, sir.
Thank you, ma'am.
All right. And corrections, he'll need to be printed.
Yes, ma'am.
Ramondo Roya.
Azelia Ramirez Sanchez on behalf of the defense.
He's in Orange County Jail, Your Honor.
For the record, Mr. Proya is not in our custody. He's in Orange County. Does the public defender know what he's in Orange for?
No, Your Honor.
All right. Why don't we reset him? And my understanding is they are doing transfers. So we'll reset him for the 20th. And I'll ask the state to do a transport order, please. Elliot Rivera.
Your Honor, we'd like to waive the reading of the charges of the violation of probation.
Okay. MM30. Good morning, sir. Please say your name for me.
Elliot Rivera.
Thank you. Mr. Rivera, you're here for arraignment. The charge is violation of probation. The probation officer alleged that you didn't report like you were supposed to. You didn't do your drug tests. You fell behind on your court costs. However, they also have alleged a new felony charge. So it's 20 CF 1984. And that's the biggest issue for the violation. So if you decided to plead guilty to the violation, that could also be used against you in the new felony charge. You have the public defender representing you already. They're on this side of the camera with me. How does the defense wish to proceed?
Your Honor, looking at benchmark, we don't see that we're represented. Can we double check that?
Let me double check because my docket sheet says yes. Let me just double check and see what happened. He had an on-view violation and the day that he was arraigned on the new felony, Judge Epperson saw the on-view for violation. He did appoint the public defender for the felony, and I would say that that should have also counted as pointing the public defender on the VOP. Although it doesn't specifically say that, it is on that sheet. And then probation filed a couple days later the actual affidavit. So the public defender's office is appointed based on the IA July 15th. And how does the defense wish to plead?
Denial, Your Honor.
All right, Mr. Rivera, we're gonna enter you a denial to the violation, which is like saying not guilty, and then the public defenders will talk to you about everything altogether, okay?
All right.
Next court date will be? Oh, okay. Give me a second to get to the, you know what? I'm gonna put it in a pile and I will give you, we will send you the court date and your lawyer will know and tell you the next court date, okay? I just have to give you a calendar date. I just don't have them ready yet. All right, thank you. Need VOP staff. As pending. Felony. What I'll do is I'll look towards the dates that the felony has set and try to go somewhere around there because I know they're gonna be intertwined there for a little bit.
Yes, Your Honor.
Okay. Dexter Roberson.
Azalea Ramirez Sanchez on behalf of the defense.
And Ms. Castro, is this your case?
Yes, Judge. Good morning.
Good morning.
Good morning.
Hi there. Can you tell me your name, please?
Dexter Roberson.
Thank you. Mr. Roberson, you are here for arraignment. The charge is violation of an injunction. That is a charge punishable by up to a year in jail, a year of probation, and $1,000 in fines. You are represented by the public defender's office.
Yes, ma'am.
How does the defense wish to plead?
Your Honor, does the state have an offer in this case?
Ms.
I
Castro,
want to
the
resolve.
defense-
I want to resolve this today because I got 28 months.
Mr. Robertson, we understand. I just need to get
understand.
offer.
I'm gonna ask the state attorney what her offer is, and then you can tell me what you want to do with it. Okay?
ma'am.
State,
Judge, the state does not have an offer at this time. Victim input is still required, and we didn't have the opportunity to reach out to them before the court date today.
have you been in contact with the listed victim?
Yes.
Okay.
We just weren't able to get in contact with them to discuss sentencing options, but we do have good contact with them.
Okay, understood. So, the only option that I have based on the law that requires that the victim be notified that he may be entering into a plea is he can set it for a plea date certain, or he can plead today and we can set off sentencing so that I can give the victim an opportunity to appear or to give input.
Your Honor, we'll do a not guilty for right now.
Mr. Roberson, your lawyer wants me to go ahead and enter a not guilty at this time because of the options that are available to plead guilty. I would not be able to sentence you today anyway, so she wants to get more time to talk to you about this case.
But I'm waiting to go to DOC prison.
I understand. If you plead today, I can't sentence you. The law requires that I give the victim an opportunity to know, and I can't sentence you today. But your lawyer can talk to the state, and if you all are on the same page, I can bring you back and plea you then. But right now, I have to give the victim that opportunity. So we'll enter by the public defender's request a not guilty and set for pretrial. And I have a pretrial date, yes? Yeah, 9/8 is fine.
Pretrial September the 8th at 8:15 in courtroom 4A.
Thank you. Jose Salinas Calderon, 2020 CT 1755.
Azalea Ramirez Sanchez on behalf of the defense.
He needs an interpreter. Mr. Calderon, Mr. Salinas Calderon, do you speak English?
Yes, I do, but I would like to have an interpreter so I can fully understand what you're saying.
You don't understand me?
A little bit.
Okay, let me try, and then if you don't understand me, I'll call the interpreter, because your English sounds pretty good.
All right.
All right? Yeah. So let me just grab your driving record. If you end up you don't understand, I'll call the interpreter.
Okay.
All right, so you are charged in this case with DUI. Okay, driving under the influence. State, are there blows? I think so because he's got a suspension for unlawful BAL.
Oh, I apologize, Your Honor. Yes, there is a blow. He did blow over the legal limit.
How much? What, I mean, was it above 0.15?
No, Your Honor, it was not. It was above 0.1. It was 0.13, I believe.
That's fine. So, Mr. Salinas, a DUI in Florida is punishable by up to 6 months in jail the first time somebody gets convicted, up to a year of probation, up to $1,000 in fines, up to a year of losing your license, DUI school, victims class, community service hours, and an impound of your car. There's a lot of detail involved in a DUI. Did you understand that?
Yeah.
Okay. Defense?
Your Honor, the client's going to accept the negotiated offer of adjudication of guilt, 12 months supervised probation with credit time served of 13 days, 6 months driver's license suspension, $500 fine, 50 hours of community service, 10-day vehicle impoundment, victims awareness panel, DUI level 1, reserve restitution, $150 of cost of investigation to the Osceola County Sheriff, and court cost.
Mr. Salinas, your lawyer's telling me you want to go ahead and take the probation offer that they talked to you about. Is that correct?
I think about it, and that's the only offer that I have right now.
Yes, that's the offer from the state attorney. But you can say not guilty. You don't have to take that if you don't want to take that.
Yeah, I do not want to take it.
All right,
I need
so-
more time to talk to my lawyer.
All right, no problem. I'll enter you a plea of not guilty, and we'll set you for pretrial, okay?
Okay.
All right, your next pretrial will be September the 8th
Okay.
at 8:15 and 4A. Thank you.
All right, thank you.
Christopher Sullivan,
This next group, Your Honor.
thank you. Robert Velez, good morning, sir. Please say your name.
Robert Velez.
Thank you. Mr. Velez, you're here for arraignment. The charge is resisting without violence. That's punishable by up to a year in jail, a year of probation, and $1,000 in fines. And you are represented by the Public Defender's Office. How does the defense wish to plead?
Not guilty, Your Honor.
All right, Mr. Velez, the public defender wants me to enter you a plea of not guilty, okay? We're going to set you for pretrial September the 8th at 8:15 in courtroom 4A. Thank you. Javier Villarroel,
Baker County Jail, Your Honor.
he's still in Baker?
Yes, ma'am.
All right. 19 mm 2730, 20 mm 1071. Do we know why he's in Baker County?
Your Honor, he has, we believe, talking to the family, it could be an immigration hold, and I see some charges down there too.
Okay.
I heard immigration hold, Your Honor. What was the last part?
Immigration hold
Okay.
and local charges.
Local charges. I missed the local charges part.
That's fine. He's been in Baker for a while. And I don't know if, we've done transport orders. But
Your Honor had
they-
mentioned doing a full.
Excuse
Your
me?
Honor had mentioned doing a full habeas last time.
Oh, a habeas. Is this the one? The writ of habeas?
Yes, Your
Okay.
Honor.
That's what they're the ones who said that they would bring them only if we did a writ of habeas. And for two petty thefts. What's the state's position on that?
I would have to ask it what my boss wanted to do if we wanted to go forward, given the ice hold. And I can reach out to the Baker ASA and find out what their plans with him are.
Okay, so why don't we reset it for next week's jail arraignments and give the state an opportunity to get that information, and then you can convey that to the state attorney who's going to be appearing next Thursday.
I will.
And then if your office does want me to do a writ of habeas, let me know, and I'll enter it and set it for when we have court again.
Okay. Do you know which PD is assigned to him, Your Honor, so I can CC the PD?
No PDs. He doesn't
No
have a
PD.
lawyer because he bonded out in our cases, never asked for a lawyer, and then got in trouble in Baker County.
Okay.
Thank you. So we'll reset to next week for, let's call it a status for the state to decide if they want to move forward and seek the court to issue a writ of habeas corpus. That way there's a note and they know what's going on.
And we roundtable today with Chris and Crystal, so I'll be able to get an answer today.
Excellent. Thank you. Alicia Willis.
Next group, Your Honor.
Thank you. Brandon Rentis.
Bonded 5/2020.
Okay. It says status on my document.
He may be outside, Your Honor.
He's outside?
I don't know if he is. He may be.
Oh, well, he's not allowed to come into the courthouse. That's the problem. I was under the impression that he was in custody. Let me take a look. What my notes say. June 22nd came for status, and the only violation was the new charges in orange, which have now been filed.
Yes, Your Honor.
No offers were made. All right, I'll skip it. I'll let you maybe, oh, you guys don't represent him, do you? 'Cause it doesn't say that on.
It doesn't say it on the sheet, but I'm appointed to him, Your Honor.
All right, let me take a look and see what the file says. Defendant is filling out an affidavit of insolvency, public defender provisionally appointed, court date forthcoming. All right, so let's leave the PD on there. And who did we skip? Did we do Ocasio? Oh, Mr. Ocasio was reading the admission form. Are you done or do you need more time, sir? You can have more time if you need it.
I already read it.
You read it? Okay. You could go ahead and put it there on the table. Raise your right hand. Do you swear to tell the truth, so help you God?
Yes.
Thank you. Please lower your hand and say your name.
Gino Casio.
So this is Gina Ocasio Morales, 19 CT 1813, 19 CT 1814. Mr. Ocasio, did you have enough time to read the plea form?
Yes, I read. I understand most.
Okay. Did you read everything?
Everything.
Okay. And do you have any questions?
No, I don't got no question. I understand most.
Okay. Most of it or all of it?
All of it.
All of it. Okay. Do you have anything in there that you want me to explain to you?
It's okay. I understand it.
All right. Do you feel like anybody obligated you to make the decision you're making today?
No.
You feel obligated or forced?
No.
Are you threatened? Anybody threaten you?
No.
Okay. Do you take any medication?
No, señora.
Are you under the influence of drugs or alcohol?
No.
If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand that?
Sí, señora.
And you have the right to have a lawyer. If you can't afford to hire a lawyer, I'll appoint one for you if you qualify. Do you understand?
Sí, señora.
All right. By pleading today, these charges will get resolved right now, and all the rights that are in that form are waived. They're gone. Do you understand that?
Sí, señora.
Do you admit, Mr. Ocasio, do you admit that you did not follow your probation the way that you were supposed to?
Sí, señora.
And do you think that if you would have put more effort, that you would have tried harder, you could have done these things? Did you have the ability to do it, but you just didn't do it?
Yes, sí, señora.
Okay. So I find that you are alert, that you're intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Anything further from the public defenders?
No, Your Honor.
19 CT 1813 will be an adjudication of guilt, revoke and term, credit time served. 273 is the remaining court costs, and there was, I guess, a public defender fee in here. It says 316 on the court docket. And then, no, it's 273, I'm sorry. 19 CT 1813 is 273. In case number 19 CT 1814, it's also an adjudication of guilt, revoke and term, credit time served, and 316. There's a $150 back cost of supervision. All of that will go into one account. Within 30 days of your release, Mr. Ocasio, you have to contact the clerk of court, the clerk here at the courthouse, and set up a payment plan.
So I released today?
Yes. You have 30 days to appeal. All appeals must be in writing. If you cannot afford a lawyer, I'll appoint one if you qualify. You're released on these two cases. Do you have anything else?
No,
Any other cases?
No, señora.
Then you should be released today. Good luck.
Thank you.
You're welcome. Mr. Cohn? 2020 MM1152. All right, sir, did you have enough time to finish reading the form?
Yes, ma'am.
Great. Can you please raise your right hand for me? Do you swear to tell the truth, so help you God?
Yes, ma'am.
Thank you. Lower your hand. Say your name again.
My name is Wallace Khan.
Mr. Khan, did you read the plea form that you were given to go over?
Yes, ma'am.
Did you go over everything front and back?
Yes, ma'am.
Do you understand the rights that are in the paperwork?
Yes, ma'am.
Do you have any questions for me?
Yeah, see, I was arrested on this charge on May 18th, and they only gave me 36 days. It's supposed to be really 37 days.
Yeah, I have 36, but whatever it is, it's, well, let me double check. The clerk told me 36.
Because I was been here since the 25th of June. And
Okay,
then
let me look. I'll look it up for you.
Thank you.
You're welcome. Yes, it's been calculated since June 25th. And you got credit for the day you were originally arrested and then released. So that was May 6th. And then June 25th.
No, they don't do group yet.
It should be 37.
Thank you.
You're welcome. What's fair is fair.
Yes, ma'am.
Any other questions?
No, ma'am.
All right. Do you need any more time to speak with your lawyer?
No, ma'am.
Do you feel like anybody forced you to make the decision that you made today?
No, ma'am.
Are you acting under the influences of any medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand that?
Yes, ma'am.
Are you willing today to waive your rights and to enter this plea to resolve your charge?
Yes, ma'am.
Okay, you can put your hand down, thank you. On May 6, 2020, in Osceola County, Florida, did you not listen to a lawful command given to you by law enforcement?
Yes, ma'am.
I find that you are alert, that you're intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Pursuant to the offer, it'll be an adjudication of guilt, 45 days with credit for 37, $273 in court costs, and $100 public defender lien. Within 30 days of your release from jail, contact the Osceola Clerk's Office and set up a payment plan.
Yes, ma'am.
You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. Thank you, sir.
Thank you.
And Your Honor, Garrett Litz on behalf of the state. It looks like he does have an open warrant out for his arrest in Orange County as well, just putting defense on notice on that.
Thank you. Good luck, sir.
Excuse me.
Yes,
I
sir.
don't have no open cases in Orange County.
I'll ask the public defender if they were able to find anything. They represented you in our case. The state attorney says he saw it in the system. I don't have Orange County on my computer.
That's another con. That's Darius Con. That's not Wallace Con.
Oh, he said that's Darius Con, not Wallace Con. All right, thank you, sir.
All right.
Okay, Your Honor, we're getting the other people up. We'll be up as soon as possible.
Sounds good, no worries.
Thank you.
I will say, Your Honor, that it does say Wallace Con in the system, but I'm sure that's going to get figured out.
Okay. We are one day away from the end of July.
Hey, it looks like we're gonna go out with a bang.
Craziness.
With the hurricane, is that what you're saying?
Right. Yeah.
Sunday night, yeah.
Wow.
It may skirt the coast, you know, may get lucky.
Well, I heard this morning that it's now anticipated to go to the east of us, where before they were predicting to the west of us into the Gulf. So, you know what that normally means? Direct impact. Because at first it was going west, now they say it's going east, which means it's probably gonna go right in the middle.
Right.
And they always come in the middle of the night. Have you noticed that? These storms always roll over us in the middle of the night.
Mm.
Port deputy says it's still predicted to be a tropical storm. Yeah, but
Have they
with all the
given the
water
storm a
we've
name?
had, excuse me?
Have they named the storm yet?
Oh, yes.
Okay.
Isaias?
Isaias, okay. Got
With
it.
all the water we've had though lately, that's gonna be bad. But Steve just looked up the most recent weather prediction, and the cone is right over Florida.
Oh, great.
Right up the middle.
Yeah.
So I have Fox 35 on and on my TV in the background. So if it comes up fast, I'll tell you what it is.
All right.
Before we start the second batch.
No problem.
8 a.m. advisory from the National Hurricane Center.
Great. So far, they were saying Sunday.
Judge,
Yes?
when Alicia Willis calls up, the state has an announcement to make.
Okay.
I'm trying to listen to you and.
Lisa, here are these notices to appear for violations of probation. I looked on benchmark and I gave you the dates that are. I'm gonna process them now. And they're all signed. I told them. So, right, and so there's plenty of spaces if you fill in the blocks of where these times are, and that way. Nobody will. Before we leave court. Yeah, cause, and it's 8:28. They're not setting that. Well, that's why. I saw that one and I put all the other ones on that time slot. Because I checked it to make sure it was still okay. Hmm? Oh, okay. That's fine.
Alright, and then we were at 2020, it was just when we had C. Sullivan, and we definitely had 120. So always from, so let's go back to page 3, were we on page 3? Okay, a couple ones here. what do you mean? We're good with them all?
We talked to them.
Yeah, yeah. Okay.
We're good.
No, meaning,
We don't know anybody else to talk to.
we've already talked to them all? On 6?
Yeah, or they're not there. Yeah.
Okay.
That patient concern is 20. No, we need to talk to 20.
Just tell me, you've already talked to 19 and 21?
We've already talked to 19.
And 21?
We've already talked to 21. 22 is not here, 23 is not here. 24, we have not talked to. We have not talked to.
That one, there's
But it's
no
IC,
announcement.
but, yeah,
There's
ICP.
no- there's-
Yeah, okay, okay. And then 25? And this is a plea date, these are, sorry. I think I
It's okay,
marked.
it's
You got
black,
that.
it's not gonna see it.
Okay. I don't know who that was, I grabbed theirs, so thank you.
Wait, where's yours?
I think I gave it over here. No, I just didn't know if you talked to me. I thought.
I just didn't know if you were. I was just asking because I just didn't, because you said everybody can take, I don't know who's there, so.
Oh, yeah, anyone that came up to the podium.
But I don't know who that is. It's not, I was wondering.
Which one?
No.
Oh, which one? What about him? What did he say? Yeah, he was in there. You know this, right? He wanted to take his whole thing. I'm like, he's like, I remember when he was saying, so I get out of jail. You know. Yeah. He's like, all right. Like, thanks, Jim. See, because when you're talking, I'm like, I started talking to the guy, and he said, well, this is the minimum mandatory. Yeah, yeah, for the DUIs. He asked me to tell him, I'm like, this is what you're going to get no matter what, because it's DUIs anyway. Because we went over that, he was like, oh, he said, no. You know how it goes.
We didn't have an offer for him.
Which one? You guys were back at that?
The one that's violation, that's this injunction. You remember talking to me?
What about him?
I don't know. We're not involved.
I forget which one.
Yeah.
He's good now?
I said not
Okay.
guilty.
Okay.
And I was ready.
Yeah, yeah. Yeah, you did that?
Yeah.
Because he talked to me about it.
Oh, thanks for letting me know after I did it.
Well, no, what do you call it? He started talking on the phone on that. But reading themselves, it shouldn't be done unless it's part of the new law. Oh, it was part of the new law?
Yeah.
Okay. Because I said to him, I said, hey, this, they're just talking about the DPP.
Yeah.
But it was part of the law? Because that would have said out loud.
Yes.
Okay. You good with the rest then?
Yeah.
We have a case set at 2 for a competency issue. And I was wondering if the state and the defense are still going forward with this evidentiary hearing, 19 MS 3164.
Your Honor, Azalea Romero Sanchez, on behalf of the defense, I spoke with the state, and he's willing to stipulate to the competency evaluation.
Is that something that we can address right now instead of at 2? That way you guys don't have
Yes,
to
Your
come back?
Yes, please.
All right,
Yeah.
so for the record, 19 MM 3164, State of Florida versus Michelle Sanfillo Savinon. Appearances from the state
Gary Lentz on behalf of the state.
and for the public defenders.
Azalea Romero Sanchez, on behalf of the defense.
Thank you. And so let me start by asking the public defenders, have you been in decent contact with your client?
Constantly, Your Honor.
Excellent. And we are set today at 2 p.m. for a hearing with regard to the court making a finding. The state had previously objected and wanted the court to consider more evidence. And so the positions have changed, correct?
Correct, Your Honor.
And what is the state's position now with regard to this defendant's motion to find the defendant incompetent to proceed?
Your Honor, the state would stipulate to the defendant being incompetent at this time, however, would ask the court to pursue restorative services and redress the matter 6 months' time.
Okay. Defense, do you know if your client is actively participating in any kind of counseling or treatment?
Your Honor, I believe so. She is in heavy amount of medication, and I believe the last time I spoke with her, which was in the hearing, she was talking about having an appointment with some kind of counseling.
So, let me look back into the file. I was just typing some notes. Hello, everybody.
Yes, ma'am, we have the second group.
Okay, so let's put Ms. Samfiel on pause for a second.
Yes, Your Honor.
And then we'll come back as soon as we've finished everybody in jail. But we will address it prior to 2 p.m., which will help us not have to reconvene.
Right.
Great. So, good morning, everybody. I'm Judge Savage. You all are here for arraignment. When I call your name, I need you to come up to the microphone on the side by the wall, and I will tell you what the charges are that the state attorney's office has filed against you. I will also tell you what the penalties for that kind of charge are, up to what the maximums are as filed. Once I tell you that information, I'm going to ask you or your lawyer how you want to proceed. Your options are to plead either guilty or not guilty. It's completely up to you. If you plead guilty and you want to resolve it today by accepting the offer that was made by the state, you can do that. If you want to plead not guilty, that's fine too. Once I know what your choice is, then I know where we're going next from here. We are being recorded. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, and if you cannot afford to hire a lawyer, I will appoint one if you qualify. The case that we have on the schedule for today is the only case that we're able to address today. Keep in mind that if you have other cases, especially open felonies or violations of probation, what you do in here today could also affect you in those other cases. If you're not sure how that works or how they connect, you might want to consider saying not guilty so that you could talk to your attorney and figure it out first. So let me give you the example that makes the most sense to everybody. Let's say you're in here today for a driving on a suspended license, and the offer from the state is credit time served, and you're thinking, hey, yeah, I'll take that, I can handle that, and you plead guilty to driving on a suspended license. But if you also have a fleeing and eluding in felony court that happened the same day from the same driving incident, you just put yourself behind the wheel. So in felony court, they can rewind and get the audio from here where you said, guilty of driving while my license was suspended. You just admitted to one of the elements of the crime in the fleeing and eluding. So if that's the possible situation for you, or if you have a violation of probation in felony and you plead guilty to this case today, you are probably admitting that you violated your probation. So just keep those things in mind before you make up your decision. That way you don't say that, oh, I didn't know, oh, they tricked me, they didn't tell me. It's up to you to make the decisions, not up to us to tell you how your decisions will impact everything else. So just keep that in mind. Basically, that's it. If anything else comes up case by case, I'll let you know. We'll go from there. Kenny Alvarez.
Azalea Ramirez Sanchez on behalf of the defense.
Kenny Alvarez, come on up. 2020 MM1605. Good morning, sir. What's your name?
Kenny Alvarez.
Thank you. Which state attorney is on this case?
That's me, Judge. Sarah Castro on behalf of the state.
Thank you. This wasn't the one you said you were gonna make an announcement on, is it?
No, it was Alicia Willis.
Thank you. So, Mr. Alvarez, you are charged with domestic violence, battery, and resisting without violence. Both of those are first-degree misdemeanors. Each one is punishable by up to a year in jail, a year of probation, and $1,000 in fines. The domestic violence also carries the possibility of a 26-week batterers program and a $201 domestic violence surcharge. How does the defense plead?
Your Honor, there's no offer at this time, so we're just gonna do a not guilty.
Mr. Alvarez, your lawyer is saying to plead you not guilty, okay? We're gonna set you for pretrial. That will be set September the 8th at 8:15 in courtroom 4A. Thank you. Joel Castillo.
Azalea Ramirez Sanchez on behalf of the defense.
Thank you.
Your Honor, I believe he hasn't been talked to.
All right, Mr. Castillo, have one of the public defenders talk to you on the phone?
No, ma'am.
All right, have a seat. They'll call you in a minute. You can talk to your lawyer on the phone. Andy Sherazard.
Azalea Ramirez Sanchez on behalf of the defense.
Your Honor, he's on the phone right now.
I'm sorry, he's where?
He's on the phone with PD.
Oh, all right. I'll come back to him. Gonzalez Cuts.
Azalea Ramirez Sanchez on behalf of the defense.
Gonzalez Cadez Cuts.
One moment, ma'am.
No problem. Good morning, sir. Can you please say your name for me?
Gonzalez Cadez Cuts.
Thank you. Mr. Cuts, you're here for arraignment. You're represented by the Public Defender's Office. The state attorney filed 2 charges against you, resisting without violence and trespass. The resisting is punishable by up to a year in jail, a year of probation, and $1,000 in fines. The trespass is up to 60 days in jail, 6 months probation, and a $500 fine plus court costs. How does the defense plead?
Your Honor, has Mr. Cuts been talked to?
Mr. Cuts, did you talk to the public defender this morning?
Yesterday.
Yesterday, okay.
Well, he's going to enter into a negotiated plea of adjudication of guilt, credit time served, and court cost.
So, Mr. Cuts, do you want to take the offer?
Yes.
How do you plead?
Guilty.
Do you already have a plea form? I see
I
a
do
paper
not.
in your hand. What's that paper in your
This is my
hand?
paperwork.
Oh, okay. Did you go over a plea form with the public defender yet?
I have not.
No, okay. So that's the paper right there on the bench. Well, you want to take that for me, please, and go back in the back and read it. That way you know what rights you're giving up, and then when you're done, I'll call you back up.
This is a violation of probation.
Oh, okay. Let me ask the corrections officer where the other form is. A regular plea form. All right, Mr. Cuts, you can go back to where the corrections officer directs you and read the paperwork. How about Joshua Engel? Good morning, sir.
Good morning.
Please say your name.
Joshua Engel.
Thank you. Mr. Engel, you're here today for arraignment. The charge is violation of probation. Really, the biggest issue, the only issue, is the new charge. And so if you say guilty to the violation, you are admitting guilt to the new charge, which right now is a felony case number. But, hold on, it looks like that case just got no info. It's over.
Yes, Your Honor.
Okay. State, what is your position with regard to the violation? Because 20 CF 1659 got no build.
Yes, Your Honor. Garrett Lutz on behalf of the state. At this time, the state will go ahead and ask for the court to dismiss the violation of probation.
All right. Mr. Engel, I'm going to dismiss the violation, reinstate and terminate your probation. All of your other conditions are done, and you are about to be finished with probation anyway. Because of the amount of days that you've served, I'm going to go ahead and cut you loose. You'll be released today. You have $50 back cost of supervision that you owe to probation. We're gonna put that into the balance of your court costs. And I'm just gonna tell you, within 30 days of getting out of jail, just report to the clerk's office and restart a payment plan. Okay?
Okay, so my probation is over?
Yes, sir. Terminated.
Okay, thank you.
Do you have any questions?
Nope, that's it.
All right. Thank you, sir. Have a good day.
Thank you.
Christopher Sullivan.
Dalia Ramirez Sanchez on behalf of the defense.
He's on the phone with PD.
All right. Thank you. Alicia Willis. 2020 MM 1640.
Dalia Ramirez Sanchez on behalf of the defense.
Good morning. Can you please say your name?
Alicia Willis.
Thank you. State you had an announcement.
Yes, Your Honor. In 20 MM 1640, the state will announce a null pros.
Ms. Willis, the state decided that they are going to drop the charges. You are going to be released on this case today.
Today?
Today. This case is now closed. It's over. If you have nothing else holding you, you were released.
Oh, thank you.
You're welcome. Have a good day. Brandon Rentis.
Your Honor, this client is actually in our office. I just got a text saying he's in our office right now.
Who'd they just take out of the cage?
I'm uncertain, but I definitely just got a text saying he's in our office.
Your Honor, this is the VOP status hearing we just talked about.
Oh, got it. All right, never mind. I saw them, I called the name, I forgot what we said before, and then I saw them open the door in the back, so I was like, huh? All right. Is Castillo ready? Joel Castillo? 2019 MM 4375. Good morning.
Yes, Your Honor.
Hi, please say your name.
Joel Castillo.
Thank you. All right, so Mr. Castillo, 19 MM 4375, you're represented by the public defender. This is a violation of probation, arraignment. The biggest issue on here is the batterer's intervention program. But wait.
Your Honor, can we do a Spanish interpreter as well?
Sure. I don't understand. This note makes no sense.
Good morning, Your Honor. This is Alan Figueroa, Cesar Fast Masculine Interpreter.
Hi, Mr. Figueroa. Have you been sworn?
Yes, Your Honor.
Great. We have Joel Castillo, 19 MM 4375 over at the jail. Can you ask him, please, if he can hear you?
¿Me escucha, señor Castillo?
Sí, señor.
He can hear me, Your Honor.
Fantastic. Okay, so Mr. Castillo, you're here for arraignment. Violation of probation is the charge.
Señor Castillo, se encuentra aquí en su vista incoatoria. La acusación es por incumplimiento de la libertad vigilada.
Sí, Your Honor.
Yes, Your Honor.
I'm going to read right off of the affidavit in the file because the slip that probation gave me doesn't make any sense.
Voy a leer directamente del documento que está en el archivo, la affidavit, porque la documentación que me ha dado el oficial no tiene sentido.
The update she gave me today isn't exactly in line with what's in the file.
La actualización que ella me entregó hoy no se correlaciona directamente con lo que consta en el archivo.
And the file is what controls.
Y el archivo es el que rige.
So the violation was supposedly because of a new charge.
El incumplimiento supuestamente fue por un nuevo incumplimiento o un nuevo cargo.
2020 MM 1693.
El 2020 MM 1693.
Which alleges a new battery on the same victim.
lo que alega una nueva acusación de agresión física contra la misma víctima.
However, it looks like the state no infoed the new charge yesterday or day before yesterday.
Sin embargo, parece que la fiscalía radicó los cargos fue ayer ante el nuevo cargo.
However, back to the violation,
Pero de vuelta al incumplimiento.
there's a no contact order
Hay una orden de prohibición de contacto
with Melanie Rios.
con Melanie Ríos.
And even if the state could not prove a new battery, they might still want to try to prove contact.
Incluso si la fiscalía no pueda demostrar un nuevo cargo por agresión física, podrían demostrar que sí hubo contacto.
And then the affidavit also says, hold on, I got to go back and forth between two folders.
Y el affidavit también indica, deme un segundo porque tengo que estar pasando de uno al otro entre dos archivos diferentes.
Falling behind on money and that contact that I just talked about.
Por faltar en los gastos o en los pagos y por el contacto.
So that's the reason for the violation.
Esa es la razón por la acusación del incumplimiento.
Any offer from the state?
Yes, Judge, sorry.
You're okay.
Yes, Judge, we were able to reach, I think we were able to reach, a negotiated plea as to the BOP.
Hold on, let
the
me
offer
interpret, hold on. Let the interpreter translate.
¿Tiene alguna oferta, Fiscalía? Sí, su señoría. Creo que hemos podido llegar a un acuerdo al que hemos negociado.
You may proceed.
Yes, Judge, the agreement that I believe we were able to reach was admit as to the no contact, not completing the BIP and the costs, dismiss as to the new law since it was no infoed, revoke and terminate probation, sentence him to a new term of probation that I believe is 196 days.
Okay, hold on. Hold on.
Sí, su señoría. El acuerdo que creo que hemos podido llegar es a una admisión ante el incumplimiento de la orden de prohibición de contacto. Se desestimaría la acusación por la agresión física, ya que no fue radicado por la fiscalía. Se revocaría y se pondría fin a la libertad vigilada actual y se metería un nuevo término de libertad vigilada de 196 días.
Anything else?
As a condition of his new probationary period, 90 days in the Orange County Jail with credit for the 79 days he has served with all original conditions that he had on his first term.
Como condición de la nueva orden de libertad vigilada, se emitirían 90 días de cárcel, acreditándole los 79 días ya cumplidos y todas las otras condiciones originales de la primera orden.
All right, 1 second. All right, let me make sure I understand. So the offer is adjudication of guilt, revoke and term. 90 days with credit for whatever he has, followed by a new term of probation.
Yes, Judge.
Bien, déjeme ver para asegurarme que entendí todo. Entonces, la oferta es emitir un dictamen de culpabilidad, revocar y poner fin al término actual, 90 días de cárcel acreditándole el tiempo que ha cumplido hasta ahora y un nuevo término de libertad vigilada. Sí, su señoría.
And I'm asking the clerk to recalculate the credit time served because the number that the state just gave me is different than the number that's on my docket sheet.
Le estoy pidiendo a la secretaria que vuelva a hacer los cálculos con respecto al tiempo que se le acreditaría porque los días que me ha dado la fiscalía no son los mismos a los que constan acá.
The clerk is telling me that the credit time served is 69 days thus far.
La secretaria me está diciendo que el tiempo acreditado hasta este momento serían 69 días.
I thought I heard the state say 79.
Y pensé que la fiscalía me había dicho 79.
I did, Judge. My apologies. I was reflecting back on an email exchange that I had with the public defender, and I think they accidentally wrote 79 days, so I relied on that. So my mistake.
Sí, su señoría, me estaba basando en un correo electrónico que me había enviado la oficina del defensor público en el que decía originalmente 79 días y creo que fue un error. Me disculpo.
No problem at all. I do that all the time. I just wanted to make sure we were all using the same numbers.
No hay problema, pasa todo el tiempo. Quería asegurarme que todos estábamos usando los mismos números.
So, Mr. Castillo, do you want to take that offer or do you want to say not guilty to the violation?
Señor Castillo, ¿desea aceptar esa oferta o desea declararse inocente ante la acusación del incumplimiento de libertad vigilada?
Yes, Your Honor. Sí, Your Honor.
Yes, Your Honor.
So, defense?
Yes, Your Honor. I was just about to ask him because I'm getting mixed information from my co-counsels. I know this offer was heavily negotiated, so just a yes or no for our client. He understands he's going back on probation.
Sí, su señoría, solamente quería aclarar porque estoy recibiendo mucha información de parte de mis coabogados. Esto fue una negociación que no fue muy fácil. Quiero asegurarme sí o no que él entiende que se emitirá un nuevo término de libertad vigilada.
Do you understand?
¿Lo entiende, señor? ¿Que habrá un nuevo término de libertad vigilada?
Sí, señor.
Yes, sir.
So, Mr. Castillo, if you plead guilty today, you are going to serve probably another few weeks in jail and then go back on probation. Do you understand that?
Señor Castillo, si usted se declara culpable hoy, tendrá que cumplir con un par de semanas más de cárcel y después volverá a otro término de libertad vigilada. ¿Lo ha entendido?
Actually, let me tell you, if you are entitled to your regular game time, it won't be a couple of weeks. It'll probably be about a week.
De hecho, déjeme reformular. Si usted tiene derecho al término original, no será un par de semanas, será una semana.
And if you're wearing white, that means you're a trustee and you might actually be qualified for even more game time.
Y si tiene puesto el uniforme blanco, quiere decir que es un reo confiable, por lo que podría dar más tiempo acreditado.
So I would ask the state attorney this. If he's a trustee, I don't know what the jail is doing nowadays, but it used to be that trustees got 10 days off for every 30 days.
Déjeme preguntar a la fiscalía. No sé cómo lo está haciendo la cárcel en este momento, pero antes, cuando un reo tenía el uniforme blanco, que era un reo confiable, acumulaban 10 días adicionales por cada 30 días cumplidos.
If I say 90 days with credit for 69 and he gets all his trustee gain, he'll be out today.
Si yo establezco 90 días acreditándole 69 días cumplidos, bajo esa regla, él quedaría en libertad hoy mismo.
And so, in essence, that gives him 21 days of credit that he will never have to serve.
Eso, entonces, le daría a él, o se acumularía en 21 días acreditados que, por lo que él nunca tendría que cumplir.
So my question is twofold.
Así que mi pregunta es de dos partes.
Does the victim know that there is the potential that he would get out of jail as soon as today?
¿Está la víctima al tanto que él puede quedar en libertad hoy mismo?
Whether she cares or not, I don't know.
No sé si eso es algo que sea pertinente para ella o no.
The reason the case was no-billed earlier this week was because the victim was severely uncooperative. As of yesterday, she now became cooperative and wanted me to refile the initial charges, which I am not going to do. She was made aware of today's offer. I did not tell her, though, that he may be released because I did not know about his additional gain time. If he is released, she does not know that, but I can let her know after the admission. But if he's entitled to that time to good behavior, then it is what it is if he gets out today.
Señoría, la razón por la que el cargo original no fue radicado era porque la víctima no estaba cooperando. No fue sino hasta ayer que ella comenzó a cooperar y pidió que el cargo original fuera radicado, lo que no se va a hacer. Ella estaba al tanto de la oferta que se había presentado, sin embargo, no estábamos al tanto de que dado su buen comportamiento, hubiese la posibilidad de que él quedara en libertad hoy mismo. Ella no está al tanto de eso, pero se le puede informar al respecto después de que se radique la admisión.
So the second part of my question was then going to be, if he has the possibility of getting the gain and getting out today, wouldn't it make more sense to credit time serve him followed by probation?
Entonces, la segunda parte de mi pregunta es, si a él se le acumularía ese tiempo que ha acreditado por buena conducta y quedaría en libertad hoy mismo, ¿no sería mejor entonces acreditarle solamente el tiempo cumplido y ya emitir el término de libertad vigilada hoy?
Because then that way not that I want him to violate, and I hope he doesn't violate, but if he does, there's more jail time that is on the table as incentive to behave.
Porque si él llegase a incumplir con ese término, no que estoy diciendo que yo quisiera que él lo incumpliera, pero si él llegase a cumplir con ese nuevo término, habría entonces más tiempo de cárcel que quizás pueda ayudar a enforzarle o darle aliento a él a que cumpla con el término.
And my understanding, although this is just my feeling, the jail is looking to let out anybody who is safe to let out.
Y se me ha hecho entender, creo yo, en mi idea, que la cárcel está tratando de ya dejar en libertad a cualquier persona que pueda quedar en libertad.
So if he is a trustee and has not given them any problems, I would guess that they would be more than willing to gain him out with the extra time.
Y por lo que yo pienso, ya que él es un reo confiable, yo imaginaría que ellos están dispuestos a ya dejarlo en libertad, acreditándole ese tiempo acumulado extra.
But it's the state's offer, so I'll let you tell me, do you want me to sentence him to the 90 or do you want me to credit time serve him followed by probation?
Pero la oferta es de la fiscalía, así que usted decidirá si se le emiten los 90 acreditando el tiempo cumplido o si ya simplemente se le emite una oferta de tiempo cumplido y se emite el nuevo término libertad vigilada.
I like your idea better, Judge. If defense is fine with it, then I think that would be better.
Me parece mejor la idea suya, su señoría. Si la defensa está de acuerdo, creo que esa sería la mejor opción.
I have yet to see a defense attorney not want credit time served.
Todavía no he conocido ningún abogado defensor que no esté de acuerdo con acreditar el tiempo cumplido.
I'm pretty sure my client will want to get out today, so defense has no objection.
Estoy segura que mi defendido quiere salir ya hoy mismo, así que no hay ninguna objeción de parte de la defensa.
Mr. Castillo, did you understand all that?
Señor Castillo, ¿entendió usted todo eso?
Sí, Your Honor.
Yes, Your Honor.
And would you like to plead guilty and be put back on probation?
¿Desea declararse culpable y que se emita nuevamente la libertad vigilada?
Sí, Your Honor.
Yes, Your Honor.
All right. Does he still need to fill out an admission form? Or does he need to review an admission form?
¿Él necesita leer el formulario de admisión?
I believe so, Your Honor. I know that his attorney talked to him yesterday in debt, but can we just ask him just to make sure?
Creo que sí. Creo que su abogado habló con él bastante ayer, pero podemos preguntarle para estar seguros.
Well, Mr. Castillo, did you go over with your lawyer the rights that you would be giving up if you chose to take the state's offer?
Señor Castillo, ¿usted repasó con su abogado los derechos a los que estaría renunciando si decide aceptar la oferta?
Sí, Your Honor.
Yes, Your Honor.
All right, so what I'll do is I'll go over things with him now and he won't have to reread the form.
Thank you, Your Honor.
Bien, entonces voy a repasarlo con él ahora y así él no tendrá que leer nuevamente el formulario.
Because I have the interpreter on the phone now.
Porque tengo el intérprete en línea ahora.
Mr. Castillo, please raise your right hand.
Señor Castillo, levanta la mano derecha.
Do you swear to tell the truth, so help you God?
¿Jura decir la verdad? ¿Lo jura ante Dios?
Sí, Your Honor. Sí, Your Honor.
Yes, Your Honor.
Okay, please lower your hand.
Baja la mano.
Mr. Castillo, you are set today for this charge of violation of probation.
Señor Castillo, usted se encuentra aquí hoy por esta acusación del incumplimiento de su libertad vigilada.
If you are willing to admit guilt to the violation, we can resolve this charge as discussed.
Si usted está dispuesto a admitir culpabilidad ante el incumplimiento, podemos resolver el caso tal y como hemos establecido.
By going forward with the plea, you are giving up the rights you have to make the state attorney prove these charges against you.
Al aceptar este convenio, usted renuncia al derecho de obligar a la Fiscalía a demostrar su culpabilidad ante esta acusación.
Do you understand that?
¿Lo ha entendido?
Sí, Su Honor.
Yes, Your Honor.
You have the right to make the state present evidence for the court to consider whether or not you willfully and substantially violated your probation.
Usted tiene el derecho de obligar a la Fiscalía a presentar pruebas contundentes de que usted deliberadamente incumplió con su libertad vigilada.
Do you understand?
¿Lo ha entendido?
Sí, Su Honor.
Yes, Your Honor.
You have the right to challenge all of the evidence that they might provide.
Usted tiene el derecho a disputar las pruebas que ellos presenten.
You have the right to present your own evidence if you want to.
Tiene el derecho a presentar sus propias pruebas si así lo desea.
You have the right to call witnesses to testify.
Tiene el derecho a convocar testigos a testificar.
You have the right to testify yourself if you'd like to in your own
Ti-
defense.
Tiene el derecho a testificar usted mismo si así lo desea en su propia defensa.
Do you understand all that?
¿Lo entiende todo?
Sí, Su Honor.
Yes, Your Honor.
And did you have as much time as you felt you needed to talk with your lawyer about your options?
¿Tuvo usted tiempo suficiente para hablar con su abogado con respecto a sus alternativas?
Sí, Su Honor.
Yes, Your Honor.
Do you have any questions for me?
¿Tiene alguna duda o pregunta?
No, Su Honor.
No, Your Honor.
Do you need any more time to speak with your attorney?
¿Necesita tiempo adicional para hablar con su abogado?
Sí, Su Honor.
Yes, Your Honor.
You do want to talk to your lawyer?
¿Quiere hablar con su abogado?
Sí, Su Honor. Yes.
Yes, Your Honor.
Okay. So they're going to be calling you over there on the phone. Is it? That's fine. I won't ask. All right. So go ahead and have a seat, and then they'll call you on the phone.
Bien, ellos lo llamarán por teléfono, toma asiento y ya lo llamarán.
Gracias, Su Honor.
Thank
you, Your Honor.
You're welcome. All right. We'll call the interpreter back if needed.
Not a problem, Your Honor.
Thank you, sir. Andy Sherazad. Or Zard. Sherazard. Sorry.
Yes, Your Honor.
Good morning.
Good morning. How you doing?
I'm good, thank you. Please say your name.
My name is Andy Cherizard.
Thank you. Mr. Cherizard, you're here for arraignment. You're represented by the public defender. The charge is violation of probation. Probation says basically all of your conditions are due. Nothing got done. And so no license, no paying off tickets, no doing your hours, no making payments.
Actually, ma'am, I did pay off the tickets, and I did pay the safety class, the driving safety class, and I did took it. And the only thing I didn't do, because I was a full-time student. I didn't have a job. I couldn't pay for the fees.
Okay, and I'm not saying that's not true. I was just letting you know what probation was saying.
Okay.
All right? Defense?
Your Honor, my client's going to accept a negotiated offer as to admit credit time served and revoke in term.
Okay. Mr. Cherizard, your lawyer is saying that you want to go ahead and just take the offer and be done with it. Is that correct?
Yes, ma'am.
All right. Did you already read a plea form?
I didn't see one.
Okay. I'm going to have the corrections officer go ahead and let you hold on to that form, and then I'll call you back up.
All right, thank you.
All right. Thank you. Christopher Sullivan.
Good morning, ma'am.
Good morning. Please say your name.
Christopher Joseph Sullivan.
Thank you. Mr. Sullivan, you're represented by the Public Defender's Office. You're charged with trespass. That's why you're here for arraignment today. Let me just open the file to see specifically what the state alleges. So, July 14th, 2020, 4444 Vine Street in Kissimmee. That charge is punishable by up to a year of jail, a year of probation, and $1,000 in fines. How does the defense plead?
Your Honor, my client's going to accept the negotiated offer of adjudication of guilt, 120 days in Osceola County Jail with, can we check the credit time served? Because I got 47 and now it's saying 16.
Yes.
Yes, Your Honor, 47 days as well.
It says he was arrested July 14th, so I don't, that would be July 14th through to today would be an additional 15, that would be 15 days, so 17 sounds right. July 14th and today's the 30th, right?
Yes.
So that's 17 days. I don't know, where did Mr. Sullivan think the rest of the credit came from?
That was.
I apologize, Your Honor, it is 17 days.
It was in a previous docket, Your Honor, so that's.
Oh, okay.
What
So,
we-
Mr. Sullivan, the state's offer is 120 days, and you have credit for 17 on this case. Is that something you still want to take, or do you want to say not guilty?
No, I'm gonna take it, ma'am. I was there.
All right. And did you already review or talk with your lawyer about a plea form, or do you need time to read it?
We talked already about that.
Okay. So if you please raise your right hand for me. Do you swear to tell the truth, so help you God?
Said you, ma'am.
Thank you. Please lower your hand. Mr. Sullivan, you are here today for an arraignment. The charge is, like I said, trespass. It's from July 14th, 2020. By entering the plea, you are giving up the right to make the state prove those charges against you. Do you understand that?
Yes, ma'am.
Did you have as much time as you needed to talk with your lawyer about all of your rights?
Yes, ma'am, I did.
Do you have any questions for me?
No, I don't have no questions. At first, he started off telling me it was a month. Then 2 weeks later, he changed up on me, and then I got this offer. I have another case, which is a pay-death felony, but I'm going to take that one to trial because I was never there. I can prove it.
I don't know why the offers changed. They don't share that with me ahead of time. I don't get involved in the negotiations. I let them negotiate the way they want. I have the final say so, but if this is the offer you want to take, I'll take your plea.
I'll take it, ma'am.
Okay, no problem. Do you need any more time to speak with your lawyer?
I do not, ma'am. I'm good.
Do you feel like anybody forced you to make the choice you're making today?
No, I made it on my own.
Are you acting under the influences of any medications, drugs, or alcohol?
No, ma'am, I'm not.
If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand?
Yes, ma'am, I do.
And are you willing today to waive your rights and enter this plea?
Yes, ma'am, I am.
On July 14th, 2020, in Osceola County, Florida, did you willfully enter or remain on the property of Walmart at 4444 West Vine in Kissimmee after you were told you were not allowed to be there?
Yes, ma'am, I was getting a soda there from the soda machine.
So I find that you are alert, that you're intelligent, that you understand, that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Pursuant to negotiations, it'll be an adjudication of guilt, 120 days credit for 17, 273 in court costs, and $100 public defender lien. Within 30 days of whenever you are released from jail, just report to the clerk's office and you can set up a payment plan.
Okay, thank you, ma'am.
You're welcome. You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Thank you, sir.
Thank you, ma'am.
Did Mr. Cutts finish reading his paperwork? Okay, Mr. Cutts, raise your right hand for me, please, the best you can. Do you swear to tell the truth, so help you God?
I do.
Thank you. Please lower your hand. Say your name.
Gonzalez Cadez Cuts.
Mr. Cutts, did you have enough time to read the plea form?
Yes.
Did you read everything front and back?
Yes.
Do you understand the rights in the form?
Yes.
Do you have any questions?
No question.
Do you need any more time to talk to your public defender?
No, I'm good.
Do you feel like anybody forced you to make this decision?
No.
Are you acting under the influences of any medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand that?
I do.
And are you willing today to waive your rights and to enter this plea?
Yes.
How do you plead?
No contest. Well, I just go ahead and just say guilty.
All right. On June 4th, 2020, in Osceola County, Florida, did you not follow a lawful command that was given to you by law enforcement? Did you not do something that they told you to do?
I did.
Right. And did you willfully enter or remain on the property of 207 Lindo Court in Kissimmee without being authorized, licensed, or invited to be there.
That's correct.
And State, could you show that that address is actually defined as a structure?
Yes, Your Honor. Garrett Lentz on behalf of the state, covering on Carly Jernigan's behalf. Yes, Your Honor, the state would be prepared to share that finding.
Okay. So, Mr. Cutts, I find that you are alert, that you're intelligent, that you understand that your plea is freely and voluntarily entered, that I have a sufficient factual basis, and I will accept it. Pursuant to negotiations, it'll be an adjudication of guilt, count 1 and count 2. Credit time served for 7 days, count 1 and count 2 concurrent. $273 in court costs, count 1. $52.50 on count 2, and $100 public defender lien. Within 30 days of whenever you are released from the jail, you have to contact the clerk's office on the second floor of the courthouse and set up a payment plan. Do not return to 207 Lindo Court in Kissimmee.
Now, when I went to first appearance, I was at the house for like 10 days. I had left my personal property there. The judge had said he would allow me with an officer to go and get my property. Is that still possible?
Let me take a look at the booking report. You can go back one time with an assist order with law enforcement, but I will kind of just say to you, I would be very surprised if any of your stuff is still there. I don't know for sure for a fact, but based on the allegations in this affidavit, the owner of the property would have had the right to get rid of your stuff because according to this information, you were not a lawful tenant of the homeowner, so they were not under a legal obligation to hold on to your stuff. So before you pay for a law enforcement officer, you might want to consider what you thought was left in there and whether or not it'd be worth it for you. That's just friendly advice. I'll give you that opportunity, but the assist comes at a payment. You have to pay the sheriff's department to go with you. And so I don't know.
It's just that I don't know. I know they got my ID, but I just don't know if they got any other my belongings that's there, like my debit card or anything may be left.
I understand. What I would suggest to you is to go to the sheriff's office with the copy of the paperwork. Maybe they can call the homeowners and say, does any of this stuff still exist? Is that around? Do y'all have it? Because we'd like for him to come and get it, or or make arrangements.
Right.
Just before you pay them to take you out to the property, you want to make sure that there's something worth you going to get.
That makes sense, yes.
All right? 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Good luck, sir.
Thank you.
You're welcome. Mr. Castillo was talking to the public defender.
Yes, Your Honor. He is going to accept the offer.
All right, and he's the one who we had the interpreter with.
Yes, Your Honor.
Joel Castillo, okay.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter, previously sworn.
Thank you. We have Mr. Joel Castillo, 19 MM 4375 at the jail. All right, Mr. Castillo, I'll remind you that you're still under oath.
Señor Castillo, le voy a recordar que usted todavía está bajo juramento.
So we took a break from your plea to let you have time to ask the public defender some questions.
Tomamos un receso para permitirle a usted que le hiciera preguntas al defensor público.
Did you get that opportunity?
¿Usted tuvo esa oportunidad?
Sí, Su Honor.
Clarification. Repita, señor, no se le entendió bien.
Sí, Su Honor.
Yes, Your Honor.
And did you have enough time to ask all your questions?
¿Tuvo tiempo suficiente para hacer todas sus preguntas?
Sí, Su Honor.
Yes, Your Honor.
Do you wish to go forward with your plea?
¿Quiere proceder con su declaración?
Sí, Su Honor.
Yes, Your Honor.
Do you have any questions for me?
¿Tiene alguna pregunta para mí?
No, Su Honor.
No, Your Honor.
Do you feel like anybody forced you to make the decision that you made today?
¿Usted cree que alguien lo ha obligado a usted a hacer la decisión que está haciendo en el día de hoy?
No, Su Honor.
No, Your Honor.
Are you acting under the influences of any types of medications, drugs, or alcohol?
¿Usted está actuando bajo los efectos de algún medicamento, drogas o alcohol?
No, Su Honor.
No, Your Honor.
If you are not a U.S. citizen, entering a plea would be used as a reason to have you deported. Do you understand that?
Si usted no fuese ciudadano norteamericano, esta declaración pudiera ser usada como base para que usted sea deportado. ¿Usted entiende eso?
Sí, Su Honor.
Yes, Your Honor.
Are you willing to waive your rights and enter this plea to accept the state's offer?
¿Usted está dispuesto a dispensar de sus derechos, a aceptar esta declaración y este acuerdo con el fiscal?
Sí, Su Honor.
Yes, Your Honor.
Do you admit that you did not comply with the terms of your probation the way that you were supposed to?
¿Usted está de acuerdo que usted no cumplió con los requisitos de su libertad vigilada tal como se lo habían exigido?
Sí, Su Honor.
Yes, Your Honor.
And I'm going to ask this very specifically.
Y le voy a hacer una pregunta muy específica.
Do you admit that you had communication or contact with Miss Castillo, with the listed victim in July?
¿Usted admite que usted tuvo comunicación y contacto con la víctima indicada en el mes de julio?
Sí, Su Honor.
Yes, Your Honor.
And did you know that as a condition of your probation, you weren't allowed to have any communication with her?
¿Y usted estaba consciente que como condición de su libertad vigilada usted no se le permitía tener contacto con ella?
Sí, Su Honor.
Yes, Your Honor.
So I find that you are alert and intelligent, that you understand, and that your plea is freely and voluntarily entered.
Determino que usted es alerta y coherente, que usted entiende las condiciones y que usted lo está haciendo de su propia voluntad.
Sí, Su Honor.
Yes, Your Honor.
And I will accept your plea.
Aceptaré su declaración.
So here's the way that I think we left it.
Creo que esta es la manera que lo habíamos dejado.
It will be an adjudication of guilt and a revoke and terminate probation.
Será una adjudicación de culpa y se revoca y se determina la libertad vigilada.
You have credit as of today of 69 days.
En el día de hoy ya tiene créditos por 69 días.
You are going to be then placed on a new term of probation for 200 days.
Lo vamos a colocar en un nuevo periodo de libertad vigilada por 200 días.
You are on probation the minute you step out of the jail.
Usted estará en libertad vigilada el momento que usted salga de la cárcel.
You're going to have until Friday at 4 p.m. to contact your probation officer.
Usted tendrá hasta el día viernes.
Oh, we lost the interpreter.
Can you hear me, Your Honor?
I can hear you now, yeah.
Tendrá hasta el día viernes hasta las 4 de la tarde para contactar su oficial de libertad vigilada.
All of your original conditions are hereby reinstated.
Se les restablece todas las condiciones originales de su libertad vigilada.
But you have credit for anything that you've completed.
Pero le damos crédito por todo lo que usted ya haya completado.
For right now, until we figure out what's going on with this victim, you are ordered to not have any contact with her.
Por ahora, hasta que nos enteremos lo que está sucediendo con esta víctima, le ordenamos que se le prohíbe el contacto con ella.
And for the record, that's Melanie Rios.
Y para que consten las actas, es la señorita Melanie Ríos.
You are going to have to pick back up or restart the batterers program.
Va a tener que volver a comenzar el programa de intervención de agresores.
You will have 60 days from the day of your release to show that you have either restarted it or you are going to have to show that you've immediately picked back up.
Tendrá 60 días desde su libertad para mostrar que usted ha vuelto a comenzar el cursillo o que lo comenzó de nuevo desde el punto que lo había dejado.
In other words, contact the program immediately and see if you can pick up where you left off so that you can get credit.
O sea, contáctese con el programa inmediatamente cuando lo suelten para ver si usted puede comenzar desde el momento que lo dejó.
The longer you wait, the more likely they're going to make you start again.
Mientras más se demore, es más probable que lo hagan comenzar desde un inicio.
If they tell you you have to start again, you need to have that just redone within 60 days.
Si le exigen que lo tiene que completar de nuevo, tiene que tenerlo listo ya antes de que se cumplan los 60 días.
And then finish the program by going every week as directed.
y terminar el programa acudiendo todas las semanas de la manera que le indiquen.
Your payments will just restart again at $25 a month.
Los pagos comenzarán de nuevo a una tasa de 25 por mes.
And I'm going to let you start those in November so you have a couple of months to focus on taking the classes.
Y le voy a permitir que los comience a pagar en noviembre, así dándole tiempo para que usted se enfoque en las clases.
The $150 that you owe back cost of supervision, I'll put into your payment plan.
Los costos de supervisión atrasado que usted debe, lo voy a colocar en el plan de pago.
And I'm going to direct the state, let the victim know that he is likely going to be out by the end of the day today.
Y le voy a instruir al fiscal que le indique a la víctima que usted va a salir muy probablemente antes de que termine el día de hoy.
It takes a few hours to process out.
Porque se toman unas horas para procesarlo.
Mr. Castillo, if you violate your probation, you will end up back in jail.
Señor Castillo, si usted incumple las condiciones de su libertad vigilada, va a regresar a la cárcel.
If you get out of jail today and you contact Melanie, that will be a violation.
Si usted sale de la cárcel hoy y se pone en contacto con Melanie, eso será una violación.
So please understand that.
Por favor, entienda eso.
You have 30 days to appeal. All appeals must be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify.
Tiene 30 días para apelar. Todas las apelaciones deberían ser por escrito. Si no puede costear un abogado para la apelación, le asigno uno si cumple requisitos.
Thank you. Good luck.
Muchas gracias y buena suerte.
Thank you, sir. So on.
You're welcome.
Thank you.
Your Honor, just for clarification, the state is going to dismiss the new law
They
violation?
did already.
Okay, just making sure.
They no-billed it, correct, Ms. Castro?
Yes, Judge.
And she indicated earlier that she had no intention of refiling it, even though the victim had asked her to.
Yes, Your Honor, I just wanted to make clarification for the violation of probation. He's not admitting to that.
Thank you. And that's why I asked him what I asked him, and I did ask about
Yes.
battering her.
Yes.
All right. So thank you to the interpreter.
You're welcome, Your Honor. Have a good morning.
You as well. All right, Mr. Cherizard. Andy
Judge, that was
Cherizard.
my final case on the docket. Is it okay if I head out?
Yes.
Thank you, Judge. Have a wonderful day.
You too, thank you. All right, Mr. Cherizard, 19 CT 3859. Please raise your right hand for me. Do you swear to tell the truth, so help you God?
Yes.
Thank you. Please lower your hand and say your name.
My name is Andy Cherizard.
Mr. Cherizard, did you have enough time to read through the plea form?
Yes, ma'am.
Did you read everything front and back?
Yes, ma'am.
Is that the paper in your hand?
Yes.
All right, can you put it back there on the table? That way the next person can read it if they want to. Thank you. Do you have any questions?
I wanted to ask the state that since I was they had gave me probation with adjudication with hell. Can that add on to my plea?
State, the defendant is asking if you have any objection for me to maintain the withhold.
Your Honor, the state would object to maintaining the withhold at this point.
They do object. Do you still want to go forward?
Yes, sir. Yes,
Okay.
ma'am.
Do you have any other questions?
No, ma'am.
Do you need any more time to talk to the public defenders?
No, ma'am.
Do you feel like anybody forced you to make the choice you made?
No, ma'am.
Are you acting under the influences of any kinds of medications, drugs, or alcohol?
No, ma'am.
If you are not a U.S. citizen, entering a plea would be used as a reason to deport you. Do you understand that?
Yes, ma'am.
And are you willing today to waive your rights and enter this plea to resolve your case?
Yes, ma'am.
Mr. Cherizard, do you admit that you did not comply with all of the conditions of your probation the way that you were supposed to?
Yes, ma'am.
If you would have tried harder, do you think you could have done it?
Yes, ma'am.
So I find that you are alert, that you're intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis and I will accept it. Pursuant to negotiations, it'll be an adjudication of guilt, revoke in term, probation, credit time served. You owe $330 back of your costs from before and $250 to probation. We're going to put that all into one account here at the courthouse and you can make payments on it, okay?
All right, ma'am. Thank you.
You're welcome. Within 30 days of your release from jail, just call the clerk's office and they'll set you up with a payment plan.
All right, thank you, ma'am.
You're welcome. You have 30 days to appeal. All appeals have to be in writing, and if you cannot afford a lawyer, I'll appoint one if you qualify. Good luck to you.
Thank you.
You're welcome. All right, so I think that's it for the jail. Or no, what about, is Chris Smith at the jail? State Hospital, all right, so we're done with the jail.
Ma'am, we still have one.
Who is it?
It's a Paulino.
It's number 25 on the docket, Your Honor.
What did I do with that one?
He also has a private attorney.
Okay, hold on.
Or she, I'm sorry, she has a private attorney.
Soneda Paulino, it's not on my paper. I don't have a sheet. It's, 18 mm 188. Good morning.
Your Honor.
Hi, please say your name.
Sonida Guadalupe Paulino.
Thank you. What, that was the late add-on?
Your Honor, I think this is a late add-on because it's going to be a credit time served, so they wanted to get her in
Yeah,
for
but
you.
where's private counsel? I can't plea her without her lawyer. I don't have anybody waiting in the waiting room. Ms. Paulino, I'm trying to find out where your lawyer is. And I guess, let me see if Judge Arendis is available. Is she here today? Do you know if she's in court? She wouldn't be if you're here with me, right?
We had 6 cases for today, so she should still be.
Okay.
I can ask Diane to let me know your terms and conditions.
Excuse me, Your Honor, would you like my attorney's number?
No, give me one moment, please. Thank you. I'm just talking to Judge Arendis, who is the one who asked me to cover your plea today.
Yes, ma'am.
So I'm just trying to find out first from her, what did she tell your lawyer?
Okay, yes, ma'am.
Thank you. Another option that we have, because the state attorney is telling me that it was a credit time served offer, is that I also have jail arraignments at 1 o'clock, and that if we can't find where Mr. Martinko is, we can call him and give him the link on the video to appear at 1 o'clock. So that way you would still get out today, we would still resolve it today. It's just I can't take a plea for you without your lawyer being present. He doesn't have to physically be here, but he at least has to be on the video.
I understand, Your Honor, but he had told me that the state and them and the judge had approved for credit time served
Right.
and termination of probation.
Right, and that's still the goal, but for you to do that, for me to give you credit time served and terminate the probation, you have to enter a plea. And I'm not allowed to take your plea if you have a lawyer without your lawyer being available.
Yes,
So I'm
ma'am.
just trying to find out where he's at, and I'm letting you know that even if I can't find him right now, I could do it at 1 o'clock, so the result will be the same.
Yes, ma'am, thank you.
You're welcome.
Your Honor, my information from the ASA is that he was given a link by her JA, but that may not be the right link. So I just forwarded the link that you yourself provided me this morning that got me in.
Fantastic.
So I'm hoping that he pops up in the next couple seconds.
Okay. Oh, got him. He just has to activate his camera and we'll hear him in a minute.
Yes, ma'am, thank you.
Okay, so I see defense counsel was admitted from the lobby. I just need you to please check if your camera and your mic are active. And that's unknown user. Let's see who that is. I have an icon. Oh, hello. I hear you, but I don't see you.
Okay, let me turn on, see if I can get the audio on.
All right. Check your video. There we go.
Yes.
Something's coming
There.
up. Hi, good morning.
Hi, good morning.
Can you please state your name for the record?
Yes, my name is Michael Martinko. I'm the attorney for Snyder Paulino.
Thank you, Mr. Martinko. I'm glad that we were able to get a hold of you. I think maybe you were sent the wrong link.
Yes, I've been on hold since 9:20, so.
Oh, I'm so sorry. I had no idea. I was doing court and waiting for the doorbell to ring, and so it looks like you got the wrong link.
Yeah, that's why I emailed the state, so I think that's why we were able to get.
No worries. No worries at all. We got it worked out. I have Miss Paulino over at the jail. She's on the large video that I have, but you're not going to be able to see that.
Okay.
Okay, but she can hear you.
Very good.
Can you hear him?
Yes, ma'am.
Fantastic. So my understanding was that this was going to be an admission on the violation of probation, and the state and the defense have agreed to an adjudication, revoke, and term credit time served.
That's correct. She's admitting to violating 4 standard conditions: that she absconded, that she failed to provide a proof of address, that she failed to pay towards cost of supervision, and that she also failed to pay court costs or fines.
Okay. So for the record, 18 MM188, Ms. Paulino, if you could please raise your right hand for me. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Please lower your hand. So, ma'am, you are set today for a plea in the charge of violation of probation. How do you wish to plea?
Guilty.
And did you have as much time as you needed to review all of your options with your attorney before coming to that decision?
Yes, Your Honor.
Do you understand that by entering into this admission today, you're giving up your right to make the state prove these charges against you?
Yes, Your Honor.
Do you understand that you are giving up your right to challenge any of the evidence and to question any of the witnesses that the state has against you?
Yes, Your Honor.
Do you also understand that you're giving up the right to testify or to present any evidence or witnesses of your own?
Yes, Your Honor.
And do you have any questions about any of this process or any of those rights?
No, Your Honor.
Do you need any more time to talk to your lawyer about what you want to do and what you have the right to do?
No, Your Honor.
Do you feel like anybody forced you to make the decision that you've reached?
No, Your Honor.
Are you acting under the influences of any types of medications, drugs, or alcohol?
No, Your Honor.
If you are not a U.S. citizen, entering a plea would be used as a basis to have you deported. Do you understand that?
Yes, Your Honor.
And are you willing today to waive your rights and enter this plea to resolve this case?
Yes, Your Honor.
Do you admit, Ms. Paulino, that you did not comply with the terms of your probation the way that you were originally ordered to do them?
Yes, Your Honor.
Do you admit that you didn't report and you didn't provide the appropriate and the proper change of address the way that you were supposed to?
Yes, Your Honor.
Do you admit that you didn't take all the classes that you were ordered to take by the judge? I think you said, didn't you say there was a class?
No, Your Honor.
No,
Oh.
cost of supervision and court cost fine.
I'm sorry. I misunderstood then the note from probation. Let me take a look. Failure to report, failure to pay costs. Oh, and then failure to change address. Okay. And does the defense stipulate for purposes of plea that this would be willful and substantial sufficient enough to to have a factual basis.
We do, Your Honor.
So, Ms. Polino, I find that you are alert and intelligent, that you understand that your plea is freely and voluntarily entered, and that I have a sufficient factual basis, and I will accept it. Pursuant to the negotiations, the court will adjudicate you guilty of violation of probation, revoke and terminate your probation, and sentence you to credit time served.
Thank you, Your Honor.
You're welcome. It looks like you have 125 days, according to the clerk. All of the other conditions that may be unfinished are hereby waived, except for the money that you owe. According to probation, you owe $100 back cost of supervision, and your court costs from before are $878. Of course, if you had paid that down with receipts, you'll get credit for everything. But we're gonna put that into a payment plan. Within 30 days of your release, just contact the clerk of court for Osceola. You could call them by phone and set up a monthly payment plan, and they'll set you up with that, okay?
Thank you, Your Honor.
You have 30 days to appeal your sentence. All appeals must be in writing, and if you cannot afford a lawyer, I will appoint one if you qualify. Good luck.
Thank you, Your Honor. Have
You're
a good day.
welcome. All right, thank you.
Thank you, Your Honor.
All right, and I apologize for the confusion and the delay.
No, I understand. Thank you.
All right, bye-bye. All righty, so let's finish talking about Brandon Rentis, that he was downstairs
Yes, Your Honor.
in the PD's office. I don't remember why we set it for today. Maybe we were optimistic that we would be open again. Maybe we were confused that he was going to be, that he was at the jail, but I don't think he was. I don't know. He denied the violation of probation at arraignment, and we set him for a status today. So I'll ask the defense, have there been any developments?
Senator Jeff Volker for the defense. We asked for a reset, Your Honor. There's a felony case in Orange County that's set.
Felony charges, but sometimes we do have dates. So just pay attention to that. You will also get everything written down, and if you have a lawyer, your lawyer will get copies of all your dates as well. So there's a couple of different backups just in case. Just please stay on top of that. You are being recorded. You have the right to remain silent. Anything that you say can be used against you. You have the right to an attorney, and if you cannot afford to hire a lawyer, I will appoint one for you if you qualify. The clerk will make an announcement on whether or not your form was accepted. If you didn't fill out a form, I'm going to need you to fill one out. And if you filled one out, but now you decide you want to hire a private lawyer, you can do that too. Just tell me that. And whatever I end up saying will end up going on the paperwork. And that'll be helpful to you so that we know we're all on the same page. If you were picked up on an out-of-county warrant, I don't have court dates for you. I'm not going to change the bond on somebody else's warrant. If there is a bond and you can post it, you can get out of the Osceola County Jail. If there's not a bond or you choose not to post the bond that's there, we'll get you transported to Orange, if it's Orange, or the other county will come and pick you up otherwise. Having said that, we'll just take everything else case by case as we go, and hopefully it'll all make sense. Let me know if you don't understand when you come up. Okay. Okay, unless they tell me they're getting a private. Okay. Appearances from the state,
Carly Janigin on behalf of the state.
and with you is?
Janelle Green, ma'am.
Hi. And from the Public Defender's Office?
Guillermo Lopez from the Public Defender's Office.
Thank you. And from pretrial release?
Officer Ray Okendo.
Those masks make things so bizarre.
I
I'm
know.
far enough away. I don't have to have mine on. It takes off all my lipstick.
That's why I don't wear makeup anymore. There's no reason. Mascara only.
Yeah, it's muffled already. Can you imagine? All right. Roland Ford. Good afternoon, sir. Please say your name.
Roland Ford.
Thank you. Mr. Ford, you were arrested on a warrant out of Orange County, aggravated assault with a firearm. That warrant came, actually 3 counts. Counts 1 and count 2. Are they both ag assault? Yes. And then count 3, aggravated battery with a deadly weapon. Count 4, battery on, is that Leo or, it just says battery and then it just has initials, so just say battery.
It's just a
All right. I'm sorry, I gotta read somebody else's handwriting and it doesn't really give me a whole lot of information, but it is a warrant that a judge read and signed, and
I
it's
don't
a 0
accept
bond.
those charges. I'm not sure who put those charges on me.
Nor am I, I'm sorry, they don't give me the details, they just tell me that a judge signed a warrant, so I'm obligated to pass that information on to you so that you know. The bond is set at 0. We're gonna get you transferred, hopefully transferred over very soon to Orange County, but do you need a public defender?
No, I will hire a
You're
lawyer.
gonna hire a private? Okay. Thank you. Jamirez Brinson.
PD approved.
Okay, I'll take a look. Got it. All right, so good afternoon, please say your name.
Good afternoon, Jamirez Brinson.
Thank you. Mr. Brinson, I was handed 3 different warrants, but one of them might be a duplicate, so let me look at it real quick and just double check. The first warrant is a violation of probation, case number 17 CF 1577 that Judge Whitehead signed, 0 bond. Then the second one says failure to appear for drug court, but it's also Judge Whitehead, and it also says 17 CF 1577. You really can't have 2 warrants out for the same thing.
Yeah, it's all together.
I understand. So what I'm going to tell the clerk is to set aside the FTA warrant with the understanding that the violation of probation violation warrant is still active. It's the same case number. I mean, it's still holding him on a 0. So the result is the same, but you can't be in custody under 2 different warrants for the same case number. And then the third case is 18MM 2557, and that's a failure to appear. So that one's going to be Judge Whitehead's as well, but different case number. That's why it's a separate warrant, and that one's set at 0. Do you want a public defender, or are you going to talk to a private lawyer?
I believe Mr. Gray is the public defender over the drug court.
My understanding is that the clerk just said you do have a public defender already, so that will remain. You do still have your same lawyer. And your next court date?
Next court date for 2017, CF 1577 and 2018 MM 2557, August 5th in courtroom 3D at 2 p.m.
Thank you. They'll either transport you or they'll connect you via video. Marty Foster.
PD approved.
Good afternoon, sir. Please say your name.
Marty Foster.
Thank you. Mr. Foster, you were arrested on a warrant signed by Judge Johnson. You've got 5 counts here. You have count 1, attempted second-degree murder. Count 2, shooting at or within an occupied vehicle. Number 3, shooting from a vehicle. Number 4, aggravated assault with a deadly weapon. And number 5, possession of a firearm or ammunition by convicted felon. So Judge Johnson found probable cause, and your bonds are set. Let me just turn to the right page and tell you what he wrote. Well, okay. I don't even know where they are. They're in the back here somewhere. Judge Morgan did the transport order. Here they are. So all bonds will be stayed. Actually, this warrant only has 2 counts in it. Where's the rest of it?
The original warrant had 1 count and they filed on those 5.
Oh, okay, I see. So the original warrant had 2 counts, but the state has filed on the 5 counts that I just read to you. So it'll be bond per count of what's filed. 0 count 1, 10,000 count 2, 10,000 count 3, 10,000 count 4, and 1,000 count 5. No weapons or firearms, no contact with the victim. Do you need a public defender, Mr. Foster?
No, ma'am.
No? You're going to talk to a private lawyer? All right, thank you, sir.
Next court date, August 10th in courtroom 5F at 8:15 a.m.
Jerry Nader Medina.
PD approved.
Good afternoon, sir. Can you please say your name?
Gary Nader Medina.
Thank you. Sir, you were arrested on a warrant for failure to appear for pretrial. Your bond is set at 0. Do you need a public defender?
Right?
Do you need a lawyer? No? You're gonna talk to a private lawyer?
I want to do the time, whatever. I just want to finish with this. And that's
Yeah, but you still could benefit from talking to an attorney who knows what's right, what's not right. If you do it yourself, you could mess it up and make it worse. If you can't afford to hire a lawyer, I'll appoint a public defender for you. That's not a problem if you fill out the form for me.
Let's see. Yeah, I get it.
Okay, so PD provisionally approved. You said he did fill out a form?
Well, right now because of COVID, they're also.
Okay, so provisionally approved, he just has to fill out a form. All right, next court date.
Excuse me, September 30th in courtroom 4E at 8:15 a.m.
Thank you. Reginald Phillips.
PD approved.
I understand the rule that they're saying appoint the PD on everybody, but like 3 of them have already said they're hiring private, so.
That's the procedure. If they don't say they're not gonna hire private, that will.
But if you say approved, that means you've already looked at paperwork.
No.
So then don't approve them until I ask them. If they say they want a PD, then I'll give them a PD for sure. That's still compliant with their order, but if they're not, if they tell me they want private, they still have to fill out the forms. They'll get them automatically if they ask me, but they still have to fill out the forms. So you don't have to say approved, only if you've already reviewed a form. Thank you. Otherwise, it gets confusing. And the public defenders are like up to here now, so. Hello, sir, please say your name.
Reginald Phillips.
I can't hear you.
Reginald Phillips.
Thank you, that was much better, Mr. Phillips. Those masks don't help with hearing people. Sir, you're here because you were arrested for aggravated assault with a weapon, a deadly weapon, domestic violence, battery, and possession of cocaine, and there is probable cause. PTR, any history?
Defendant has arrests going back to 2012, possession of narcotics with intent to sell, possession of marijuana with intent to sell, selling cocaine, possession of cocaine with intent to sell, 2014 aggravated battery on a pregnant woman, domestic, those charges were dropped, and a domestic battery, he was found guilty on that. It is not the same victim as today.
Mr. Phillips, your bond in count 1 will be set at $10,000. Your bond in count 2 will be $2,500. Your bond in count 3 will be $1,000. He doesn't qualify for PTR, correct?
He can have PTR with the bonds, Judge.
All right. With PTR supervision, no contact with victim, no weapons or firearms, no alcohol or drugs. Do you need a public defender, sir?
Yeah, I'll take one.
PD will be appointed provisionally. Just please make sure you fill out the form if you haven't already. Thank you. Next court date?
Next court date on demand.
That means they'll let you know. Thank you. Victor Rosado Diaz. Don't say it. Good afternoon, sir. Please say your name.
Good afternoon, ma'am. My name is Victor Rosado.
Thank you, Mr. Rosado. You were arrested for sale of cocaine, possession of cocaine with intent to sell or deliver, sale of cocaine within 1,000 feet of a place of worship, and possession of drug paraphernalia. I've read the affidavit, and there is probable cause. PTR?
Has one prior arrest in 2019, a battery, those charges were dropped. That is all, Judge.
Okay. Bond in count 1 will be $150, count 2 will be $150, count 3 will stay at $10,000, count 4 will be $100. Do you need a public defender, Mr. Rosado?
Yes, ma'am.
PD will be appointed. Next court date?
On demand.
Thank you, sir. And then that's the changing of the guard.
Yes, ma'am.
Great.
Get them in as soon as we can.
What do you, I'm sorry?
They'll get them in.
Oh, yeah, no problem. It's kind of bizarre because my kids say I have like dog ears, that I hear everything, but recently with all the muffling and all, it just seems like I'm not catching.
Like Charlie Brown.
No, I don't mind.
I called them this morning. They're like, he's gonna be there, Pruitt isn't. So I'm like, okay. I took Pruitt out, kept him in. I came here and they're like, oh, Pruitt's coming and Watson isn't.
No problem, that's fine. You know what, I learned a long time ago, like, we're all taught that the shortest distance between 2 points is a straight line. That's fine. We know that if you want to get there the quickest, you go straight. But there are people and there are procedures that going straight is so much hassle that going around sometimes just saves you the agony. And I learned that because my dad was one of those kinds of people. Like, dealing with him straight on would cause you all sorts of headache. So just do what he wants you to do, even though you know there's an easier way to do it, and then you just don't have the aggravation. And sometimes that's just easier to live with.
Mm-hmm.
You know, it's not always about, well, they should do it this way. Just let them do it. Pick your battles. That's my credo in life. Pick your battles.
Yeah, I agree.
Not everything is a fight, and not everything is worth the fight.
Amen.
And you don't have the energy to fight everything. So,
So true.
Say that again? Do you mind reading what I wrote?
sure.
I just like to write stuff.
Yeah, I noticed. So you
That's fine.
bond amount, the PC has been found, and the PD has been
Sometimes I know that when we're signing
The main things, and conditions.
we don't realize there's already another warrant.
But sometimes on the DV cases, sometimes you're gonna get a civil judge in here and they don't know what's going on. So you need to make sure that on those domestic cases that there's no weapons, no firearms, no contact with the victim, no drugs or alcohol. Especially if those were a part of the case.
That was my point.
So, like I had to do that one day. She was looking to me, to us, to the state, to make sure that everything's done. But Jan Savage is a criminal judge in the county court, so she knows what's going on.
You know how they say that, like, all doctors have wonky signatures?
Mm-hmm.
Well, I mean, I really believe that people with that personality who would sign their names like that have personality traits that motivate them to become doctors. They don't sign wonky because they're doctors. They become doctors because they sign wonky. And so I think those are like character traits.
That's interesting.
And like, for example, if any of you have ever gone to a casino, the majority of the people in the casinos, at least here in Florida, are older people who are walking around with walkers and oxygen tanks, and then they're smoking up a storm.
With their
Smoking,
oxygen
smoking,
tank,
smoking.
which is so dangerous.
But they're compulsive gamblers, so it's the same compulsion that makes them smoke nonstop that also makes them gamble. It's that compulsion behavior.
Well, I think that's in any aspect of life. If you,
Maybe.
You might feel compulsed to play with your pen or something, or click your pen. There's like little things that we all do because of who we are. Which is why you smoke cigarettes, or
Agreed.
maybe if you have an addictive personality, which is why maybe you can get addicted to chocolate. Like not necessarily drugs, but just anything in life.
I mean, some things we do, some behaviors we repeat because it's calming, like a baby with a pacifier. It's a calming behavior. I think that there is some brain connection between people who smoke and people who gamble. Or at least gamblers. Maybe it doesn't go the other way. But if you gamble, if you compulsively gamble, you likely also smoke.
Because it helps with the anxiety of the gambling, which they fuel each other. But just because you smoke cigarettes doesn't mean you gamble.
Correct. I don't know that it goes the other way around.
Correlation is not causation in that.
Right. I think it flows one way, but not necessarily the other.
Okay. People who are OCD. Like some things that they do are calming. And I feel like all of us have a
little OCD.
Yeah, like me, if I'm in trial or anything, my papers need to be perfect. I can't have a messy desk when I'm in trial. I can't. It just looks bad to me. And it makes me feel like I'm not in control, if that makes any sense.
I can't leave the house without making my bed. That bothers me to no end.
I'm like that too, actually.
And I have to double check myself and kind of almost say it out loud to make sure that I've unplugged my flat iron.
Oh God.
Because I'll be halfway to work and go, oh my God, did I unplug the flat iron?
And then you're gonna be thinking about it the whole
I have to
day.
text one of my kids to go check that I unplugged the flat iron. Make sure the oven's off. You know, and those few things I have to consciously say, okay, remember, you're turning it off. That I've gotten that way as I've gotten older, though. Maybe probably more out of paranoia.
Paranoia drives me for that. I just unplug it.
I can't leave it. I'm so
I have a dog at home. He doesn't know how to turn off anything, so it freaks me out. Anything else could be burned down in my apartment. I don't care. My dog, no.
I agree. Well, I mean, I have other things that I don't want to burn down either, but yeah, I agree with, I understand what you're saying.
I guess I have a baby blanket too. That would be nice not to burn, but
I think girls are probably a little bit more OCD than guys.
shoes, jewelry.
I don't know, maybe. I could say something else, but I won't. Guys have different attributes that appear more consistently. Not everybody, obviously, you can't stereotype and lump everybody into one group, but they have other things. I really think that book, Men Are From Mars and Women Are From Venus, has some merit to it, because I think we are wired, for the most part, to approach things differently. I think we're predisposed that, of course.
Like men don't ask for directions.
Well, now you don't have to. Siri, how do I get to Google?
Instead of asking a person, you ask Siri.
So that's the difference. You won't ask a person, but you'll ask a machine.
You ask a machine,
Makes sense.
and then the machine is wrong.
Can't judge you.
Because Siri is.
Okay, sorry. Questions?
My mother has a habit of calling me and go, "Oh, hi, you're home?" A, you called me.
Yeah, I was just trying to make sure that the F1 was going to be a no bond.
B, why did you call if you didn't
It was no
expect to
bond.
reach me?
So. If you heard her, that's why I didn't say anything.
Seriously, oh, hi, you're home?
If I really feel like it's important, I'll be like, Judge, can I be heard on bond?
I still have a phone line, a landline.
Sometimes I'll ask for an elevated bond, especially on the
And an answering machine.
like I had one recently where
But I don't have voicemail on my cell
there was a
phone.
road rage and the guy pulled out a gun and shot into the
If you
car.
need to get a hold of me, call me
So
back.
I was like, I need an elevated.
I talk all day long. By the time I go home, I'm spent. I'm done. Done. My husband's like, what do you want for dinner? Don't ask me. I make decisions all day. You pick dinner.
It's really nothing too
Settling
crazy.
ties all day long, you know? I'm like,
Ooh, I had a guy that was accidentally released from jail, and he was supposed to be no bond in Polk County.
As you can
They like
tell.
accidentally let him out. They found him at a strip club actually when they went to pick him up. He didn't leave.
wow.
And he was like, "You guys are so dumb. You guys let me out. What's going on?" Like on the first appearance camera. It was so funny.
That Miscellaneous was coming with us to IAs and
I was like, "No bond, Judge."
Right, and so we were talking about you, and I was thinking
He had like
about
finished a prior
birthday. Was it your mom?
a case, like a sentence he had, and they accidentally didn't realize that he had another case open for murder. I know. It's craziest thing.
Did you make anything paleo? That's so cool. She just looks it up and does it? That's so cool.
Because she went to 4-day group, like, maybe like 10 years ago. But she always.
But I think the most important thing is just making sure that those conditions for DV get put in. No contact, no weapons, no drugs or alcohol. I know it sounds weird to say no drugs, but I mean, people get in trouble all the time for drugs, so that is a way that we can drug test them, and if they're on pretrial release, and new charge if they violate pretrial release.
Let me know when you got everybody. Hi.
Hello, ma'am. I got 2 of the 3 up.
That's fine. Who's the person
Oh.
standing at the mic?
This one here is Jesse Smith.
This is the
Thank
weird
you.
one,
Hi, Mr. Smith. I'm Judge Young Savage.
How you doing?
right?
Fine, thank you. You're here for first appearances. Let you know we are being recorded. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney, and if you can't afford to hire one, I'll appoint one for you if you qualify. Looks like you were arrested for possession of a controlled substance and possession of paraphernalia. And I'm going to ask the state, do we have any information about how the substance was identified as meth? Assuming they're still requiring field tests.
1 second, Judge. Yeah. They have 24 hours, Judge?
Yes.
Thank you.
So there's probable cause for possession of paraphernalia. That bond will be stayed. The court will exercise a discretionary 24-hour pass on the controlled substance. So, Mr. Smith, here's what you can do. If you want to post the bonds you have, you're allowed to. If you can't or you don't want to, we're going to reset you for tomorrow. The state attorney's going to see if there's anything else that they need me to read with regard to the possession of the controlled substance. If there's not, that one will probably be an ROR. If there is, I'll review it and I'll let you know what the bond is set at after that, okay?
Okay.
Do you need a public defender in the meantime?
Yes.
All right, PD appointed.
To just staying the person at 1,000.
The second one. No, well, it just stays where it's at.
Okay.
The court makes no ruling as to count one with the 24-hour pass.
Okay.
Thank you. See you tomorrow. And who else do you have? You have Hostos?
Hostas?
Okay.
Your Honor, we waive the formal reading of the charges at this
Thank you.
time.
Giovanni Hostos. Good afternoon, sir. Please say your name.
Giovanni Hostos.
Thank you. 1, 2, 3, 4, 5, 6. All right, sir, you were arrested for 6 counts, and I'm not going to say the specifics, but of not reporting information that you are otherwise legally obligated to report. And there is probable cause in this affidavit. PTR, any history?
These are added charges, Judge. The defendant is arrested for similar or same charges as today, and a violation of probation of the original charges, no bond. That is all, Judge.
And let me clarify, it's 2 counts of not reporting one specific type of information and 4 counts of providing false information. So just to make that a little bit more clear, but the public defenders don't want me to go into more detail out loud, okay? That's why, are you okay with that? All right. And so bond will be set at $500 each count, and the court is going to prohibit you from having any access to social media. Next court date?
Next court date on demand.
That means they'll let you know. Thank you. Oh, you know what I just realized?
Tab done.
Although I knew that we were being live streamed, I mean, I know that IAs are live streamed. While we were on pause, I forgot that the live stream just still continues.
Oh.
Judge, quick
I
question.
forgot. I didn't even realize it was.
For hostels, are we appointed?
Which one?
The one we just did.
Yes, he said
Okay.
yes.
Okay.
Yeah, I asked him, he said yes.
Okay, I missed it.
Yeah. As long as they say yes, I'll do it, but I don't want to just go off of no affidavit and no request for a PD. Because I'm not gonna make you all do work that you don't need to do. If they're gonna turn around and hire a private, then they're gonna have to do a substitution of counsel, and that's a nightmare. Then you're on the hook until you're off the hook, and I don't like that.
Exactly. Thank you.
You're welcome. See, if you came to my division, I would protect you.
Yeah. Arend-
Very protective of my state and my PDs.
Judge Arendis protects us too.
Does she?
Yeah.
From what? I wasn't listening. From what?
No, just in, like, I always try to make sure that the people that work in my division, we work as a team, and that we work to the best of our ability to reach a just decision or a just point in what we're doing. And I particularly don't like assigning public defenders to cases where I don't know for sure the person is seeking a public defender, or if there's a possibility they're gonna go hire a private, because I don't think the public defender should be spinning their wheels working on cases that the person's gonna ditch them on.
Yeah.
And their time is valuable, and they should be spending it on people who they will ultimately represent.
Mm-hmm. Is this all we have?
No, we have one more.
Forgot.
A lady.
What happened
I
to
think they're trying to find her.
What happened to Frajola? Did he bond out?
I don't know. Brizola? Who?
Oh, not Frajola, Vaughn.
Vaughn, he bonded out.
That's what I thought. I was saying the officer's name. Yeah, the DUI people, they usually bond out.
Judge Arendis was my mentee, so I hope that she does some things the way she and I discussed were advisable. But she's also very smart and very
This one?
clever, so I'm sure she comes up with a lot of really
When you can't find
good, appropriate things as well.
So a lot of the times when you can't,
She has mommy
isn't
voice,
found,
I call it.
and you know
Gives
by reading it
little
that
lectures
there is no
that
PC
sounds
for
like a
it.
mom scolding a kid. I'm like, did you use your mommy voice?
Yeah, that's what I'm talking about.
Yep.
You just ask for 24 hours. You email
There's a debate
the
tonight,
person who's
sheriff's
going to
office
be
forum, the people running for sheriff on Facebook through,
for Orange or Osceola.
you could watch it without participating, you could just pay attention to it.
Orange or Osceola.
Osceola.
My friend is running for Orange sheriff.
Oh,
Andrew Darling.
very nice.
We went to law school together.
I
But
went to law school with a guy named Scott Justice. So we told
Oh.
him he had to run for Supreme Court.
That's great.
Be Justice.
Um,
You have to look him up.
So you would want to email the officer and the IA people, like whoever's going to be doing it tomorrow, I'm going to tell them. And I'm going to reach out to the law enforcement officer later. Which I don't have this guy's number, so I'm probably going to have to talk to Wanda. Wanda has everybody's number.
Hector's wife.
Or Hector too. But Wanda, she's my go-to. And so what they'll do is they'll send you just request them to file a new affidavit. So the issue with this one is that there was no field test done. Or there probably was, but he just didn't write it in there. So that's part of what you need for PC.
You can't watch, but it's just watching. Yeah.
Where'd you go to law school?
Region in Virginia Beach.
What? Oh, in the primary. I see. Yeah.
We're allowed.
I get you. I was gonna say, yes, you can vote.
I've never really tried and do it more than the one, but yeah.
Because if it had been done, let's
Yeah, but I still would like to see what they have to say. I can't vote in this primary.
gonna have the information.
Then nothing really crazy happens. Like you'll just get ROR'd on that. So the chart, it's not like a big deal. Like
Go to the Osceola.
you can still file information and stuff on it later, and
page.
which we'll have to do
Forward
anyway.
this to you?
But it just
You can watch it there.
we can't do a bond on it.
Mute everything. Nobody will even know.
So you'll get ROR'd if you don't.
That's how I
He has
watched the
PC was found on the paraphernalia.
debate
So
forum. Hello, good afternoon.
Good afternoon, ma'am.
Hi, what's your name?
Kamala Mirage.
Thank you, Miss Mirage. Give me 1 sec to turn to the right page. Okay, so Miss Mirage, you have 2 cases that you're set for first appearance today. You were arrested on a warrant for failure to appear for arraignment with Judge Arendis, and that's a 0 bond. And then you also have a new charge for resisting without violence, and I read through that paperwork, and there is probable cause for that as well. I will let you know we are being recorded. You do have the right to remain silent. Anything that you say can be used against you. You have the right to an attorney, and if you cannot afford to hire a lawyer, I will appoint one if you qualify. Now, I'm going to ask an officer from pretrial release who's here with me in the courtroom if he has any other info for me.
The defendant has prior arrests going back to 2003, grand theft, petty theft, driving with license suspended in October 2019, another grand theft with petty theft, and a resisting officer without violence, which is the case that she FTA for, and a prior FTA on a prior case, which already did time served on. She's on county probation, but I believe she's going to be served with a VOP.
She was violated yet?
Yes,
She has your violation already.
Excuse me, Judge, I'm sorry.
Yes,
I do
ma'am.
apologize. I didn't understand, when I got locked up the last time, when I did the 23 days, ma'am, I thought that's what I was doing my violation of probation for, because you guys said that I missed court. That means I missed court 3 times, ma'am. I don't understand. I went to court June the 15th, right? That was supposed to be violation of probation. Ms. Schoonover said she was gonna violate me twice. But I did everything, but she says because of the coronavirus, once I go to court, everything will be dropped, because I did everything that I was supposed to do, ma'am.
All right, let me take a look. What's your date of birth?
January 3rd, 1979.
All right, I'll look it up for you.
If I get in trouble, ma'am, I have no problem with serving my time. But ma'am, when the officer came to arrest me last night, he saw that it was a battery on an officer with no,
Resisting without.
yes, ma'am.
Yeah.
So he was very aggressive with me, ma'am. I swear to God, if you look at I'm not aggressive with anybody. I'm not aggressive. The other officer that arrested me initially, when he came to arrest me for the grand theft, that was dropped.
Ms. Mirage, I suggest you don't keep talking about the facts of your case. This is being recorded.
Defender talking. Just to let you know who's talking. I know you can't see him, you can only see me.
Yes, ma'am.
One of the public defenders here in the courtroom is advising you, suggesting that you not talk about your case. Because what I just told you about being recorded,
Yes, ma'am.
yeah, I'm just letting you know what he said.
Yes, ma'am.
All right, so let me tell you, I'm looking at the violation of probation case, 19 MM 3816. You got put on probation in February, and then a violation was filed in June. You were given a court date of July 27th with Judge Arendas, and that's when she said you didn't show up, and she issued the failure to appear.
Excuse me, ma'am.
Yep.
The court dates that was sent to me was June.
No, this says July. I'm reading it right here.
Ma'am, I swear to God, I did not receive that.
Well, it's 519 Bromley Court. We got no returned mail. None of the mail was sent back to us.
Excuse me, ma'am, I'm so sorry, but if I got out of court on the 23rd, why would I not show up to court? Please, ma'am, why would I not come to court if I know it's gonna get me in trouble, ma'am? I just got a nursing job. Again, I just got rehired.
Ms. Mirage, I'm sorry, I can't answer that question. I don't know why you would or you wouldn't. I'm just reading you the file. I wasn't there either. So I'm just telling you what the file says. We also sent a courtesy copy to Ms. Perez, who had represented you before, just in case.
Ms. Perez didn't get in contact with me either, ma'am.
Well, but if she doesn't represent you in the violation of probation, she's not obligated to. But we sent it to her just to be on the safe side in case you were gonna go back to her and use her. So that's the reason why you have 2020 MM 142, which was a petty theft case closed. It's closed, but I'm trying to see about the dates. In that one, you pled in February and you got credit time served. So that wasn't something you just got out of jail for. And those are the only other things that were going on at this time. You had a 19 CF 3731, that's closed.
Driving with license suspended.
All right.
And then the grand theft.
And that was closed in January.
And then the grand theft that I'm supposed to be on probation for, that you guys dropped the grand theft, so you guys left me with the battery on an officer without violence, ma'am.
Okay.
And I was supposed to do the 8-hour aggressive class, and I did that.
I am not going to get into the details of the violation. What I'm just telling you is what the computer shows, that when you pled and got probation in February, the probation department filed an affidavit of violation on June 8th. And that's the one that was set for court, and then that court date was the one Judge Arendas said you missed. So it is what it is. Any mitigation you want to present, you're more than welcome to do that. But I was just trying to address your concern that you had no idea about this. This is what the file says. So that's why you're in custody. It doesn't mean you're guilty. It just explains why you're in custody. Guilt still has to be proven or admitted to, whatever the situation ends up being. Do you need a public defender to represent you?
Yes, ma'am.
PD will be appointed. Your next court dates will be? 500 on the new resisting and 0 as per the warrant.
Am I getting a bond, ma'am?
On the new arrest, yes, I gave you a bond.
On the one that I have now,
The new charge from yesterday, the new resisting, is a $500 bond.
Okay, but what about the other one?
The bond on the VOP was issued by Judge Arendas. It's set at 0.
Okay.
All right, so your public defender will be in touch with you.
Next court date for 2020, MM 1786 is still in jail, August 6th. If filed August 24th in courtroom 4E at 2 p.m.
August 24th?
They'll write it down for you.
And for 2019, MM 3816, next court date, August 6th in courtroom 5B at 8:05 a.m.
And if you are still in custody, we'll either have you brought over or they're going to do a video like this, depending on what's going on with COVID. So if you're in custody, we'll make sure you get transported for your court dates.
Yes, ma'am.
Thank you. All right, that's all we had from the jail, correct?
That's it, ma'am.
Great. We are adjourned until tomorrow at 1.
Good afternoon, Osceola County.
Good afternoon, sir.
I got the notes, officer, on Quinn, Rivera, and Coates. What's the deal with Mr. Coates?
He's COVID locked down.
Okay. All right, thank you.
Yes, sir.
And Mr. Quinn Rivera will be brought in the next group?
Yes, sir.
Thank you. All right, let's take Mr. Morrison's case first. Good afternoon, Mr. Morrison. Am I on mute? I am. Good afternoon, Mr. Morrison.
Good afternoon, Judge.
All right.
Good afternoon, Judge.
Are we ready for your admission?
We are, Judge.
All right, thanks. Ashley Emmond.
That video coming through clear to you, Judge?
Yeah, you're not green today.
First time for everything.
All right. For the record, we have Ms. Gonzalez joining us by video. We have Mr. Morrison joining us by video. I'm looking at Ms. Emmond at the jail facility. Good afternoon, Ms. Emmond.
Good afternoon, sir.
Ms. Emmond, we're going to place you under oath.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Emmond, I have an admission of violation of probation form. It looks like this document right here. It appears to have a signature on the second page. Did you have an opportunity to read and discuss this document with your attorney?
Yes, I did.
And did you sign it?
Yes, sir.
What your signature on this document tells me is that you have read and understood all the rights and obligations on this document. It also indicates that you wish to admit that you have violated your probation in 2018 CF, that's 3562, for the allegations contained in the affidavit, specifically allegations 3, 13, 12, 12, 13, and 15. Is that what you wish to do?
Yes, sir.
You understand that you have a right to have a hearing contesting the finding that you had violated your probation. At that hearing, the state of Florida would have had to prove to the court, to me, that you had violated your probation in a willful and material way. At that hearing, your attorney would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision. I'm sorry, let me back up. You don't have a right to remain silent at your VOP hearing. You could have participated in the hearing, had it recorded, and appealed any error that occurred in that process. You understand you are giving up all of your hearing rights because if the court accepts this admission. I'm going to go along with this agreement. We will not be having a hearing in this matter. You understand all that?
Yes, sir.
Is anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises other than what's written on your admission form?
No, sir.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir.
You understand if you are not a United States citizen, entry of this admission would cause you to be deported.
Yes, sir.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this admission could cause you to be involuntarily civilly committed. Do you understand that?
Yes, sir.
I've already read the sworn affidavit of your probation officer. I do find a factual basis with which the court can accept your admission, find that you appear to be alert, intelligent. You've had an opportunity to think about this decision and discuss it. I hear a dog. And discuss it with your attorney. State, is this a stipulated downward departure based on an uncoerced and legitimate plea bargain?
It is, Your Honor.
All right, thank you. Ms. Emmond, are you satisfied with the help of Mr. Morrison?
Yes, I am.
I would think so, based on the fact that this is a stipulated downward departure. It appears that your score sheet was indicating a minimum of almost 20 months in the Department of Corrections, so it seems like Mr. Morrison's done a significant amount of work for you. The court's going to go along with this agreement. I will revoke and terminate your probation in 2018 CF, say 3562. You'll be sentenced to 364 days in the Osceola County Jail, given credit for the time that you have already served, which is
247 days.
it's 247 days under your belt so far.
Yes, sir.
All the costs that you owed while you were on probation, you're still going to owe upon your release. I'll give you a period of 18 months to make any remaining payments to the clerk of the court. As long as you make payments, you'll have no issue with them. If you don't make payments, let them know what's going on. They'll try and work with you. If you don't pay and they don't hear from you, they could suspend your driving privileges. You understand?
Yes, sir.
30 days to appeal. If you wish to appeal, you must do it in writing. Can't afford an attorney. Won't be appointed for you. Anything further, Mr. Morrison?
No, Judge.
Ms. Gonzalez, anything further?
No, Your Honor, that's all I have for you today. May be excused.
Thank you for joining us.
Thank you, Your Honor.
See you, Mr. Morrison. All right. So I'd like to call the...
Judge?
Yes.
Just really quickly, there was communication between me and Attorney Blanco on the Bertrand matter.
Yes.
I believe he is going to be pleading to a DOC offer of a year and a day.
Okay.
I know he ran over to the jail to get things signed and whatnot. So I just want to let you know that in case what you were about to call was the Bertrand.
All right, thanks. I'm looking at Mr. Blanco right now. He is at the jail facility. Good afternoon, Mr. Blanco.
Good afternoon, Judge. I'm here.
Okay.
I got the plea form almost all the way done, and we should be ready to rock and roll. I worked it out with the state, and we're ready to go.
Okay, all right, let's get Mr. Bertrand's case handled and you on your way. Mr. Bertrand, good afternoon.
Good afternoon.
Mr. Bertrand, we're going to place you under oath.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
For the record, Mr. Blanco is joining his client, Mr. Bertrand, at the jail facility. I'm looking at them via video, or I'm also looking at Mr. Abreu on my computer screen, who is joining us remotely. I understand there's been a resolution, Mr. Blanco, and your client is going to enter an admission to the violation. Is that correct?
Yes, Judge. I worked it out with I worked it out with the state between this morning and now. That's why I decided to fly back over here. I hope that the court can understand me because I'm a little bit muffled. But it will be a resolution to both his cases. It's going to be the violation of probation and the new law violation.
All right.
Mr. Abreu, which I'm very thankful for, has offered a resolution to case a year and a day DOC with credit for time served, and these cases are to run concurrent with whatever credit he has. I think that his credit is back from March 5th.
No, because before I bonded out, I stayed, when they extradited me from North Carolina, I stayed in jail all of December and January.
Okay, well, the clerks will figure out the credit for time served on the cases.
Yeah, we'll tell you what we calculate, and then you can tell us whether that's contested.
No, and so I know that as far as the new law violation, it's from March 5th, okay? So I'm talking, the VOP might be something different. They'll figure that one out.
All right, thank you.
And he's going to plea with no contest or guilty as charged in the information and count in case 2020 CF 746. The Dwillis charge, I didn't know if it was charged as a M1 or an M2 because I didn't have the information in front of me.
All right, let me pull up.
It's charged as an F3
Thank you.
under 322.34, subsection 2C. Driving while license suspended 2 prior.
All right, that's the third-degree felony allegation.
Okay, it's an F3. Okay, that's fine.
All right, Mr. Bertrand, you are sworn. I think that you've had an opportunity to go over a plea form in 2020 CF 746. What that plea form is going to tell me once it's filed is that you wish to plead no contest to counts 1, 2, and 3 of the information, count 1 being possession of methamphetamine, count 2 being possessing drug paraphernalia, and count 3 being driving while license suspended with 2 prior convictions. Is that what you wish to do?
Yes, sir.
And the document is also, another document is going to tell me that you wish to admit that you have violated probation in 2019 CF 3500 for the reasons alleged by your probation officer. Is that correct?
Yes, sir.
On the new law offense in 2020 CF 746, you had a right to have a jury trial, and at the jury trial, Mr. Blanco would have been present with you. He would have cross-examined witnesses and examined evidence against you. You would have had a right to present your own witnesses, your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified. That would have been your decision after you talked things over with your attorney, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you're giving up all your trial rights because I'm going to go along with this agreement? We won't be having a trial.
Yes, sir.
You understand you had a right to have a hearing contesting the finding that you had violated probation in 2019 CF 3500. You would have had all the same rights at the hearing, except you don't have a constitutional right to remain silent on a violation of probation hearing. You could have participated in that hearing, and the state would have had to prove to me by a lesser standard, that's a preponderance of the evidence, it means a greater weight of the evidence that you'd violated your probation. You understand if I accept this resolution, we're not going to be having a probation hearing either.
Yes, sir.
Anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises on either of these cases?
No, sir.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you
No,
made?
sir.
You understand if you are not a United States citizen, entry of this plea would subject you to deportation.
Yes, sir.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of these admission and plea could subject you to involuntary civil commitment. Do you understand that? Understand all that?
Yeah.
That's the state of the law. It may not apply to you, but I got to advise you of that.
Okay. Good, because I was going to say that.
Okay. Fair enough. I don't see any sexual offenses on your score sheet.
I don't remember seeing any, Judge.
Actually, I don't have a score sheet. Mr. Abreu, can you send one over?
Judge, I just merged the VOP and the new law offense and just sent it to Tabitha right now.
All right, thanks. I'll ask for the clerk's assistance once again in getting us that score sheet. Thank you. Mr. Blanco, are you stipulating a factual basis on the new law offense for purposes of the plea?
Yes, Judge, stipulating for the purpose of the plea.
We'll accept that stipulation. I've also read the sworn charging affidavit and the violation of probation allegation. I find a factual basis on both cases. To accept the plea and admission, find that Mr. Bertrand, based on our discussions, appears to be alert and intelligent. He's had an opportunity to think about the decision and discuss it with Mr. Blanco. You satisfied with Mr. Blanco's help, Mr. Bertrand?
Yes, sir.
Seems like he wrapped it all up for you, and it's done a good job. You've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. On 2020 CF 746, counts 1 and 3, you'll be sentenced to 300 and what is that? A year and a day in the Department of Corrections. I think it's a leap year. As to count 2, you'll be sentenced to credit for time served. That's going to be what?
148 days.
We're showing 148 days credit for time served. Does that sound about right, Mr. Bertrand?
Yeah, it's
All right, I'll give you credit.
from March 5th, yeah, for the new case.
Oh, for the new case, yes.
Yeah.
I'll give you credit for the 148 days on both counts 1 and 3 as well. On the violation of probation case, that's 2019 CF 3500. Court's going to sentence you to a year and a day in the Department of Corrections. I'll revoke and terminate your probation in that case. You're no longer on probation. There's going to be costs owed on the new case as well as costs that were already owed on the old case. The new case, Madam Clerk?
The case is $418 court costs, a $100 cost of prosecution, $350 drug case fine, $100 contract attorney lien, and a $15 drug paraphernalia surcharge for a total of $983.
All right, there's $983 in new costs. I don't know what you owed on the violation of probation. I'm going to give you a period of 3 years from today's date to pay off those costs in both cases. You need to make payments to the clerk of the court. If you don't pay and they don't hear from you, they could suspend your driving privileges. You understand?
Yes, sir.
And Judge, Andrew Bray on behalf of the state, since the defendant scored a total sentencing points of 60.9, this is a downward departure and uncoherent downward departure between the state by agreement with the defense.
All right, thanks. Seems like Mr. Blanco's done an excellent job for you in securing a downward departure. The court's going to find the state of Florida is in the best possible position to make a recommendation to the state. I make a recommendation to the court for downward departure. I'll accept that recommendation. This is a stipulated downward departure based on an uncoerced and legitimate plea bargain. You're going to have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. Can't afford an attorney, won't be appointed for you. Let's talk about credit for time served on the VOP.
192 days.
We're showing 192 days on the VOP.
Yeah,
That one did have,
that reflects it. Yeah, that's about right, Judge. That's what I had.
So all that's.
So I think that it did encompass the prior time that you served, so we'll give you a credit for 192 days on the other case. Good luck to you, Mr. Bertrand. We're going to transfer you to Department of Corrections.
Judge, there was one other question I just had to ask the clerk, and I'm sorry to interrupt. This is the last thing. There was a monetary amount, I believe it was from a bond, right, Mr. Bertrand, that's supposed to be returned to him or give him credit for?
Yeah, you granted me my bond money back before I took the probation.
Yes, sir.
Ms. Nicole DePrez was representing me. I still never received that money.
Was it a cash?
Right. Did you go through
Yeah,
a bond
I
or was
paid
it
cash.
Okay. Do you want that back or you want that applied to your court costs?
They have to apply to the court cost.
Yeah, put it towards the court cost.
Okay. Any cash bonds will be applied to court costs. All right. I think that'll do it, Mr. Bertrand.
Perfect. Thank you so much, Your Honor, and I'll have him sign the forms and I'll scan them and send them to the state attorney.
Thanks for your efficient work, Mr. Blanco and Mr. Abreu.
Thank you so much, Your Honor. Have a great afternoon.
Sorry. One thing I forgot, Mr. Bertrand, I have to suspend your driving privileges for 6 months on adjudication in count 1. I have no objection to you obtaining a work permit should you qualify.
Understood, Judge.
Thanks.
Understood, Judge. Yeah, you heard it.
Let's do Mr. Baird's case. All right, I see Mr. Franco in our waiting room. Mr. Franco, good afternoon.
Good afternoon, Your Honor.
All right, we are calling Mr. Rosario Andino. Mr. Rosario Andino? Miss Rosario Andino.
Yes, sir.
Good afternoon, Ms. Rosario Andino.
Good afternoon.
Ms. Rosario Andino, I'm looking at your attorney, Mr. Franco, here on my computer screen. We also have Mr. Baird present, who is representing the state of Florida. Mr. Franco, can you give me an update?
Yes, Your Honor. At this point, we will be admitting the violation and ourselves at the mercy of the court.
All right, thank you. I don't know if you heard that, Ms. Rosario Andino. Your attorney is indicating that you wish to admit that you have violated probation. Is that what you wish to do?
Yes, sir.
All right.
I have a question. Can I have a interpreter, please?
I'm sorry, I can't hear you.
Can I get an interpreter, please?
An interpreter? Yes, of course.
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Bar Interpreter. The interpreter has been sworn in already today.
Good afternoon, Mr. Morales. We have Miss Rosario Andino present at the jail. This is case number 2013 CF 1217, and you'll be interpreting over the PA system.
Yes, Your Honor.
Good afternoon, Miss Rosario Andino.
Buenas tardes, señora Rosario Andino.
Buenas tardes.
Good afternoon.
Ms. Rosario Andino, I am looking at your attorney, Mr. Franco, on my computer screen. He is joining us remotely. I'm also looking at the prosecutor, Mr. Baird, who is with me here in court.
Señor Andino, tengo a su abogado, el señor Franco. Él está asistiendo a esta vista de manera virtual o por medio de la computadora. Y también puedo ver al fiscal, el señor Baird, que está aquí.
If at any time you cannot hear the court or anything that's going on, please so indicate to the interpreter and he'll let me know.
Si en algún momento usted no puede escuchar lo que se está diciendo aquí en la sala, hágaselo saber al intérprete y entonces el intérprete se lo informará al juez.
Okay.
Mr. Franco, have you presented Ms. Rosario Andino with an admission form that has all of her rights on it?
Unfortunately, Your Honor, I have not. I can. I'm not sure with the logistics with I guess do that quickly, but I'm open to doing that.
We're having a very difficult time hearing you. Your transmission is a little bit scrambled. We may be able to solve that. I've got the interpreter on the PA. I'm not sure your client's going to be able to understand what you are saying. I understood that you had not presented her with a violation of probation hearing form. I think we may have some of those at the jail facility. Officer, do we have a VOP admission form in Spanish out there?
Yes, sir. One moment, please.
All right, thank you.
Your Honor, the interpreter is going to go ahead and interpret what Your Honor said. The interpreter couldn't hear what the attorney said.
Understood.
Tengo entendido, señor Franco, estamos teniendo dificultades escuchándole. Está un poco distorsionada la conexión. Lo que entendí es que no le ha dado el formulario de reconocimiento de incumplimiento del régimen de probatoria con los derechos. Voy a preguntarle a alguien en la cárcel si tienen uno en español. Quizás tenemos uno allá en la cárcel en español.
Sí, ya me lo entregaron.
Yes, it was handed to me already.
Have you had a chance to read that document, Ms. Rosario Andino?
Señora Rosario Andino, ¿tuvo usted la oportunidad entonces de leerlo?
Sí, lo estoy leyendo en estos momentos.
Well,
No tenía la oportunidad anterior, pero sí lo estoy leyendo en estos momentos.
Okay. Well, I'm reading it as we speak. I had not had a chance to read it earlier, but I am reading it right now.
All right, Ms. Rosario Andino, I want you to have an opportunity to read that document. So I'm just going to have you have a seat. I will ask the interpreter. We'll call back the interpreter. Mr. Franco, we will, if you can hold on with us, you can mute your microphone. You may think about disconnecting and reconnecting. We're having a very difficult time hearing your audio. And if we can't resolve that issue, we may resort to having you call in. But I'm not sure how I can have you and the interpreter at the same time on our system. So if you'll just stand by, I want Ms. Rosario Andino to read this document.
Señora Rosario Andino, quiero que usted tenga una oportunidad para poder leer el documento, así que tome asiento, lea el documento y después pues volveremos a convocar su caso y llamaremos al intérprete para atender su caso también.
Okay. Gracias.
Okay, thank you.
You'll have a...
Your Honor, can you hear me now by any chance?
Yes, we can hear you much better. Now we can't.
How about now?
That's better. Yeah, that's much clearer. All right, so we're going to stand by on this case. So if you'll stand by with us, I'm going to go ahead and mute my microphone for you guys. No, I can't do that. I've got to take another.
Your Honor,
I'm sorry.
do you want the interpreter to hang up or do you want the interpreter to hold on for a couple minutes?
Mr. Morales, I will just give you a call back.
Okay, thank you.
Thank you for your help.
Sure.
All right, sorry for the delay, Mr. Baird. Is Zaldana ready to go? Zaldana?
Yes, Your Honor, and I should have a score sheet as well. I did provide that to.
Thank you.
It's the one that was emailed to Ms. Hafner
Thank you
earlier.
for that courtesy. Good afternoon, Mr. Zaldana.
Good afternoon.
Mr. Zaldana, I have a plea form. It is that admission form. You've already heard me go over that with somebody this afternoon. It looks like this document. It's front and back, and it's signed on the second page. Is that your signature?
Yes, sir.
What your signature on this document tells me is that you understood all the rights and obligations contained on this document, and you've read it, had enough time with your attorney to discuss it. Is that correct?
Yes, sir.
It also tells me that you wish to admit that you have violated your probation in 2018 CF 4306. That's a violation of, the original charge was 943.0435 subsection 4 subsection B. Is that what you wish to do?
Yes, sir.
You understand you have a right to have a hearing contesting the finding that you had violated your probation. At that hearing, the state of Florida would have to prove to the court by a preponderance of the evidence that you had violated your probation in a material and willful way. At that hearing, your attorney would have been with you, and she's present here in court. She would have cross-examined witnesses and examined the evidence against you. You would have had a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have participated in your hearing, had it recorded, and appealed any error that occurred in that process. You understand you are giving up all of your hearing rights, because if I accept this admission, I will go along with this agreement. We will not be having a hearing in this matter. You understand that?
Yes, sir.
Is anyone forcing you or pressuring you into making this decision?
No, sir.
Has anyone made you any promises other than what is written on your admission form? Would you mind tapping on that microphone for me? We can hear it. If you could get a little bit closer to it, I'd appreciate it, because we're having a difficult time hearing you when we're actually recording your responses. So the last question I asked, has anybody made you any promises other than what's on this admission form?
No, sir.
Under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir. I mean,
Is that
sir.
no?
No, sir.
Understand if you are not a United States citizen, entry this admission would cause you to be deported? You understand that?
Yes, sir.
And you'll be considered for involuntary civil commitment at the conclusion of this sentence. Do you understand that?
Yes, sir.
I've already reviewed the sworn affidavit of your probation officer. I do find a factual basis with which the court can accept your admission. Find that you appear to be alert, intelligent. You've had an opportunity to think about this decision and discuss it with Ms. Chrysler. Are you satisfied with her help?
Yes, sir.
You've indicated to me no one has forced you or pressured you into making this decision, and you do so of your own free will. Is this a downward departure?
Yes, Your Honor.
Yes, Your Honor, Lauren Day for the state, a stipulated downward departure pursuant to a legitimate uncoerced plea bargain resulting from depositions that were taken on this case.
All right, thank you. State's in the best possible position to gauge the strengths and weaknesses of their case and recommend a downward departure to the court. I will accept that recommendation from the state. Seems like your attorney's done a good job for you. You've indicated to me no one has forced you or pressured you into making this decision. You do so of your own free will. Court will accept your admission to violating probation in 2018 CF 4306. Court is going to sentence you to 18 months in the Department of Corrections. Your probation will be revoked and terminated. The court will give you credit for the time that you have already served,
279 days.
which is 279 days. All the costs that you owed on probation, you're going to still owe upon your release. The court will give you a period of 24 months from today's date to make payments to the clerk of the court. As long as you're making payments, everything will be fine. If you don't make payments, let them know what's going on. I'll try and work with you. If you don't pay and they don't hear from you, they could suspend your driving privileges. Do you understand?
Yes, sir.
You're going to have 30 days from today's date to appeal the judgment and sentence to the court. If you wish to do so, you must do it in writing. If you can't afford an attorney, one will be appointed for you. Good luck to you, sir. We'll transfer you to the Department of Corrections custody.
Thank you, sir.
All right, let's just go ahead and call the Coates case. This is 2020 CF 574 and 2015 CF 1737 and 2016 CF 1778. Mr. Abreu, apparently Mr. Coates is on a lockdown pursuant to the COVID-19 protocol. The court was eager to move forward in a resolution or a hearing remotely, but I cannot do that under due process considerations without the defendant being allowed to participate. So the court is inclined to reset Mr. Coates' violation of probation hearing. I'm going to give it a hearing date of September 3rd at 9 o'clock.
Understood, Judge.
And if there's a change in resolution, obviously, please notify the court and we'll handle it. As far as the pretrial case goes, I guess we're going to put that on the September trial docket. That's going to be September 8th through the 25th. I've got some time on Wednesdays between now and then if you want to set it for a plea conference. I'm happy to accommodate that.
Thank you, Your Honor.
Judge, that's the last matter I believe I have. May I be excused?
Of course.
Thank you, Judge.
All right, I have Randall Quinn. Is that one ready to go?
Yes, Your Honor.
All right,
Mr.
thank
Quinn
you.
is ready. I believe he's in the second group.
Ah,
I stand corrected, Judge. That is also mine.
all right, he's on our second group, so we're going to have to wait on that one. We're going to go back to our interpreter case, Ms. Rosario Andino.
Good afternoon, Your Honor. This is the Spanish interpreter.
Good afternoon, Ms. Arroyo. Have you been sworn today?
Yes, I have.
All right, thank you. We have present Ms. Rosario Andino at the jail facility. This is case number 2013 CF 1217. Ms. Rosario Andino, I'm still looking at your attorney. He's still present and appearing remotely.
Señora Andino, sigo viendo a su abogado, quien está aquí presente y está conectado de manera remota.
Is it pronounced Franco or Franco?
Either way.
Se pronuncia Franco o Franco. Cualquiera de las dos maneras, su señoría.
All right.
And hopefully, hear me, Judge.
I can hear you much better. Thank you, Mr. Franco. Go ahead.
¿Me oye bien? Sí, le oigo mucho mejor. Gracias, señor Franco.
Ms. Rosario Andino, have you had a chance to read that violation of probation admission form?
Señora Andino, ¿usted ha tenido la oportunidad de leer el formulario de admisión que tiene ante usted?
Sí, señoría.
Yes, Your Honor.
All right, I'm going to have you sign that document today. I'm also going to ask your attorney, Mr. Franco, to supplement the court file with the terms of the ultimate plea. Well, there is no terms of the plea, so you don't need to supplement anything, Mr. Franco. We'll take that form when she signs it.
Le voy a pedir a usted que firme el formulario aquí hoy día y le voy a pedir al licenciado Franco que interponga un documento suplemental donde constan los términos del convenio. Sabe que no existen términos en este convenio, por lo tanto, el licenciado Franco no tiene que presentar ningún suplemental, simplemente el formulario que usted está firmando.
So after you've had a chance to read all your rights and obligations, do you understand your rights and obligations on the violation of probation hearing?
Después de haber leído todos los derechos y las obligaciones en ello, dígame, ¿usted ha entendido cada uno de los derechos y obligaciones que tendría usted en la audiencia por incumplimiento de su régimen?
Sí, señor.
Yes, Your Honor.
Mr. Franco has told me that you wish to admit that you have violated probation in 2013 CF 1217. Is that what you wish to do?
El licenciado Franco me ha indicado que usted desea reconocer haber incumplido con su régimen en el caso 2013 CF 1217. ¿Acaso eso es lo que usted desea hacer?
Sí, señor.
Yes, sir. Yes, Your Honor.
Mr. Franco, yes?
Dígame, licenciado Franco.
Mr. Franco, can you hear me? Mr. Franco, can you hear me? hear me, Mr. Franco? Ms. Rosario Andino, the call dropped. I'm going to try and rejoin communication with your attorney.
Señora Rosario Andino, parece ser que se ha caído la llamada. Voy a intentar reconectarme con su abogado. Okay.
The video, I don't know if you can hear me, but the video is, I have to reconnect.
All right, thank you. Okay. You did reconnect, or you are attempting to reconnect?
I didn't physically disconnect yet, but the video's a little bit, I don't know if you can see it, I can't see the green screen. I can try reconnecting, but I can definitely hear you.
Sorry, Your Honor, the interpreter will not be able to interpret what he said. It's all breaking up, and it's hard to understand what he said.
Understood, yeah. We're having some audio difficulty between your attorney, Mr. Franco, and the court.
Señora, estamos teniendo problemas auditivos con el señor Franco y el juzgado.
Mr. Bray?
Judge, perhaps a suggestion if Mr. Franco would reconnect using his cell phone.
Su señoría, permítame sugerir que el señor Franco vuelva a conectarse utilizando su celular.
I can see you now perfectly. I don't know if you can see me, but I can try my cell phone because that got better luck. And I apologize, Your Honor, that never happened before.
No problem. We're troubleshooting from here, Ms. Broadway.
Your Honor, would this result in the defendant's release? This plea?
It's a plea to the bench.
I was wondering if I could step in as a friend of the court to help finish it up, but
Oh, thank you.
I can't.
I appreciate that.
Your Honor, can you hear me now, by any chance?
Yeah, I can hear you good now, but before it was very digitized.
I'm working on connecting by the cell phone, but I didn't want to hold forward about. I guess we could continue. Well, I guess connect myself. I really apologize.
Not a problem. We're just having some communication difficulty. So if you can disconnect and try and reconnect with your cell phone, we'll see if it's an improvement. Apologize for the delay, Ms. Arroyo.
No problem, Your Honor.
Ms. Rosario Andino, we're just trying to get your attorney to reconnect with us.
Señora Rosario Andino, simplemente estamos intentando hacer que su abogado se vuelva a conectar a esta llamada.
Okay.
Your Honor, can you hear me?
Yes, Mr. Franco, we can hear you. Can you hear us?
Yes.
Okay. Do you have any video?
I can see you. I don't know. I don't know if you can see me.
I can't, but that's less important.
All right, perfect. I'm ready, Your Honor, to proceed.
Thank you. That's much clearer. All right, Ms. Rosario Andino, we have a good connection with your attorney, Mr. Franco.
Señora Rosario Andino, hemos conseguido una buena conexión con su abogado, el licenciado Franco. Good.
So I had asked you before, and I want to repeat that, whether you wish to admit that you violated probation in your case 2013 CF 1217 for the reasons alleged in the sworn affidavit by your probation officer.
Se lo pregunté previamente y le voy a repetir nuevamente y es, ¿usted desea admitir haber incumplido con su régimen en el caso 13 CF 1217 bajo las razones que se agregó en el affidavit juramentado por el oficial en su régimen?
Sí, señor, sí, señor juez.
Yes, sir. Yes, sir. Yes, Your Honor.
Do you understand that you have a right to have a hearing contesting the finding that you had violated your probation?
Usted entiende que tiene todo el derecho a que se celebre una audiencia donde podría usted discutir los hallazgos que se han establecido con respecto a su incumplimiento?
Sí, yo entiendo eso.
Yes, I understand that.
At that hearing, Mr. Franco would have been with you and he would have cross-examined witnesses and examined evidence against you.
En dicha audiencia, el licenciado Franco estaría ahí con usted interrogando a los testigos de carga y contravirtiendo las pruebas en su contra.
Yo entiendo.
I understand.
You could have participated in that hearing and presented your own witnesses and your own evidence.
Usted pudo haber participado en la audiencia presentando sus propios testigos y sus propias pruebas.
You could have had your hearing recorded and appealed any error that occurred in that process.
Y pudo hacer que la audiencia fuese grabada y apelar cualquier error que se cometiese en esa diligencia.
Do you understand?
I understand.
Okay. Do you understand if I accept your admission, I am going to craft a sentence that I think is reasonable, and we are not going to be having a hearing in this matter?
Usted ha entendido que si acepto su declaración de admisión, impondré la sentencia que yo considere que sea razonable y no se va a celebrar audiencia en esta causa.
Entiendo y confío que el señor juez es un juez justo y entiendo esa parte, sí.
I understand and I trust that Your Honor is a fair judge, and yes, I do understand that part.
Has anyone forced you or enticed you to plead today?
¿Alguien la ha forzado o le ha incitado a usted presentar su declaración de hoy?
No, señor juez.
No, Your Honor.
You understand that no one has made you any promises as to what the possible sentence will be.
Usted ha entendido que no se le ha hecho ninguna promesa alguna con respecto a cuál sería la sentencia posible.
Sí, yo entiendo.
Yes, I understand that.
Mr. Baird, is this an F1 or an F2?
Your Honor, this is a first-degree felony. This is a second-degree felony.
Licenciado, ¿es esto un delito grave de primer grado o de segundo? Su señoría es uno de segundo grado.
Ms. Rosario Andino, do you understand I will listen to the state and your attorney? I will take a look at the score sheet for you, which will give the court some guidance. And go ahead.
Señora Andino, usted ha entendido que le voy a escuchar al fiscal y también a su abogado y me voy a acatar a la hoja de cálculo, lo cual me orientará un poco.
Sí, entiendo.
Yes, I understand.
You understand that the maximum penalty for any second-degree felony is up to 15 years in prison.
Usted ha entendido que la pena máxima para un delito grave de segundo grado sería hasta un máximo de 15 años de penitenciaría.
Sí, entiendo.
Yes, I understand.
You understand if you are not a United States citizen, entry of this admission would cause you to be deported.
Ha entendido que en caso de no ser ciudadana de los Estados Unidos, el presentar esta declaración de admisión causaría su deportación. I understand.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making this afternoon?
¿Se encuentra usted bajo los efectos de algún tipo de alcohol o droga o padece usted de algún trastorno mental que le impide entender las decisiones que esté tomando usted aquí hoy día?
No, no estoy bajo ninguna influencia de nada, señor.
No, Your Honor, I'm not under the influence of anything.
Based on our discussions, I'm going to find that you appear to be alert and intelligent.
Basado en las conversaciones que hemos tenido, determino que usted actúa conscientemente.
that you are entering this admission of your own free will.
que presenta esta declaración por su libre albedrío.
You've indicated you'd have an opportunity to read the plea form.
Usted ya nos ha indicado que ha tenido la oportunidad de leer el formulario declaratorio.
Do you have any remaining questions for Mr. Prado?
¿Le queda alguna duda o pregunta que hacerle al licenciado Prada?
No sobre el formulario, no. Ya.
No, not regarding the form. I already read that.
Court is going to accept your admission that you have violated probation in 2013 CF 1217. The court will now hear argument as to sentences. Mr. Franco.
Este juzgado va a aceptar su admisión de incumplimiento de su régimen de libertad vigilada en la causa 13 CF 12117 y estaré dispuesto a escuchar cualquier argumento que desean presentar con respecto a la sentencia. Licenciado.
She's been incarcerated since February, and she served about 48 months in total.
Ella se ha encontrado encarcelada desde febrero y en total ha cumplido 48 días.
She scores 52 months incarceration, and the state had made an offer of 60 months.
Ella ha acumulado un total de 52 meses en la hoja de cálculo y la Fiscalía ha extendido una oferta de 60 meses.
The violation here is for a DUI that involved no crash and no injuries.
El acto de incumplimiento en esta causa es por conducir bajo los efectos en la cual no hubo ningún accidente ni tampoco hubo lesiones.
And the reality is that she's already served much more time than most people who commit multiple DUIs.
Y la realidad es que ella ha cumplido mucho más tiempo que las personas que cometen múltiples casos de conducir bajo los efectos.
Especially now that usually the state makes offers of diversion in first-time DUI cases.
Especialmente siendo que hoy día, en general, la Fiscalía extiende ofertas para el programa alternativo al proceso penal.
Your Honor, we're asking for a time-served sentence for several reasons.
Su Señoría, por varias razones estamos solicitando una sentencia de condena cumplida.
Ms. Rosario is not the typical defendant.
La señora Rosario no sería uno de los acusados típicos que vemos.
He was almost done with probation when this unfortunate incident happened.
Ella casi había cumplido con su régimen cuando esta situación desafortunada ocurrió.
She had about a year left.
Le quedaba casi un año por cumplir.
And basically, Ms. Rosario is actually quite an amazing person because after the unfortunate incident that happened in 2010, she's worked hard to reintegrate herself into society and be a productive human being.
Y básicamente la señora Rosario es una persona increíble, ya que después que todo este incidente desafortunado ocurrió en el 2010, ella se puso a trabajar bien duro para poder reintegrarse nuevamente en la sociedad y ser una persona productiva.
She had 2 jobs and has a job waiting for her when she is released.
Ella tenía 2 trabajos y cuando se ha puesto en libertad tendrá un trabajo esperándole.
She was also going to school part-time and she will be continuing her studies when she is released.
Y de manera de tiempo parcial iba a la escuela y va a continuar una vez que se ha puesta en libertad.
She takes care of her 3 children and she actually has a young grandchild.
Ella cuida de sus 3 hijos y, de hecho, tiene un nieto.
One of the children is special needs and is late and receives SSI disability.
Uno de los menores tiene necesidades especiales y de hecho recibe discapacidad.
And the truth, Your Honor, is that in these strange times, every day in prison is another day where COVID-19 could break out. And COVID-19 is especially dangerous in the sheltered environment of jails.
Y en estos días que nos encontramos, cada día que transcurre es un día que puede haber un brote de COVID, especialmente en un centro cerrado como las cárceles.
And it is especially dangerous for Ms. Rosario, as she unfortunately suffers from asthma to the extent that she has even received medication from the jail.
Y es aún sumamente peligroso para la señora Rosario porque ella desafortunadamente padece de asma y de hecho está recibiendo medicamentos ahí en la cárcel.
And at the end of the day, Your Honor, I don't want to minimize the severity of this offense, but it is not a violent offense, and she's already done enough time, and her family is suffering every day that she's not with them. They depend on her financially.
Y al final del día, no quiero decir que se debería de minimalizar el tiempo que debe de cumplir, pero no cometió ningún ilícito violento y ha cumplido suficiente tiempo ya encarcelada y cada día la familia está sufriendo porque ellos dependen de ella para ingresos.
Your Honor, at the end of the day, we believe Ms. Rosario has been punished enough and she's done her time, and we would ask that she be allowed to be released so she can continue making herself a productive member of society and somebody that her family can look up to in terms of her rehabilitation story. Thank you, Your Honor.
Y a final del día, nosotros consideramos que la señora Rosa ha sido castigada suficientemente y ya ha cumplido su tiempo y debería de ser permitida, de ser puesta en libertad, porque así se le permitirá a ella poder seguir siendo productiva con la sociedad y ser una alegría para la familia cuando la ven a ella rehabilitándose.
Thank you, Mr. Franco. Mr. Baird?
Gracias, licenciado. Licenciado Baird.
Yes, Your Honor. I'm going to be asking the court to consider 3 items here. The first is going to be the Criminal Punishment Code score sheet. It reflects the lowest permissible sentence of 52.05 months DOC.
Su señoría, yo voy a estar solicitando 3 puntos hoy día. El primero tiene que ver con el código de enjuiciamiento. La hoja de cálculo para el código de enjuiciamiento indica que se requiere 52,5 meses.
The affidavit of violation of administrative probation that includes the arrest report by Officer Rothschild on the DUI.
En el affidavit de incumplimiento de su régimen, lo cual incluye el informe de arresto que fue redactado por el oficial Rothschild, perito de casos de conducir bajo los efectos.
And the Kissimmee Police Department investigative narrative from the underlying case by Detective Barrio, an 11-page document.
Y el atestado de la policía de Kissimmee con respecto a la causa original que fue preparado por el detective Barrio, un documento de 11 páginas. ¿Se me permiten presentar estos documentos? Sí, su señoría.
Thank you. So, before I review these documents, Mr. Franco, does your request require a downward departure?
Antes de estudiar estos...
I did submit some mitigation letters that support what I was saying. I forgot to mention that as well. But we believe that there should be a downward departure. I'm sorry, I'm going to let the interpreter finish.
Antes de ponerme a estudiar estos documentos, licenciado Franco, ¿acaso usted está solicitando una pena por debajo de la mínima? Sí, su señoría, estamos solicitando eso y de hecho tenemos aquí cartas atenuantes que me olvidé mencionar previamente.
And the reasons that we're requesting a downward departure are not explicitly in the statute, But as Your Honor knows already, that's just a list that's not that doesn't involve all the mitigating circumstances that would possibly justify a departure.
Y las razones por las cuales estamos solicitando una pena que sea reducción de la mínima no es algo explícito en los artículos de ley porque, como sabe bien su señoría, es una simple lista que no contiene todas las circunstancias atenuantes que podrían justificarlo.
And specifically, we're requesting a downward departure based on her demonstrated rehabilitation. She takes care of 3 children, a grandchild. She has 2 jobs, is going to school. And combined with the fact that this is not, this at the end of the day is not a violent offense. It's not, I guess, I don't want to minimize the importance, but it's not as serious. It's not a violent offense that would justify more prison.
Y nosotros
COVID-19 situation, a few more months, assuming we're talking about a few more months in jail, I think is justified when it comes to exposing her to the risks of COVID-19 as somebody with pre-existing conditions.
Give me a second, counsel. Y reconocemos y solicitamos que se reduzca de la pena mínima, ya que nuestra cliente, la acusada, ha demostrado que ha podido rehabilitarse, que tiene 3 hijos que mantiene y un nieto, que ha tenido 2 trabajos, que ha estado yendo a la escuela y en combinación a ello, aquí no tenemos un ilícito violento. No es que estoy intentando reducir la seriedad de la acusación, ni tampoco eso, solo quiero justificar que no se requiere más tiempo de prisión. Además, si uno tiene en cuenta la situación que tenemos con el COVID, agregar más meses sería justificado, ya que le hemos explicado que esta señora, teniendo su patología, se encontraría a riesgo.
Your Honor, the defense is now requesting a downward departure. Ms. Rosario Andino is a violent felony offender of special concern based on the nature of the offense.
I'm sorry, counsel, could you repeat that? It didn't come through very clearly.
The defense is requesting a downward departure.
La defensa está solicitando una reducción de la pena mínima.
However, Ms. Rosario Andino is a violent felony offender of special concern under the statute.
Pero, sin embargo, la señora Rosario, en conformidad a la ley, se considera una delincuente grave violenta.
Ms. Rosario Andino was previously sentenced to 43.05 months in the Department of Corrections.
La señora Andino, que previamente había sido sentenciada a 43,5 meses en la penitenciaría.
The score sheet reflects a lowest permissible sentence of around 52 months in the Department of Corrections.
La hoja de cálculo refleja la pena mínima que se permite, que sería 52 meses.
Prior to the court offering a downward departure in this case, the court would first have to determine whether Ms. Rosario Andino poses a danger to the community.
Antes de que su señoría le pueda ofrecer una pena por debajo a la mina, se tiene que determinar si la señora Andino es un riesgo a la comunidad.
Among the factors the court should consider in determining whether Ms. Rosario Andino poses a danger to the community are the facts of the underlying case.
Uno de los factores que su señoría tiene que tener en cuenta al determinar si la señora Andino es un riesgo a la comunidad son los hechos que constan en la acusación original.
As described in Officer Barrios' report that I've provided to the court,
tal como consta en el informe que el policía Barrios preparó y que he presentado a su señoría.
Ms. Rosario and her co-defendants lured the victim to another location with the intent to rob him.
La señora Rosario con el otro coacusado consiguieron que la víctima fuera a otro lugar para que le robaran.
Ms. Rosario's firearm was used by one of her co-defendants to shoot the victim multiple times.
El arma de fuego que le pertenecía a la señora Rosario fue utilizado por uno de los coacusados y le dispararon a la víctima en múltiples veces.
Ms. Rosario made a false police report to attempt to hide her involvement with what happened.
Y la señora Rosario prestó declaración falsa a la policía para intentar esconder todo lo ocurrido.
This is not the kind of case where I believe the court should consider a downward departure or consider the defendant not to be a danger to the community.
Esto no es el tipo de caso donde su señoría debería de considerar reducir la pena mínima o considerar que la inculpada no es un peligro a la comunidad.
Another factor the court should consider in determining whether the defendant's a danger to the community is the nature of the violation.
Otro factor que su señoría debería de tener en cuenta para determinar si es un peligro a la comunidad es tener en cuenta la naturaleza de la acusación.
DUI, I would submit, is inherently dangerous to the community.
Conducir bajo los efectos en sí es un peligro a la comunidad.
Here, the defendant was asleep or passed out behind the wheel.
En este caso dado, la inculpada estaba dormida o había perdido el conocimiento detrás del volante.
Outside of the apartment complex where this occurred,
y donde esto ocurrió, que fue fuera del complejo de apartamentos,
several feet from an intersection with a road, pointed toward the road.
A unos pies de una intersección ahí en la calle.
Her breath test resulted in a high blow.
Y la prueba de alcoholímetro resultó en un nivel alto.
Based on these factors, I do not believe that it's appropriate for the court to find she is not a danger to the community at this time.
Debido a estos factores, yo no considero que su señoría en este momento dado debería determinar que ella no es un peligro a la comunidad.
If the court does find that she is not a danger to the community, the state objects to a downward departure in this case.
Si su señoría en vez determina que no es un peligro, la fiscalía está en contra que se reduzca la pena mínima en esta causa.
We are not sentencing Ms. Rosario Andino today for DUI, but rather for attempted robbery with a firearm.
No nos encontramos aquí hoy día sentenciando a la señora Andino por conducir bajo los efectos, sino por un intento de robo con arma de fuego.
There have been no valid statutory or non-statutory grounds for a downward departure presented.
No se han presentado causales para reducir la pena mínima en conformidad a los artículos de ley o no en conformidad a los artículos de ley.
The two potential grounds that I believe I heard from the defense are based on familial support obligations and a necessary treatment for asthma.
Las dos causales que la defensa ha presentado son una obligación con la familia para mantenerlos y el tratamiento de asma.
There has been proper testimony that Ms. Rosario Andino has asthma, but there has been no testimony or evidence before the court from which the court can make a finding based on the evidence that she requires any sort of specialized treatment for asthma.
Se ha presentado prueba ante el juzgado que la señora Andino padece de asma, pero no se han presentado ningún indicio o prueba alguna de que ella va a requerir un tratamiento especial para su asma.
Merely having asthma is not a valid ground for a downward departure.
El mero hecho de tener asma no es una causal válida para imponer una reducción de la pena mínima.
The second basis the defense argued is that Ms. Rosario Andino has children to take care of.
El segundo argumento que la defensa ha presentado es que la señora Andino tiene hijos que cuidar.
Our appellate courts have repeatedly held that familial support obligations, such as taking care of children, are not a valid ground for a downward departure.
Los tribunales de apelación han establecido más de una vez que tener una obligación para mantener a la familia, en este caso dado los hijos, no es una justificación para reducir la pena mínima.
With the thought process being that such a downward departure would treat a defendant with children differently than a defendant who does not have children.
considerándose que tal tipo de procedimiento sería tratar mejor a las personas o a los inculpados con niños que aquellos que no tienen niños.
That is simply not permissible.
Y eso en sí no se permite.
Your Honor, for these reasons, the state objects to any downward departure. The state objects to finding the defendant is not a danger to the community. The state does ask the court to sentence the defendant in accordance with the severity of the underlying offense that she committed.
Y por estas razones la Fiscalía protesta que se reduzca la pena mínima y protesta que se determine que ella no es un peligro a la comunidad y que en vez sea sentenciada en conformidad a el delito grave que ella cometió.
All right, thank you, Mr. Baird.
Bien, gracias, licenciado Baer.
The court has taken a look at the Kissimmee police report of the original incident, which was originally came in as an allegation of attempted felony murder.
Este juzgado ha revisado el informe policial de Kissimmee, donde consta la acusación original y en la cual se le está imputando de un intento de asesinato.
Ms. Rosario Andino subsequently entered a plea to attempted robbery with a firearm. That's a second-degree felony.
Y la señora Andino, a la larga, asentó en actas un convenio declaratorio por la acusación de intento de robo con arma de fuego, lo cual es un delito grave de segundo grado.
The maximum sentence for this type of offense is up to 15 years in prison.
La pena máxima por tal tipo de ilícito es 15 años de penitenciaría.
The court would have the discretion to sentence Ms. Rosario Andino to the maximum sentence.
Este juzgado tiene la discreción de sentenciarle a la señora Andino a la pena máxima.
However, the court has reviewed the facts of this case as well as correspondence received.
Sin embargo, este juzgado ha estudiado todos los hechos en la causa y toda la correspondencia que se ha recibido.
Do not find the state of Florida's offer of resolution to be unreasonable.
I'm sorry, we do not find that the offer is unreasonable.
Correct.
Okay. Y se determina que la oferta extendida por la Fiscalía no es razonable.
However, the court is satisfied with the lowest permissible prison sentence pursuant to her score sheet.
Y en conformidad a la hoja de cálculo, este juzgado está conforme con imponer la pena mínima permisible.
The court chooses not to exercise its discretion to impose a downward departure.
Este juzgado determina de utilizar su discreción de no imponer una pena por debajo de la mínima.
Mr. Franco has done a good job of highlighting Ms. Rosario Andino's improvements in her position and life.
El señor Franco ha hecho un buen trabajo en subrayar todos los hechos que en la vida de la señora Andino donde han mejorado su situación.
As a human being, I obviously applaud and commend those efforts.
Como un ser humano, le aplauso y le felicito por esos esfuerzos.
As a judge, I intend to enforce the law and the recommended sentence.
Pero como juez, es mi intención de hacer cumplir la ley y la sentencia que se ha recomendado.
Ms. Rosario Andino, the court will sentence you to 52.05 months in the Department of Corrections.
Señor Andino, este juzgado le sentenciará a usted a 52,5 meses de penitenciaría.
I will give you credit for 43 months plus 161 days credit for time served.
Se le acredita los 43 meses cumplido más los 161 días.
On my math, that's about 48.3 months.
Según mis cálculos, eso sería 48,3 meses.
Hold on just a second. The Department of Corrections will review our calculations and make their own determinations as to credit for time served.
La penitenciaría estudiará nuestra recomendación y llegará a sus propios cálculos con respecto al tiempo que se le va a abonar.
Mr. Franco, this is the intent of the court to have a sentence in that amount. So if Department of Corrections calculation is different, you could bring that matter back before the court.
Licenciado Franco, es la determinación de este juzgado de fijar la sentencia en esa cifra. Si los cálculos de la penitenciaría son diferentes, dicho tema lo puede traer a mi atención.
The court will revoke and terminate your probation. You're no longer on probation.
Se revoca y se pone fin a su régimen, es decir, ya no está cumpliendo un régimen de libertad vigilada.
Ms. Rosario Andino, you have a few more months to serve in satisfaction of this obligation to the state.
Señor Andino, le quedan un par de meses más para cumplir y satisfacer las obligaciones que tiene usted con este Estado.
Based on your letter and based on the arguments of your attorney, I do believe that you will be a productive member of society upon your release.
Basado en la carta suya y los argumentos presentados por su abogado, yo sí considero que una vez que sea puesta en libertad, se convertirá usted en una buena ciudadana de este país.
Good luck to you, ma'am.
Buena suerte a usted.
You have 30 days from today's date to appeal the judgment and sentence of this court.
Usted tiene un plazo de 30 días para poder apelar la sentencia y el dictamen de este juzgado.
If you wish to do so, you must do it in writing.
Si desea hacerlo, lo tendría que hacer por escrito.
If you can't afford an attorney, one will be provided for you.
Y si no puede permitirse un abogado, se le podrá designar uno.
Okay, gracias.
Okay, thank you.
Juez.
I must impose a cost of prosecution. It's $100. I'll give you a period of 3 years to pay that off.
Me toca imponerle costas de enjuiciamiento que son $100 y le voy a conceder a usted 3 años para saldar esa cantidad.
Muchísimas gracias, señor juez.
Thank you very much, Your Honor.
Thank you, Mr. Franco, for joining us.
Gracias, licenciado Franco, por conectarse con nosotros.
All right, that will conclude. Thank you. That will conclude this hearing.
You're welcome, Your Honor. The interpreter will disconnect.
Thanks, Mr. Arroyo. Right, I see a gentleman in the back. Thank you for your patience. Good afternoon. Can you tell me your name, please?
David Samuel Swamp. Sir?
Was this the arraignment, Your Honor?
Yes. All right. Sorry to keep you waiting so long, Mr. Smart. I am here to arraign you on 2020 CF 889. What an arraignment is I just formally advise you as to what the charges are against you. Make sure you got an attorney on board. You are charged with grand theft, third degree of a motor vehicle for something alleged to have happened on March 22nd, 2020. I will appoint the Office of the Public Defender to represent your interest, and we're going to give you some dates in the future. Your pretrial will be September 30th. Your trial period will be after October 12th, and in that trial period, your attorney will be out to talk to you. I think you may have another issue that, was he picked up on something else? Yeah, so, okay, that one hasn't been filed yet, so I'm not going to take any action on that. When and if it's filed, we'll go ahead and arraign you on that as well. Any questions?
Yes, I was told recently that my pretrial release was revoked. I was wondering, is that going to be brought back? Because I was on mental PTR under the supervision of my mother due to what has recently happened.
Okay, hold on. Let me stop you here, Mr. Smart. Your attorney, representatives of the Office of the Public Defender are here. They can bring you back before the court to consider a reinstatement, but they've heard what you said, and I'm sure they'll be talking to you. All right. Okay, thanks, Mr. Smart. See you next time.
Thank you.
Yeah, Judge, I'm sorry, I missed that reset date for the next meeting.
Pre-trial and trial, so it was 9:30 in October 12th through the 30th. Sure. Mr. Rivera, do you want these documents filed in the court file?
That would be best, yes, Your Honor.
Good afternoon, officer.
Yes, sir. Your Honor, we working on getting those other two up here, sir.
No problem. I think Mr. Quinn and Mr. Rivera are coming over, right?
Yes, sir.
All right. We'll stand by.
All right, sir.
Your Honor, could I approach off the record?
Yeah. Let me mute the microphone here. All right, Ms. Day, Mr. Abreu, we're back on the record. I see we have someone that's joined us at the jail facility. Sir, your name?
Yes, sir.
Who's the gentleman that we have?
Quinn, sir.
Mr. Quinn, you can come on up to the podium, please. Thank you. Thanks, officer.
And Callie Chrysler covering for Nicole Dupre.
Other podium, Mr. Quinn. No worries. Mr. Quinn, we're going to place you under oath.
Yes, sir.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Quinn, I'm looking at the Assistant State Attorney, who's the prosecutor. They're on my video screen. Your attorney is present in court, and are you covering that for?
Yes, Your Honor, I am. Callie Chrysler covering for Nicole Dupre.
So Ms. Dupre is your attorney. Ms. Chrysler is her associate. I understand this is a worked-out resolution, so Mr. Chrysler is going to be standing in. What I have here is an unsigned document. It's an admission form to the violation of probation. Looks like this. What I'm going to have you do while you're out there is I'm going to have you sign off on one of the forms and give that to corrections. They're going to submit that with your paperwork at the end of the plea, and I'm going to file them both together, okay?
Yes, sir.
All right. What this document tells me is that you wish to admit that you have violated your probation in 2017 CF 2713. Is that correct?
Yes, sir.
All right. You understand that you have a right to have a hearing contesting the finding that you violated your probation. At that hearing, your attorney would be with you. They would cross-examine witnesses and examine the evidence against you. You'd have a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have participated in your own hearing, had it recorded, appealed any error that occurred in that process. You understand if I accept your admission, I'm going to go along with this agreement that's written on your admission form, and we're not going to be having a hearing. Do you understand that?
Yes, sir.
Is anyone forcing you or pressuring you into making this decision?
No, sir, they aren't.
Has anyone made you any promises other than what's written on this admission form?
No, sir, they have not.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No, sir.
You understand if you are not a United States citizen, entry of this admission would cause you to be deported.
Yes, sir.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry of this admission could cause you to be involuntarily civilly committed. Do you understand that?
I understand.
I've already read the affidavit of your probation officer. I do find a factual basis with which the court can accept this admission. I find that you are alert, intelligent. You've had an opportunity to think about this decision and discuss it with Ms. Dupre. You satisfied with her help?
I am.
Good. Seems like she worked you out a good deal. You've indicated to me no one's forced you or pressured you into making this decision. You do so of your own free will. The court's going to adjudicate you guilty of the underlying offense if you weren't already adjudicated. That's burglary of a conveyance. You're going to be sentenced to 5 months in the Osceola County Jail. I'm going to give you credit for the time that you've already served with us.
171 days.
It's 171 days, so, see, that time, sir?
171 on 5 months?
That should be time served.
Yes, Your Honor.
All right. All right, so you'll get credit for the 171 days out of a 150-something days sentence, so it sounds like you're done. There's going to be some court costs that you're going to owe based on the original case, and I'll give you a period of 12 months from the date of your release. I'll revoke and terminate your probation in 2017 CF 2713, so you're no longer on probation. As to this case, you should be released today.
There's also a $300 cost of extradition affidavit.
Okay, we have a $300 cost of extradition since we had to ship you down here. I'm going to add that to your cost, so that needs to be paid off along with the remaining costs within a period of 12 months. If you're making payments to the clerk of the court, they'll be fine with it. If you don't make payments, you need to let them know what's going on. They'll try and work with you. If you don't pay and they don't hear from you, they could suspend your driving privileges. Do you understand?
I do, sir.
30 days to appeal. If you wish to appeal, you must do it in writing. Can't afford an attorney, one will be appointed for you. Anything further from the state?
No, Judge.
Okay, thanks, Mr. Rebelli. Good luck to you, sir.
Thank you, sir.
And last, we have Mr. Rivera. Hey, Mr. Rivera.
Good afternoon.
Good afternoon. Thanks. We're going to swear you in, Mr. Rivera.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to enter into this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Right, Mr. Rivera, I understand that we are resolving your case today with the entrance of a plea. Is that correct?
Yes.
Yes, Your Honor, that's correct. Callie Crystal covering for Melito Ortega. It is my understanding of the plea that count 1, possession of ammunition by convicted felon, will be null pros. Count 2, resisting without violence, would be an adjudication of guilt, credit time served, court costs, cost of prosecution, PD lien. And count 3, trespass and conveyance, which would be an M2, is going to be an adjudication of guilt, 60 days with credit for 60.
Okay, run me through count 1 and 2 one more time.
Count 1, the possession of ammunition by convicted felon.
Uh-huh.
It is indicated to me by my colleague that that is going to be null prost. Count 2, resisting without. A M1 is going to be an adjudication of guilt. Credit time served for 225 days. Court costs, cost of prosecution, PD lien, all of the included things.
All right, Mr. Rivera, what has been represented to the court is that you're entering a plea to counts 2 and 3. That plea would be no contest. Is that what you wish to do?
Yes.
Can you hear me okay, Mr. Rivera?
Yes.
Okay. I'm having a difficult time hearing you. That's why I asked. We're recording your responses. If you'll speak up nice and loud, I'd appreciate that. You understand you have a right to have a trial as to all of the allegations against you. At the trial, the state of Florida would have to prove to a jury beyond and to the exclusion of every reasonable doubt you committed each element of every offense that you were charged with. At that trial, your attorney would be with you, would cross-examine witnesses and examine the evidence against you. You would have a right to present your own witnesses and your own evidence. If your witnesses had not wanted to come to court, you could have asked me to make them come to court with a subpoena. You could have testified or remained silent and not testified at your trial. That would have been your decision after you talked things over with your attorney, and your jury would have been instructed not to consider that decision in any way in rendering a verdict. You would have had a right to have the trial recorded and appeal any error that occurred in that process. Do you understand you are giving up all of your trial rights? Because if I accept this resolution, I'm going to... All right, I'm going to start again since I guess I inadvertently clicked the button. So what the document indicates is that you wish to enter a plea to counts 2 and 3. Is that what you want to do?
I'm pleading guilty to trespass.
All right.
That's what I'm pleading guilty to.
All right.
Yes, Mr. Rivero, it's the resisting without violence and trespass and conveyance, both with credit time served.
Right, I'm supposed to be going home today.
I understand
Yes,
that.
Mr. Rivera, that's true.
Can-
We have to go over it again because there was an issue with us being on the record. So it's not
There's
changing.
always an issue being over here too. So I understand my rights and I know what I've done wrong.
Mr.
And I went
Rivera.
over this with my PD, public defender.
Yes, Mr. Rivera, we just have to go through the steps just one more time. I apologize.
Apologies accepted. Go ahead.
All right, Mr. Rivera, I'm trying to get you home. Do you think we can get through this?
I hope so. I mean,
All right. If you don't
I'm
want
trying to get home for the past however many days I've been in here.
Okay. Well, today's the day. If we can get through it together, you willing to do that?
Yes, I'm willing to.
Okay. Well, then let me do my part of this process. I got to just advise you these things on the record. So, as to you would be entering a plea of no contest to counts 2 and 3. Count 2 is resisting an officer without violence. That's a misdemeanor, first-degree misdemeanor. And count 3 is trespass in a conveyance, a second-degree misdemeanor. Is that what we're doing here?
I suppose so.
Okay. Well, I need you to do more than suppose. Did you read the
That's
plea?
why. Where's Ms. Ortega at? I asked her to be here in court with me, and she's not even in court here with me.
All right.
She's I don't know where she's at.
Ms. Ortega
I
is...
need Ortega in front of me, right next to my side, representing me as she's supposed to be, like no one has always represented me. I've always represented myself every time I've been in this court system.
All right. I'm inclined to, I'm pretty close just to resetting this. Ms. Ortega cannot be present due to no fault of her own. So either we can move forward with this negotiated plea right now, or I will get you
Let's
some
negotiate by me saying yes, I do, and let me go.
Okay.
Okay?
All right.
I'm not pleading guilty to no ammunition or anything.
Correct, you're correct. That's going to be dropped at the end of the plea colloquy. The judge just has to go through with it, okay?
Right.
All right. I'm also an attorney with the Public Defender's Office. I'm filling in for Ms. Ortega because she cannot be here right
Okay,
now.
and your name is?
Callie Chrysler.
Who?
Callie Chrysler.
Callie Kristen?
Chrysler, yes, sir.
Nice to meet you.
Nice to meet you as well. So we're just going to do a credit time served plea. That's all we're doing for both just the resisting without violence and trespass. We just got to get through the plea colloquy, just a little conversation with the judge and we're done, okay? And you get to go home.
Mr. Rivera, I understand you're not happy about any of this. I'm trying to accommodate this plea and get you back to your life if we can just get through this. So I need you to answer my questions and let me do my part in this process. So I'm going to ask you one more time. Are you pleading no contest to resisting an officer without violence, a first-degree misdemeanor, and trespass in a conveyance, a second-degree misdemeanor?
Correct.
Do you understand that you have a right to have a trial as to both of those matters?
Yes, I do understand.
Okay. And at that trial, I'm going to go over some of the trial rights that you're giving up by entering a plea because we're not going to be having a trial because I'm going to go along with this agreement. The trial rights you would have had were to make the state prove the case beyond and to the exclusion of every reasonable doubt. You could have participated in that trial. You could have presented your own witnesses and evidence. You would have had a right to have an attorney with you. They would have cross-examined witnesses and examined evidence against you. You would have had a right to have the trial recorded, appeal any error that occurred in that process, and you are giving up those trial rights because I'm going to accept this resolution that's going to get you out today, and we're not going to be having a trial. Do you understand all that?
Yes.
Is anyone forcing you or pressuring you into making this decision?
No.
Has anyone made you any promises other than what we've talked about this afternoon?
No.
Are you under the influence of any alcohol, drugs, or mental issues that cause you not to understand the decision that you're making?
No.
Do you understand if you are not a United States citizen, entry this admission would cause you to be deported?
Yes, I understand.
And if you ever before have been convicted of a sexually violent or sexually motivated offense, entry this plea could subject you to involuntary civil commitment. That may not apply to you. I don't know if you have any of those types of offenses, but that's the state of the law. Do you understand that?
Yes.
I've already reviewed the charging affidavit. I do find a factual basis with which the court can accept your plea, find that you appear to be alert, intelligent. You've had an opportunity to think about this decision and discuss it with Ms. Ortega. Were you satisfied with Ms. Ortega's help while she was helping you?
Yes.
You've indicated to me no one has forced you or pressured you into making this decision, and you do so of your own free will.
Yes.
It seems like Ms. Ortega did a really good job for you. Court will adjudicate you guilty as to counts 1 and 2. As to count 1, you're sentenced to 225 days in the Osceola County Jail. I'll give you credit for the 225 days you have already served with us. As to count 3, you're sentenced to 60 days in the Osceola County Jail. I'll give you credit for 60 days that you have already served. As to this case, you should be released today. There's going to be some court costs that you are going to owe.
Okay.
$273 court costs and a $50 public defender lien for a total of $323.
I'll give you a period of 24 months to pay that off. Just make payments when you can to the clerk of the court. If you don't make any payments and they don't hear from you, they could suspend your driving privileges. Do you understand?
Okay. How can I get that printout? A printout of the court costs?
We're going to give it to your attorney, and then I guess they can ship it out to you. Or we can mail it to a mailing address if you have a mail.
Or, Mr. Rivera, you could come to the office and we'll make sure that you have a copy, okay?
Sure, I could do that.
You can do that?
Yeah.
All right, come to the office and I'll make sure that you get a copy.
Okay.
All right, you're going to
The
have...
office is at the courthouse, right?
Yes.
Okay.
Yes, it's on the first floor.
Okay.
As to count 1, state.
In case number 19 CF 4283, the state of Florida announces a null process to count 1.
All right, Mr. Rivera, the state has followed through with their part of the bargain and dismissed the felony allegation in count 1 against you. As I said it before, you should be released today on 2019 CF 4283. Good luck to you, sir.
Thank you.
Your Honor, do we have to do Quinn again?
Do we do Quinn? Do we have Mr. Quinn?
I just asked because of the record. Did we?
Oh, do we have to do Quinn again?
Yes. They didn't say.
Yeah. I don't know when I hit off the record, so.
Okay.
I guess if we're appealed, we'll recreate the record.
It's time served, so.
Yeah, I may have been off the record. I doubt anybody's going to appeal that.
I'm just going to notate in my file so that we know in case we do get an appeal, so someone knows what's going on.
And it was
In case it's not me who's here in the future.
All right, we'll recreate the record if we need to. Officer, thank you very much. I think that's going to be it.
All right, thank you, Judge.
Thanks for your help.
Yes, sir.
What's that? I'm good on Quinn? Okay, I must have just hit it. All right, that's going to complete our afternoon docket. Thank you, Ms. Day.
Thank you, Judge.
Thank you, Mr. Abreu.
Take care, Judge.
Thank you, Ms. Christopher.
You're welcome, Judge.
We're off the record.